ONV Independence, 100 SCT 1398, 445 US 622. Greetings of peace. Thank you for your interest and activity. However, the universe thanks you more. Nationality is not really a process except for if and when it starts in the mind, as you now already know, if you didn't before. It has apparently awakened in you, thus declaring it is to be clear yourself and does not necessarily require any paperwork, but does require study to be clear yourself, as you can only be what you know. Proclaiming is the publishing, and that is where the paperwork comes in. Anything in written form is but a brief expressing your position regarding a matter, whatever that matter may be, and that includes the card itself, which is a brief and lawful claim. Be sure to send us the application with necessary information to establish your card, and a working and legible email so we can send your draft for approval via email. We will not print and mail any card, without your approval of the draft first. The application for cards is found at the very bottom of this page. Instructions are on the application itself. We suggest you read this page in its entirety, if you have not already done so. You can send the application either via mail or email. These cards, whether obtained separately or all at one time, are not a sovereignty package, or a part of a sovereignty package. They are identification cards. We do not sell sovereignty, it is not for sale. We deal with birthrights, natural rights, liberties that come from the sheer act of being born. It is very interesting that if anyone were to get an identification and a driver's license and a school ID from a corporation, or any institution, they do not call it a sovereignty package. Important message regarding National Identification Card. One may be employed, do business, and enter into other contracts, and sue and be sued under any name they choose at will. Linden v. First National Bank 10F 894, Coppage v. Kansas 236 US 1, in Remac ULTA 189 F 250. The judicial or court method of changing one's name is merely an affirmance and aid of the common law. Thus, the common law, by superiority, establishes supreme validation, and suffices to serve public notice for declaration of a name correction and change. The court method of corroborating a name correction and change is not to be assumed as being necessary nor superior, but merely a formalized method of confirming or acknowledging a person's right to a name correction or change. Such a change carries the exact same legal weight as a court-decreed name change as long as it is not done with fraudulent intent. In Remac ULTA 189 F 250, Christensen v. King County 196 F 791, United States v. McKay 2 F.2 D 257. If you are not able to be who you say you are and exercise your unalienable rights of birth and defend your allodial identification yourself, do not apply for this card. At the same time, be willing to accept the following fact. Your nationality card is going to change on you in your pocket. Prophet Noble Drew Ali. T is advised that you read, review, and study this entire page regarding identification cards / name corrections and / or change, prior to applying them. If you don't do anything else, declare your nationality. Prophet Noble Drew Ali. And then we suggest you live your life accordingly. Beginning with your status, as it sets the stage for matters of jurisdiction. 1. Status is the standing, the state, or the condition, being a social position. It is the legal relation of an individual to the rest of the community. Status also relates to the rights, the duties, the capacities, and the incapacities, which determine a person to a given class. It is the legal, personal relationship, not temporary in its nature, nor terminable at the mere will of the parties, with which third persons and the state are concerned. While the term implies relation, it is not a mere relation, it is a legal relation, and it establishes a state, since it also signifies the condition or circumstances in which one stands in regard to his property. Note, your status sets the stage for jurisdiction. Jurisdiction, essentially the right to adjudicate, decide, regarding another. Jurisdiction covers, encompasses, assimilates, and incorporates every type and kind of judicial action. Judicial actions pertain to authoritative actions and issues involving justice and the administration of justice in matters of rights of parties, rights of property, and judicial proceedings, etc. Jurisdiction equates to right words, as juris means right and diction means words. About ex rel and nom diger. Not getting rid of old name equals ex relatione or ex rel. Ex rel is the lawful position one takes with a fictitious name or a nom diger. A nom diger is a fictitious name, a war name, a name assumed for a time. Ex rel is used in regards to a birth certificated name. A birth certificate is an instrument that indicates a title exists somewhere, as all certificates indicate, however, that title is not the L or the B. The birth certificate is the instrument that proves human trafficking, therefore there is nothing to redeem. The proper use of not throwing it away is to ex rel it, which means you information about it, the birth certificated name, but it is not you and never was. It has nothing to do with the flesh and blood being. Therefore the use of ex rel is the lawful position that Noble Drew Ali meant for you in regards to not getting rid of it, and to do all new business in your new name. Of course, upon study, he trusted you would find that out, as the half had not been told. Don't believe us, try it, instead of trying to redeem it and running from it. Ex rel is in relationship to having information only regarding the nom diger or straw, as many have called it, or regarding any fiction, as fictions cannot speak for themselves. That is why an attorney is always forced upon you, as attorneys are for the purpose of speaking for those who cannot speak for themselves, i.e., corporations. What many call the straw name and others call a transmitting utility is really lawfully a nom diger. A nom diger is a fictitious name, a war name, a name assumed for a time. Therefore what you call a birth certificated name, or in error, a government name, or straw, or transmitting utility, or slave name, fits any part or all of the definition of a nom diger. It is possibly easier, at first, to see it as a name assumed for a time, and you have decided that time is up, until you can fully understand how it is a war name and how it is fictitious. That is secondarily easier because you know it was established by a corporation and is in all caps, which by all definitions is a fiction because anything in all caps indicates a corporation name. A name is a label and is meant for corporations. You would have an appellation, which means to call out to, and an attribute. However, an attribute is not a proper appellation. It would be likened to a nickname, but is not that either, as it is a descriptive persona or personality quality. The nom diger, often referred to as straw or transmitting utility, was created by a certificate and any other instruments created from it, i.e. driver's license, marriage license, etc., are void because it comes from a void instrument in the first instance. Therefore you do not need to go through any process to make it void or voidable. Name comes under the 14th Amendment as a fiction, a corporate citizen or member jurisdiction. The 14th Amendment, although not ratified, was established under the jurisdiction of a corporate state, for and referring to corporations from its inception and never meant for natural beings, therefore any person answering to it, is potentially corporate state chattel property with no rights to be acknowledged. Those instruments are in themselves proof of human slavery or human trafficking. It does not put you on the stock market, as you are not on the stock market, that piece of paper, certificate, bond is, but not you. You are to ex rel it whenever it comes up. There are only two people who can make an ex rel claim, and that is either the Attorney General, speaking for a fiction, i.e. any corporate state, or by one who is in their proper person status, that would be you. Naturally you have more information regarding the straw than anyone. Please read the article we have on this site in regards to XREL. It is found on the jurisprudence page, along with articles in regards to rescission of signature and use of u.c.cs. Do not get caught up in thinking you. 2. You do not have to show identification and you cannot lawfully be detained or arrested for failure to show. Cannot allow your identification to be confiscated, it is your property. Colander v. Lawson, 461 U.S. 352, 1983, in which the United States Supreme Court ruled that a police officer could not arrest a citizen merely for refusing to present identification. You utilize your national identification card when and as you wish to, when you think the need arises. Do not allow any policy enforcers or highwaymen to take your identification, as it is your property. Lawful amendments were made for clarity. In Amendment V, in last part it says, nor be deprived of life, liberty, or property, without due process of law. Nor shall private property be taken for public use, without just compensation. If this somehow occurs, make a claim with a bill against them for your property. The only person guilty of identification fraud or impersonation is those who have attempted to denationalize the natural people via negotiable instruments, i.e. birth certificates, driving instruments, etc., which are absolute proof of human trafficking. Therefore, upon them trying to force a negotiable instrument as identification upon you, they are also participating in human trafficking, which is an act of genocide. Each policy enforcer who does so, must be charged with same in both their private and professional capacity. Such claims made by you of this activity must be sent to the World Criminal Court. The rest of the world are aware of the rights of the natural people, they are aware of acts of human trafficking and genocide. It is the unsuspecting, corporate, citizens who are not aware of what is really happening to them, and it is sad that they have been led to call it racism, when it is not. It is birthright theft, human trafficking, and acts of genocide. Just because an officer presumes interpretation of the law, does not make it right, exact or applicable. As officers of the court or as public servants, they are deemed to know the law and they do not have immunity to the liability of not knowing or of their presumptions or assumptions. Hoff-Summer v. Hayes, 92 Oklahoma 32, 227 F 417. The courts are not bound by an officer's interpretation of the law under which he presumes to act. ONV Independence, 100 SCT 1398, 445 U.S. 622. Officers of the court have no immunity, when violating a constitutional right, from liability. For they are deemed to know the law. Update February 3, 2016. This means we, the people, must be busy about holding anyone to the law. We must uphold and enforce it ourselves so that we are not molested by any other citizens. That is why Prophet Noble Drew Ali said, there is but one supreme issue and that is to enforce the Constitution for the United States of America. Being aware that most do not know the law or case laws that support and enforce it, which were established prior by someone who did enforce it, by them a bringing claim/suit against those persons who violated it against them. This being done in disregard to the position they say they hold. Most people have not generally enforced the law because the not knowing has placed them in a mental slavery, of which Noble Drew Ali, who was well versed in these matters, also made a statement that he has come to take you out of your mental slavery. It requires study, 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 in order to become knowledgeable and to be what you know, as you can only be what you know. 2a. Regarding correcting and/or changing name and protecting your nationality cards, and laws regarding identification, and what lawful identification/identification card is. Acquiring an identification card from a quasi-national domicile, i.e. a corporate state is not an action necessary for those who are nationals, Aboriginal and Indigenous, as a corporate state can only issue to corporate entities. Click the PDF below for further information regarding same and please continue reviewing this page. 3. No state, federal or local government can deny your claim of who you say you are. The corporate states are not only corporations, they are foreign corporations. A state's jurisdiction in a local municipality jurisdiction is quasi-national. Moors, Aboriginal and Indigenous natural peoples matters are national and international. There exists no jurisdiction over the natural people. This is what diversity of citizenship is all about, as referenced in the Constitution under Article 3 dealing with judicial authority. For any corporation existing in this land to demand that you have an identification card from a corporation and to deny you any right, privilege, or service because you don't, is a violation of your First Amendment right to free association, right to contract. Many people who operate corporations, businesses, etc., etc., will attempt to deny your identification because they say it is not a state ID and it is their policy handed down to them from the respective corporate state. However, your identification card is in fact a state identification from the Moorish nation state, to be respected as same. Besides, the Union states cannot issue a national ID, as they are quasi-national domiciles. No one can create policies that violate the law, certainly not national law. The law is established to protect the people's rights and any public official/government official/trustee is obligated to same. Governments are corporations ran by trustees/public servants/government officials, and we find now that they are actually corporations feigning to be government. Corporations have no parity with the real, they can only regulate corporations. A true public servant/trustee/ are obligated to respond to any violations of rights against the people in both their professional and private capacity, as they are obligated to be law-abiding and they cannot hide behind corporations and policies of corporations. Policies that violate the rights of the people have no standing. See Article 6 of the North American Republic Constitution for the United States of America and know that the United States of America is a corporation. The Treaty of Peace and Friendship is the pre-mandate to the Constitution and is the law of the land that established the states or brought them into the constitutional fold of government to end the wars and slavery that was taking place upon the American land, and at that time some were considered as the several states, some did not want to join the Union styled as the United States of America, which is really a union to this day. However, it matters not, when it comes to the law of the land, because any entity, association, charter, subcharter, chapter, subchapter, etc., whether an enclave of the United States or not, cannot violate the rights of HTE people. Even the IRS, which is an accounting firm for hire, is a corporation. You, the natural people, do not have to participate in making contributions to them or in participating with the Social Security Administration, which is also not government. You do not have to show proof of existence of the Moors being the Aboriginal people, as it is already recorded and is in the congressional records as well. As for the Constitution, all authority is delegated. There exists no authority to deny the people's rights, which is an act of breaking the law, acting in fraud and committing treason and genocide. Thus any person who does so can be personally and professionally liable and sued for said violations. State, N. A people permanently occupying a fixed territory bound together by common law, habits and custom into one body politic, exercising, through the medium of an organized government, independent sovereignty and control over all persons and things within its boundaries, capable of making war and peace and of entering into international relations with other communities of the globe. United States v. Kusha, D.D. Cal. 56 F sub 201, 207, 208. The organization of social life which exercise sovereign power in. Important. 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 In reference to public notice of your judicial proclamation and national papers. We have received emails in concern about posting private information, pictures, and proclamations on any website as it relates to your nationality. It is not advised to do so. Moors are private. No one ought to be able to go to any website and click and get personal and private information and pictures. As a Moor, you only need to make notice to proper departments of state, for the record, and recognize that notice to the principals is notice to the agent and notice to the agent is notice to the principal. If you are making a national proclamation, it ought be with a Moorish government entity and not a non-government. As well, there are only two things happening on this continent in the Moor's ancestral estate/national domicile, North America, and that is either the pyramid or the subordinate eagle, as an official government seal. Of course you are not under the eagle or any of its enclaves, and any corporate state is for members/citizens of a corporate state, union state, of which you are not. Also be sure you are not dealing with a 501c corporation while making your national allodial proclamation, as clearly a 501c comes under the jurisdiction of and as a corporation, whether non-profit or not. If anything, post the PX of the public servants/trustees of the corporate, union, states. After all, they are public, and as a public trustee they are violating the law, of which they are entrusted not to violate against the people's rights and liberties. Do you think you could go to a website in China, Russia, Japan, or anywhere, and get the personal information and pictures of the nationals there? If there is a need for your personal information, it ought be done at written request, at your authority/permission in regards to any inquest. Therefore we do not post personal proclamations on our site. 4. Are you confused or unsure? That is why the international community put out the Declaration of Human Rights, the Declaration of the Rights of the Child, and the Declaration of the Rights of Indigenous People, all to be disseminated in public schools, public institutions, etc. Yet of course that was not done, as these humane principles would go against the untoward intent of those who are feigning as if they have a lawful delegation and authority over the people and who want to continue slavery in a bureaucratic, paperwork, fiction manner. Even unto the Constitution there exist rules of laws that they break on a consistent basis. Yet, it is a responsibility of the people to know what law is and what law is not, and who is who in government. In so much as you need to know what government really is, and who governs you, as you are government, governing your mental, thus you are the one who governs, and you must be civilized yourself, and with that you must have knowledge of civilization principles. In the Declaration of Human Rights, Article number 15 it states: A. Everyone has a right to a name and a nationality. B. Everyone has a right to change it. This is for adults, regardless to what their parents may have done in ignorance previously, which is why it states you have the right to change your nationality, although there exists no nationality with the birth certificate that your parents seem to have vested you in, and Negro, colored, black, etc., are not nationalities. The birth certificate was established with intentional deceit and fraud. Thus one can presently declare their nationality and exercise their rights of birth. There is much resistance because finances are made off of corporate property, and that is the false report that is given when a birth certificate is issued. Example, if you are identified as a corporation, by that certificate that you claim is you, but it is not and never was. Then you pay income taxes because the paycheck is considered income, when really it is wages. However, if you say it is income, then you are saying it is profit from a corporate investment, so then you are taxed as if you are the corporate investment. So, stop calling it income. Stop acting as if you are a corporation, a corporate person, and your wages will no longer be considered a corporate investment, and the excess after listing all you spent to maintain will no longer be considered the profit, that is taxed and shared with the respective corporate state of. See about taxes page. In the Declaration of the Rights of the Child, Principle 3 it states: Every child has a right to a name and a nationality. This is for parents who wish to initiate such right from the onset of birth, ab initio. In the rights of indigenous people, those who were here before the modern European colonist, and before the forming of the corporate United States of America, who are really the aboriginal and indigenous people. If you are aboriginal, you are indigenous, but being indigenous does not necessarily mean you are aboriginal. Moors are aboriginal to all of the four corners of this earth. In Article 6, it states: Every indigenous individual has the right to a nationality. Rights of indigenous people. Article 37. 1. Indigenous peoples have the right to the recognition, observance, and enforcement of treaties, agreements, and other constructive arrangements concluded with states or their successors, and to have states honor and respect such treaties, agreements, and other constructive arrangements. Note: you are not indigenous because you are a part of a club or not, or of a private society, association, institution, etc. No man can change the descent nature of another. Aboriginal and Indigenous is a status refinement, not a nationality. Those who are Aboriginal are first, as a means to come down from, to be first, from the beginning, as enforcement and encouragement. You are not Negro, colored, black or Ethiopian people. You are Moors, the direct descendants of the ancient Moabites, who are the true and aboriginal inhabitants of Northwest, Central, and Southwest Amaxime/Africa/America. The national standard, flag, of the Moabites/Moors has flown over the lands of Amaxime/America for over 10,000 or 50,000 years, and the Great Seal Pyramid is the insignia of the Moabite/Moorish nation of the North Gate, North America. Upon truth and fact, you, Moors, are bound to the continent by heritage, and your birthright claims are, hereby, made. Moors are the ancient ones, and the true sovereigns of North America, and the four corners of the world, by heritage, birthright, right law and primogeniture. Moors are Aboriginal and Indigenous to the land, are the first navigators on the planet, all four corners of the earth, the mothers and fathers of civilization and civilization principles on the planet, spanning throughout time cycles and ages. Moorish American is a political jurisdiction established for Moors by Prophet Noble Drew Ali, for those who were involved/members of the MSTA, proper. However, whether in or out of the temple, you are still a Moor. That means you do not have to be in a temple to be a Moor. It is about birthrights and bloodline. That is why he established the institution to teach you the truth about your nationality and your birthrights. The purpose for any and all governments is to protect and preserve the rights of the natural people. As such, they have the right to travel, not drive, as drive is absolutely a commercial act. They have this right without the instruments erected by the corporate states. The terms Negro, colored, black, Ethiopian, African American are coins, thus are not right words, and are with no jurisdiction for standing in law. They refer to names, coins, brands of something that is a fiction. The more IDs you have, the better. In addition to the national ID, we offer the travel card and student card. In fact, in law, if you do not have the preferred ID of the asker, you can present two of another ID, which is sufficient. Many of the rules and thoughts people utilize in regards to IDs is based on the fact that they do not have a national ID. In the absence of a national ID, they have commonly accepted a birth certificate and/or a driver's license. Those instruments are commonly accepted because one does not have a national ID card. And as stated before, a state cannot offer a national ID and a corporation, municipality, cannot offer one either. In the United States Attorney Manual, 1508, specifically mentioned identification documents, referring to 18 U.S.C. 1028. It says the following. In Section 1028 of the Title 18, it designates three special non-federal identification documents and gives them preferred treatment. These three documents are in the absence of a national identity card. Say the preceding highlighted text 3 times to yourself. The three they will accept in the absence of a national ID is 1. Birth certificate, 2. Driver's license, and 3. Personal identification card. All being in the absence of a national ID. At this point there is no reason to read or comply any further if you have national identification. As you study and come into knowledge, you see just how much you have been violated and discriminated upon. This being due to your lack of knowledge and your lack of enforcing of same. Those who are living off your ignorance and your virtues are not going to pull your coat to it. Due to the brainwashing, miseducation, or mental slavery, you also recognize how much you have to do to bring yourself out of it, first, and you recognize the same in others around you. Until you do, and until they do, you will not be able to see your own way out, and others will annoy you into possible agitation and confusion. If you are serious, don't let that happen. Teach yourself and your own, especially your children, the maxims of truth and share profound information with your spiritual friends. https://youtube.b/uuehacksjays. 6. In regards to the right to travel card. vbasits/wetravelcard.jpg. The application and payment methods for cards are found at the very bottom of this page. Please read the following information before applying. Personal liberty. The right or power of locomotion, of changing one's situation, or moving one's person to whatsoever place one's own inclination may direct without imprisonment or restraint unless by due course of law. The right to travel, the right to mode of conveyance, the right to locomotion are all absolute rights, and the police cannot make void the exercise of rights. State F. Armstead. 6078 and 781. The right of a citizen to travel upon the public highways and to transport one's property thereon, either by carriage or automobile, is not a mere privilege which a city may prohibit or permit at will, but a common right which he/she has under the right to life, liberty, and the pursuit of happiness. Thompson v. Smith 154 SC 579. No state shall convert a liberty into a privilege, license it, and attach a fee to it. Murdoch v. Penn 319 U.S. 105. If the state converts a liberty into a privilege, the citizen can engage in the right with impunity. Shuttlesworth v. Birmingham 373 U.S. 262. Traffic infractions are not a crime. People v. Battle 50 calories app 3 step 1 123 cal.rptr 636,639. Speeding, driving without a license, wrong plates or no plates, no registration, no tags, etc., have been held to be non-arrestable offenses. Cal v. Farley, 98 calories Republic 89, 20 CA 3D 1032. The driver's license instrument is not identification in its inception and purpose. As well, it does not have a nationality on it, and never will. It has an expiration date on it, of which your identity does not expire. It is administered from a corporate agency and is an instrument for commerce, thus could never be identification for the natural people. As an instrument used for commerce in the moving of cargo, goods, and passengers along the highways, it does not and never was meant for the natural people to travel upon the highways. If used as an identification, it denationalizes a natural person. To use it as a permission to travel is to deny you of the right to travel, as it turns that right into a privilege by licensing it and attaching a fee to it. States are forbidden from doing so, thus any private corporation is also forbidden from doing so as follows. No state shall convert a liberty into a privilege, license it, and attach a fee to it. Murdoch v. Penn 319 U.S. 105. If the state converts a liberty into a privilege, the citizen can engage in the right with impunity. Shuttlesworth v. Birmingham 373 U.S. 262. 7. In regards to the student identification card. The application and payment method for cards are found at the very bottom of this page. Please read the following information before applying. Horizontal divider 12. Updated February 2, 2016. When the student is ready, the teacher appears. As we know, the half has not been told, and we all strive towards obtaining the knowledge of our ancestors, which is resting in our DNA, and applying the unshakable principles. These are the same principles Prophet Noble Drew Ali left as instructions. Read the Circle 7 Holy Quran, divinely prepared by Prophet Noble Drew Ali, which is tailored for the Asiatics at North America. Upon study we find those same principles absolutely apply today, contrary to the belief of many that they do not. However, principles do not change. Learning in degrees is a natural and necessary process of development. Today in modern European institutions of learning, one receives diplomas, diplomats, and degrees. Interestingly enough, upon receiving a master's degree, you must write a dissertation/thesis for public consumption before you receive said master's degree. This is why Prophet Noble Drew Ali said, if you want to change the people, you must change their literature. RV Publications shares information on this site and at various locations, in direct association with Moor's Heritage and History School, and operates under the umbrella of the Moor's Divine and National Movement of the World. If you participate on location, or via online and web information/classes, hard copy downloads of same, or in any way study this information, you are a student. Therein/herein we provide a student identification card. Horizontal divider 12. 8. About correcting your name and choosing your appellation. As for sisters, Allah is feminine. A is feminine, and many of the appellations of women include A, as it means the breath of life, the holy breath, the truth. Example, Diana would be corrected to Diana or Diana. Rebecca to Rebecca or Rebecca, etc. Most name books are based in Latin. You can also consult a Islamic or Arabic name book for further suggestions. Moors are the original Arabs, Berbers. As well, you may want to look up the name given by your parent, in a name book, as all name books are based in Moorish Latin, and you may find the originating spelling and pronunciation of same. You may find to keep your existing and add your title L or Bey. There was / is a simplistic protocol done by Prophet Noble Drew Ali for initiates who entered the temple to hear the truth about their nationality and birthrights and link themselves back to the family of nations. Reading the first 7 questions in the 101 questionnaire gives you the support of fact and historical foundation. After all, without history you cannot comprehend law. A simple affixing of the titles of L or Bey to your existing name placed you under the jurisdiction and protection of the Moorish nation, America, North, South, Central and the adjoining islands. Read chapter 47 of the Circle 7 Holy Quran for verification. This is why it is disturbing, futile and non-productive, unless you are an agent against Moors rising, for any Moor to think that this land estate is the dominion of foreign occupiers, and they act out as if it is as well. Yet the Prophet said we would gain back our heritage and our lost estate in a conflict that cannot be told in words. That would not be mentally cognitive, nor real and tangible if one truly believed that we are standing on the land estate of foreigners, and it is a blatant contradiction to chapter 47. Thus is it very, very disturbing when Moors act out as if this is the land estate of foreigners. Al, Day, and Ali are also titles to our vast estate. The 5 titles are the premise of the so-called acceptance of the 5 civilized tribes, families, during the induction or branding of Moors as federally reserved Indians, etc. Thus, Moors are not federally reserved Indians, that is a brand along with Negroes, coloreds, blacks, etc. The tribal, family, nomens of the people were not easily pronounced by the colonizers, as they themselves spoke Gaelic. Many didn't know how to read, write, or spell, thus the English language was devised from Moorish Latin to teach them. As for titles, we are fundamentally Els and Bey, and must be that, as we always are that apart from any self-assignment or attainment, however, of titles that are earned by degree. It is likened to wanting to come in and ghost react to the highest degree without foundational and primary knowledge to support the climb. The other titles Al, Day, and Ali are reserved for obtainment by degrees that must not be self-assigned. Many may wish to ignore these principles, however the universe does not allow circumscribing. Besides, anything else you may or may not be is private to you, particularly at this juncture. We all aspire to our higher in due time and with due measure. L, the lawmakers, lawgivers, likened to executives. Bey, law enforcers, obey the law. A mufti is a Mohammedan judge. Ali, is a title reserved for those who are, or who have reached a master degree in their line of studies, inclusive of published dispensations. Thus is an earned title, reserved for the workings of the nation and not to be self-assigned. Many get it confused with their corporate state master's degree. However, if you read Religious Controversy, from the Moorish Literature booklet, there is a information regarding those who have received those degrees and the mental state they are in, whether they recognize it or not. Al, is also reserved for obtainment by degrees in the sciences, mathematical, geometrical, psychological, etc. Day, is meant for and reserved for same in degrees of astrological, cosmological, other sciences, etc. Horizontal divider 12. 9. Notice. 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 Nationality and identification card is a writ. Constructed in allodial character. Notice to all loyal and faithful Aboriginal Moorish nationals of Northwest Amaxime/North Africa/North America, the inherited lands of our foremothers and forefathers. In keeping with the allodial subject matter of a national identification card, responsibility and competence are of most importance concerning the matters of national identities and proper person status. For all those active Moors/Moors seeking to obtain a nationality and identification card, etc. or responsibility, competency, and proficiency test is provided, below PDF, for your self-assessment and exercise. This is vitally important, particularly due to the fact that the Moroccan Empire has been under foreign European occupation for generations, and it has been the negating agenda of many European scholars and teachers to deliberately hide, misguide, misrepresent, and misdirect the educational forum in relationship to people of Asiatic and African descent. Therefore it is in your best national interest and in the interest of your offspring, for all Moorish Americans to be grounded in the fundamental civic activity concerning nationhood, international law, constitutional law, divine constitution, and bylaws, treaty laws, and those things necessary to make our people better citizens of their own national state. A national identification card is a writ. A writ is a brief that expresses your position regarding a matter. Consequently, it is everyone's failure if any one of us is incompetent regarding it, because we were given enough information to free a nation and the obligation and instruction to go out and free ourselves. Each one teach one, and the nation will be free of the usurpation and impositions placed on us by impostors. The mission of those who are usurping birthrights is to keep you incompetent to receive your inheritance. After all, it is about your inheritance, your illustrious estate, that you have been and are being denied by process of cheating by foreigner impostors. Those of Asiatic African descent who were falsely deceived by others to think they are Negro, colored, black, African American, etc., usually also accept the label of minority. Minority is a social status, a lawful term that does not mean of lesser numbers but is of a lesser mind, a minor mind unattached to its mother and father and the knowledge and customs of its mother and father. Those who have not declared their nationality, thus their standing and relationship to society and to the nations of the earth, and who identify themselves with brands and labels, are in fact of a minor mind, as there exist none of those brand names in the family of nations, which comprise the inhabitants of any land territory on the planet. Therefore, they could never take their place amongst the affairs of man or link themselves back to the family of nations. The acceptance of those brands indicates incompetence in the view of the law, along with other so-called contracts that were deliberately constructed and are instruments of bureaucratic slavery and genocide. These instruments and brands were accepted and rights were assumed to be waived with your unknowing consent, and it is that consent that keep them alive. However, waivers of rights must be voluntary acts done with sufficient knowledge. Therefore, an instrument that neutralizes one's rights without telling them so up front are void for non-disclosure, as they do not qualify as a contract from the inception. They are void ab initio and do not need to be rescinded or dissolved in order to avoid them. They are what they are: void. A writing is void ab initio in the case of fraud in the inception, and it need not be formally rescinded as a prerequisite to right of avoidance. Banaxi v. Massachusetts Bonding Ins Co., 1943, 58 CA 2D 657,664. Waivers of constitutional rights, not only must they be voluntary, they must be knowingly intelligent acts done with sufficient awareness. Brady v. U.S., 397 U.S. 742, 748. If a writ is a brief that expresses your position regarding a matter, then an identification card from a corporate jurisdiction cannot express your position as a natural person. Writs administered by a corporation are under a feudal, limited authority and places you under the jurisdiction of a corporation, indicating you are a citizen/member of said corporation. Your position is allodial, not feudal. Law say natural person in full life you could never be a citizen/member of a corporate state, see original 13th Amendment. The United States of America is a corporation in clear distinction from the United States, of which the United States is a metaphor because there are many United States. Therefore you cannot vaguely be a citizen of the United States. All law is specific. All states and the several states are enclaves of the corporate United States of America. You must know the difference between that which is feudal and that which is allodial. That which is feudal can never, ever administer anything allodial to you. Example, El, Bay, Day, Al, and Ali are titles. An instrument established by a corporate state is not and never could be a title. They can only administer certificates of title, bills of exchanges and deeds for corporations. Those who administer these instruments are acting as first lien holders against your estate via a straw man or transmitting utility established at birth and evidenced in the birth certificate and in violation of jus precarium. You cannot accept certificates and bills of exchange, as they are all instruments of commerce. Your nationality is not commercial and cannot be bought, sold, or transferred. Thus, the necessity for an allodial universal identification card, S. Horizontal divider 12. 10. Updated February 1, 16. FY. I taxes. To assist in correcting concepts. In the footnotes of the statutes at large, in regards to the forming of the American Constitution and its meaning and intent in reference to imposed taxes on persons, it states, persons are not the subjects of. This page has been established to address the accusations, inconsistencies, and the avalanche of lies that are being heaped upon Moors daily, just as Prophet Noble Drew Ali said they would be in these days and times. It also will address another prophecy made by Prophet Noble Drew Ali, and that is, be careful Moors, some of your own wearing turbans and fezzes, will put you back into slavery. Horizontal divider 12. Posted May 30, 18. History repeats itself, when you don't know history. Sticking with heritage and history of Moors of the world, thus divine and national movement of the world. Who goes there to bring forth misinformation? Only the unstudied, the anxious, and the emotional, and that is dangerous especially in these days and times. Who does not put their trust in the actions and deeds of their foremothers and forefathers. The United States of America was actually established as a company when they received their independence from the British at the Treaty of Paris in 1783. They were recognized after a 7-year war that took place because they asked for independence as a company from the British, who clearly did not want them to be an independent company. Can't blame them, colonist, they were treated very badly by the brutish Moors. Be clear that the Constitution of 1774 that the Prophet spoke of is the Articles of Association of 1774, wherein at that time they were called the United Colonies of New England, where they named themselves that by way of their Articles of Confederation 1643. They came to the existing Continental Congress at Philadelphia on September 5, 1774, and that is where and when they became associated officially or formally with the Moors of Al-Maroc on the Moroccan/American soil. That document clearly shows who we were/are and who they were/are. At that point, they were called the United Colonies of New England, and they changed their company name to the United States of America before receiving their independence. This name change happened in 1777 under the Articles of Confederation 1777. However, if you believe they received their independence in 1776, you may not be able to connect the dots, and that is why study is important. The colonist intent was to do commerce to save themselves. Read letter from George Washington to the Sultan of Morocco 1789. In that letter they are thanking Moors for their assistance and are hoping they would be useful to produce merchandise/product for themselves. The Treaty of Peace and Friendship 1787 allowed them to sail the seas to engage in commerce and protected them on the seas. Think of it as hiring a security company or bouncers at your party to keep everyone safe. Many have this relationship reversed because they think, in error, that the treaty was for the purpose of protecting Moors, when in fact it was established to protect the foreign Christian powers, known as the United States of America, on the seas. Therefore, any consuls appointed at consul post/consular courts, were also for foreigners. Commerce. The colonists were interested in commerce then and are interested in commerce now. Know that they are a company operating on the Moroccan/American soil. All historical documents proves this as fact. On the record, for the record and let the reflect. They know they are what their foremothers and forefathers were/are. Why don't you know the same about your foremothers and forefathers as it relates to heritage and history of the world, as you have an illustrious history that goes beyond the forming of the United States of America, and it is not taught in public schools, in which most of us attended over the past several generations. The Constitution, supreme law of the land. The Constitution is the law of the land, and the 7 articles delegate what any company operating on the land can and cannot do as privileges. The Bill of Rights secures, protects, and preserves the rights/liberties of the natural people. The Constitution is due process. This page contains constitutions, treaties, agreements, church bullas, contracts, and other important national and international documents and correspondences. Most were written in the spirit of preserving principled government, with emphasis on the protection of substantive rights, birthrights, and basic human rights and principles for all. However, many dishonorable and disingenuous men have violated these noble and ancient principles, which are also embodied within the Constitution for the United States of America. Many people mistakenly think these rights preservations do not apply to them. Says who? The governed are still, and always have been, the source where delegated governmental authority is derived. The preservation and protection of the people's rights are why government exists. If and when government officials fail to uphold and support the Constitution, upon which they have taken their official oaths to uphold and support, then they are in violation of law, have abandoned their fiduciary duties, have quit their jobs, and thereupon possess no lawful authority. All government officials, including local policemen and firemen in the cities and boroughs, must take an official oath on the Constitution. If the natural people and citizens lack knowledge, they will often fail to recognize when an ordinance or statute, passed by politicians, violates the supreme law of the land. No ordinances or statutes, or laws of any of the several states, can contradict or violate the supreme law of the land, see Article 6, and be held as constitutional. Physical, mental, and spiritual oppression has taken such a negating toll on the misinformed and miseducated masses, that many have become apathetic, and appear not to care, showing a lack of interest in their own welfare or that of their progeny. A misinformed and miseducated people are limited in knowledge to protect their substantive rights. Naivety subjects them, and their children, to multiple abuses against their rights. They can, and sometimes do, complain. More often than not, they get involved with selfing associations that rarely produce solutions. If one does not know the nature or cause of their condition or problem, one is not likely to find or effectuate solutions. Many others, who remain civically inactive, are even more unlikely and unable to solve their social and political problems. They often remain stagnated, while waiting for someone else to fix their condition. Consequently, this passive state of mind deems it almost impossible for them to protect or defend themselves from colorable acts of colorable government. Knowledge redeems, and improves the capacity of any active natural person or citizen to better serve man and mankind. Enforcing the Constitution is a civic duty, responsibility, and progressive action. Supporting principles of justice is the duty of all civilized people. This lends encouragement and support to a civilized world. Did you know that the first Constitution was the Articles of Association, 1774, the second was the Articles of Confederation, 1781 to 1788, the third was the Declaration of Independence, 1776, and the fourth is the present United States Constitution, adopted, 1789. Article 6 of the United States Constitution demonstrates the connectivity and unity in law of all the foregoing constitutions, Articles of Associations, Articles of Confederation, Declaration of Independence, Treaty of Peace and Friendship, and all treaties made under the authority of the Constitution, are the supreme law of the land. Scholars, and the erudite of jurisprudence recognize these documents of law as being one constitution. As for Moorish Americans, relate the Treaty of Peace and Friendship from this perspective. Article 6 of the Constitution for the United States of North America. All debts contracted and engagements entered into, before the adoption of this Constitution, shall be as valid against the United States under this. About the Secret Treaty of Verona. The Secret Treaty of Verona, as presented on the floor of the Congress on, is the foundation for the bias and corrupt, racketeering, and inquisitionist-oriented activities, color of law dictums, and negative attitudes practiced by and demonstrated by the European traitors and enemies of the Constitution and treaties, etc. The influence of the Secret Treaty of Verona and its effect on the Aboriginal and indigenous people of the land, Asiatics African, has been often misinterpreted and misrepresented as racism. All Moorish Americans should be aware of and diligent in matters in all social, economic, and political matters occurring on the North American continent due to the profiting and racketeering operatives benefiting by their allegiance to the Secret Treaty of Verona. This should be clearly associated with the following activities. A. The Civil War. B. Congress adjourning in Scindia in 1861. C. Dred Scott Case 1857. D. President Woodrow Wilson's secret meeting with representatives from the Vatican, Jesuit order, and the bankers of England with the purpose of selling the seats of the United States Republic to the Inquisitionist operations for North American conquest and the usurpation of the legitimate North American Republic. E. The usurping activities initiated by Franklin Delano Roosevelt in the year 1933 with the artificially constructed bank holiday, Executive Order 6073, 6111, 6260 and 6102, and the creation by the conspirators of the U.S. democracy system initiated for the overthrow of the constitutional republic. See Article 4, Section 4. Not limited to the above, are other related activities and measures, color of law, color of authority, color of office, and other like measures used to bureaucratize forced servitude and peonage. Below is the Secret Treaty of Verona in PDF format. Writs on this page are of no cost, as they are free to study and to utilize. However, an option has been placed on the site for those who have requested it, and are looking for assistance with reviewing and correcting their personal writs outside of the writs on this site that are free. They themselves have prepared their own writs and they themselves desire to have them reviewed and corrected prior to they themselves submitting them. This review assistance is for the purpose of content, lawful concept, spelling, grammar, continuity and unity as best as can be advised. Many who have taken the initiative in writing their own personal writs have taken a big step, and not only have they requested this service, they are willing to provide compensation for it, as they find it to be honorable and worthy and not dishonorable. rapblayz Publications does not receive compensation or donations for this service. It is referred to competent natural beings, of which we attest to their validity of knowledge. Ball and middle spinning. Click here for information on reviewing your personal writs service. Ball and middle spinning. Please fill out this form and send in with your writ to be reviewed. Horizontal divider 12. Continue further on this page for other writs, articles, and information, of which there are many, already prepared and provided free on this page, for your study and for your use. Horizontal divider 12. Posted 18th day of December 2012. In regards to boilerplates and paper terrorism, it has come to our attention that many of the usurping de factos, municipalities, Roman venues, courts, government entities, etc. have declared that Moors are utilizing boilerplates from websites and such writs are not to be received by them for that reason. Let us with a reasoning mind, think about the fact that there exist nothing but boilerplates when dealing with those same entities. When utilizing an attorney, when going on a so-called government website, what is there but boilerplates and forms to be filled out? These are assertions intended to discourage one from moving forward with exercising their rights and remedies. However, the most important and impactful problem you may experience is to submit a writ that you yourself do not understand, and understand. This is usually because you have not read it. Many think there is a silver bullet that they can shoot, yet do not know how to operate the device. This is attributed to a mindset that is looking for a savior outside of themselves, studying and casting their own spells. This is the direct effect of the spell of the Christian Crusades, in other words a European mindset and not a more national mindset. Note, when asked, "Do you understand?" in a court, know that that question in its terminology is a lawful question. Answering it yes means you stand under the jurisdiction and thereby submit to their jurisdiction. At the point that they realize you are not submitting because you have answered "No, I don't understand," they then turn the question into a comprehensive question and will suggest that you need a psychological evaluation because you don't understand. Do not be shook by this, as this is the trickery, deceit, and fraud. They just attempted to flip the script. The answer to that from you is "I object. I am not suffering from constitutional psychopathic inferiority." Constitutional psychopathic inferiority, individuals who show a lifelong and constitutional tendency not to conform to the customs of the group, and who habitually misbehave, and have no sense of responsibility to their fellow men or to society as a whole. These individuals fail to learn by experience and are inadequate, incompatible, and inefficient. Per the definition, many of us have and still do in fact suffer constitutional psychopathic inferiority. About paper terrorism and frivolous claims? If you have relied on prior decisions of True History Lesson. By comprehending the below two documents, Articles of Confederation 1643 and 1777, it will be clear to you that all of the names given to the land by foreigners are nothing more than sales territories, paper only, utilized after coming to work on the original slave plantations, of which the original slaves were the European Slavics inclusive of indentured slaves, and those who came direct from the galleys and jails to do fur trapping, etc. They came at the hands of, and under the jurisdiction of the British, Moors. Those groups of people came to be known as colonies, charters, unions and states, loosely referred to as States of America and finalized or formalized as the United States of America, but is not America. Those names, corporate tags, possesses no dominion, no territorial jurisdiction over the land, they operate upon the land. This is the ancestral estate/national domicile of the Aboriginal and indigenous Moors, who do in fact and in law, have territorial jurisdiction. Thus, the call to come and hear the truth about your nationality and your birthrights is not about processes, corporate procedures, statutes, ordinances, policies, and legalities that do not apply to you. Keep in mind, all that is lawful, substance of law, is legal, however all that is legal, form and process, is not lawful. Truth and falsehood is strangely mixed. Horizontal Divider 12. Posted March 4, 14. 2 comprehensive readings and test questions for Articles of Confederation of 1643 and 1777. The 2 PDFs below are the Articles of Confederation of 1643, and Articles of Confederation of 1777 with accompanying comprehensive test. Both are in regard to the colonist and their banding together amongst themselves to create a bond against the tyranny of the England Crown, the British or brutish Moors, of which they were running from, and eventually the native Moors who were at first receiving of giving them solace and later became intolerable of the colonists. Both are for your review in a set of comprehensive test questions, to challenge your comprehension. Keep in mind that plantations were locations wherein colonists resided. You will see that as you read wherein they say at such and such. These plantations later became companies and then became the present-day corporate states of. It is a matter of study to become conscious, as conscious means having knowledge. This class was given by Anita L. at the MHHS class at or near New York. 1 Willie Lynch test. Colonist Articles of Confederation 1683-1684-PDF. Ball and middle spinning. Test questions for 1643 Confederation. Horizontal divider 12. 1 Willie Lynch test. Colonist Articles of Confederation 1777, PDF. Ball and middle spinning. Test questions for 1777 Confederation. Horizontal divider 12. Posted March 5, 14. Quiz Constitutional Provisions 4th, 5th, and 6th Amendment. Below is a PDF with a quiz on the 4th, 5th, and 6th Amendment of the American Constitution of 1790-91. Most of the answers are in the reading of the quiz information and the Constitution itself, as well as a good law dictionary, preferred 4th edition or earlier, and/or Bouvier's Law Encyclopedia. It is not suggested to utilize law dictionaries beyond the 4th. The 5th is not bad, and anything 6th and up is not good to get the foundation of law definitions. As you may already know, many current-day law classes do not teach from the American Constitution, which is the law of the land, that any and all states' constitutions derive their authority and must abrogate, as all governments and government entities, courts, both administrative or otherwise, are established for the purpose of securing, protecting, and preserving the liberties of the people. Most current-day law classes don't even talk about or review status, yet status is the very first issue at law. Who are you? And what is your relationship to the community, which is not a mere relationship, but is a legal one? Most current-day law classes teach color of law, which by the way is a lawful definition. UP0, and reviewing it, you will determine if it applies to you, the natural living breathing in full life being, as opposed to being civil litter mortuus. Both are law terms to review. Horizontal divider 12. Ball and middle spinning. Comprehensive quiz, 4th, 5th and 6th Amendment, PDF. 3 pages. Horizontal divider 12. Vibasits/King George photo 2.jpg source of King George, 3 photo used in this website. Some have inquired as to the authentication of this depiction of King George. 3. We provide here the source as the Science Museum of London Exhibition RD London SW72DD, United Kingdom. We are aware of the hidden truth of history, particularly in the North American schools and institutions, especially corporate state public school curriculums. The full article we posted regarding this photo can be found on the What's New page, associated with Declaration of Independence. Horizontal divider 12. The Moors Heritage and History School was established by Sister Ross Mariah Bay, in 2006 CCY, to assist in the moving of information surrounding the Moors Divine and National Movement of the world. The Moors Divine and National Movement was established by Prophet Noble Drew Ali, who raised the consciousness of the people regarding their already existing, yet unknown, nationality and birthright principles and protections, and the impact it has on their economic security. This translates to the importance of one's natural person status, derived at birth, which entitles them to life, liberty, and the pursuit of happiness, as natural people, persons, as opposed to corporate persons. Corporate entities, persons, have no rights, only privileges. Thus at law they are considered fictitious and cannot be injured. For that reason they are being injured daily. It is necessary for them to proclaim their natural person status and begin exercising rights of birth, which are secured by the Constitution. It was necessary to bring this information to the forefront because it had been hidden, although in plain sight, through deceit and usurpation, particularly to those in the northern portion of the American continent. Drew came to the forefront with the establishment of the Old Canaanite Temple in 1913. Later, the Moors Holy Temple of Science/Moors Temple of Science 1925/26, and then adopted, 15 years later, the Moorish Science Temple of America, in 1928. He passed form in 1929. The remedy was to uplift fallen humanity and bring the people back into the constitutional fold of government, as stated in Drew's writing, Divine Warning for the Nations. He informed many, and formed unity, amongst those who have been labeled and branded Negro, colored, black, Ethiopian, Indian, etc. This usurpation and birthright theft was done in the spirit of ill intent and greed. There were false claims to that which was / the illustrious estate of the Aboriginal and Indigenous people who were branded Negro, coloreds, black, and who are correctly Moors with a myriad of family names, referred to as tribes over the course of history. The Moors Heritage and History School also recognizes the work of C.M. Bay, who taught Moorish science, cosmology. The zodiac, astrology wheel, is the ancient template left by our ancestors to teach us of the energies and the characteristics of man's relationship with nature. His work, Clock of Destiny 1 and Clock of Destiny 2, was filed in the Library of Congress. The Moors Heritage and History School is aware that anyone identified by brands and labels do not have rights. They have privileges, which are controlled by the very ones who usurped their birthrights and created the jurisdiction of Negro, black, colored, etc. These brands claim them as chattel property. Being chattel property, they will not receive any honor, reparations, respect, or dignity from the human family. They also do not honor their mothers. 1. Arbitrary, in an arbitrary manner, as fixed or done capriciously or at pleasure, without adequate determining principle, not founded in the nature of things, non-rational, not done or acting according to reason or judgment, depending on the will alone, absolutely in power, capriciously, tyrannical, despotic. Cornell, Virginia, Swisher County, Texas, Civ.ap, 78s.w.3d 1072, 1074. Without fair, solid, and substantial use, that is, without cause based upon the law. U.S. v. La Tempio, DCNY, 58F.2d 358, 359, not governed by any fixed rules or standard. People ex rel. Hultman v. Gilchrist, 188 NYS 61, 64, 114 miscellaneous 651. 2 Prima facie, at first sight, in the first appearance, in the face of it, so far as can be judged from the first disclosure, presumably, a fact presumed to be true unless disproved by some evidence to the contrary. State ex rel. Herbert v. Wims, 68 Ohio App 39, 38 N.E.2d 596, 599. 3 Ab initio, from the beginning, from the first act, entirely, as to all the acts done in the inception. A party may be said to be a trespasser, an estate to be good, an agreement or deed to be void, or marriage to be unlawful, ab initio. Plow. 61, 16a, 1 BLCOMM. 440, Hopkins v. Hopkins, 10 Johns. NY, 369. Before contrasted with this sense with ex post facto. 4 Colorable, that which has or gives color. That which is in appearance only, and not in reality, what it purports to be. Counterfeit, feigned, having the appearance of truth. Ellis v. Jones, 73 Colorado 516, 216 p. 257, 258. 5 POWER of attorney, a private attorney authorized by another to act in his place and stead, either for some particular purpose, as to do a particular act, or for the transaction of business in general, not of a legal character. 6 Wardship, in military tenures, the right of the lord to have custody, as guardian of the body and lands of the infant heir, without any account of profits, until he was 21 or she 16. In soccage the guardian was accountable for profits, and he was not the lord, but the nearest relative to whom the inheritance could not descend, and the wardship ceased at 14. In copyholds, the lord was the guardian, but was perhaps accountable for profits. 7 Minority, the state or condition of a minor, infancy. 8 Abandonment, the surrender, relinquishment, disclaimer, or cession of property or of rights. Voluntary relinquishment of all right, title, claim and possession, with the intention of not reclaiming it. The giving up of a thing absolutely, without reference to any particular person or purpose, as vacating property with the intention of not returning, so that it may be appropriated by the next comer or finder. Intention to forsake or relinquish the thing is an essential element, to be proved by visible acts. The voluntary relinquishment of possession of a thing by owner with intention of terminating his ownership, but without vesting it in any other person. The relinquishing of all title, possession, or claim, or a virtual, intentional throwing away of property. Abandonment includes both intention to abandon and the external act by which the intention's carried into effect. In determining whether one has abandoned his property or rights, the intention is the first and paramount object of inquiry, for there can be no abandonment without the intention to abandon. Generally, abandonment can arise from a single act or form a series of acts. Time is not an essential element of abandonment, although the lapse of time may be evidence of an intention to abandon, and where it is accompanied by acts manifesting such an intention, it may be considered in determining whether there has been an abandonment. Abandonment differs from surrender in that surrender requires an agreement, and from forfeiture, in that forfeiture may be against the intention of the party alleged to have forfeited. 9 COLOR, an appearance, semblance, or simulacrum, as distinguished from that which is real. A prima facie or apparent right. Preliminary study regarding U.C.C.S. Uniform Chimerical Codes. Posted July 26, 2010. The Uniform Commercial Codes, UCC, are for commerce, commercial contracts. There has been a wave of people who were attempting to gain sovereignty through a UCC contract. This is possibly the biggest carrot that has been placed before the people to hinder them from true sovereignty and to coerce them into consciously transferring their birthrights, rendering them ineffectual, because you are born sovereign and you cannot transfer, buy, or sell your sovereignty. Efforts in doing so is called slave trade. In the words of Drew, "Be careful, Moors, some of your own will put you back into slavery." Typically there are two levels of UCC filings that most have utilized. The first one is the UCC-1 filing, which allegedly secures the straw name. However, they essentially place themselves into the fraud, as a party to the fraud. The proper lawful procedure in not getting rid of your straw is to utilize XREL. See preliminary study of XREL on this page. This is what is meant and how one lawfully holds on to the slave name without being the slave name, which has been constructed as a fictitious entity by way of the birth certificate. All of these efforts have been constructed to keep you in the status of a corporation, constructed by a corporation. These constructs are not contracts at all, therefore they are void ab initio, meaning they have no lawful binding, other than that which you claim they have out of your lack of knowledge. In other words, it is your personal agreement that keeps them alive. Regarding the statement by Prophet Noble Drew Ali, "Don't get rid of your slave name. Do all new business in your new name." Many take the first part of that statement and run with it. If that were the case, there would be no need to add Bay, Al, Day, or Ali to your straw, and no need to say do all new business in your new name. That means sign everything in your new name, even that which pertains to the old, that is old, as you are the authorized representative of the straw, transmitting utility, and now you know so. Thus when you are in your proper person and have corrected the name, you have effectuated nunc pro tunc, meaning now for then. The straw has always needed someone to speak for it, and if you don't they will, as they have been doing in your ignorance of that fact. When you add your title to your straw, it immediately places you under the protection of your Moorish nation. By adding any of those titles, you have effectively corrected your name, and are instructed not to do business with your old name, do it with your new name. As you develop you may unfold into a spiritual attribute and you could have many appellations. An attribute describes, and since you cannot have a name you do have an appellation, that is why you corrected the name, as names are for corporations. You now acknowledge the straw as the fraud that has been perpetrated upon you, by them, therefore continued use of it, without the use of XREL, is admitting to the fraud. The UCC-3 filing is where people list their property and themselves as the first lien holder of said property. The truth is they are not the first lien holder because they are usually still paying for the property, and being taxed by the corporation in such a way that if they miss one payment, the property is taken away. To own property free and clear of liens is to have allodial property. The Constitution protects your right to be secure with your property, so you don't need a UCC filing for that. Mortgage means dead promise, and that is exactly what it is. You never own it, because even after you have finished paying the mortgage, if you fail to pay the fraudulently imposed taxes, they will take the property from you. You must have or create an allodial title in regards to allodial property. The mortgage companies are nothing more than the third party, acting as a trustee for what? Updated information. The document below is now in PDF and it is a report on the rally that took place near the Philadelphia Corporation. It is an excellent study tool for your understanding/overstanding of the mortgage myth, written by Taj Tariq Bey. It is excellent information for your study, education, and qualification benefit. Therefore study it well before taking other actions. Study well, and become competent and qualified in your knowledge and position about some of the major things that takes place with mortgages and foreclosures within the offices of bank representatives and agents, and any other claimants. It is wise to know these things as they relate strongly to your right of claim to your estate and property. After testing yourself for competence, then you are ready to issue to the bank, mortgage company, claimants, trustees, etc., the official correspondence found below the rally document, named Foreclosure Writ/Discovery. Be sure when submitting your correspondence that you address a natural person by name who is the representative or agent operating through or for the bank entity, mortgage entity, or any other entity making claims on the estate or property. Therefore, every time you correspond, place the name of a natural person that you are dealing with, or is dealing with you before naming the entity. Place their name in front of the entity name, as they are the natural person representatives. This prevents them from their practiced deceit of hiding behind corporation persons. Once they default by failure of qualifiably answering the stated questions, and they must answer all of them specific to the questions asked, you are then lawfully qualified to send them a default notice. We have found there is no need to send a reconveyance letter as your inheritance cannot be bought, sold, or transferred, therefore they are not and never have been a trustee of your estate. As you study, look up the words, ancestral estate, land, hereditament, corporeal hereditament and incorporeal hereditament. Also look up escheat and feudal law. In essence, study is required of you. Horizontal divider 12. 1 Willie Lynch test. Report on mortgage rally. Horizontal divider 12. 1 Willie Lynch test. Foreclosure writ/discovery. This writ, once understood, can be used for any financial request or demand from you, including collection agencies. Addressing misunderstandings. Of purpose concerning the Prophet Noble Drew Ali, the Moorish Divine and National Movement of the World, by Taj Tariq Bey. I have always found it troubling to see and recognize that many sincere and/or seriously interested natural persons have displayed an air of disillusionment, confusion, or misunderstandings concerning the direction and purpose of the Moorish Divine National Movement (MDNM). It must be emphasized to all people who receive Moorish culture class instruction that Noble Drew Ali was a universal prophet. Because Noble Drew Ali is a universal prophet, public airing of his literature and message is directed to the people of North America at large and not just to the fallen Moors, his people. The Prophet Noble Drew Ali made a firm and compelling plea to the nation, and presented to us the specific grand principle of love, truth, peace, freedom, and justice. Upon making this historically famous plea, the Prophet addressed the people, qualifying their loyalty. This is the specific order in which he, the Prophet, clearly addressed three specific bodies of the people, who make up the citizenry and/or body politic of North America. 1. All loyal, faithful Moors. 2. Members, nationality card-holding members of the temples. 3. The American citizens. Warning: remember that the Prophet directed his call to the above-mentioned peoples in the public arena. Look at the order or sequence in which those he addressed is placed. Do not allow anyone to try to convince you or your children offspring that he the prophet did not address the above said peoples. Let no one without a challenge try to imply, in any way, that any of the above stated persons have no right to possess the prophet's literature or writings, or that they cannot or should not talk about, analyze or discuss those things which our prophet brought to us. If anyone has any doubt to the correctness of what I have just said, then go to the prophet's own words, which are written in his Moorish literature booklet, under the editorial, A Divine Warning by the Prophet for the Nations. It is upon this document that the Moor's Order of the Round Table bases its origin and purpose. This is why I have set about the task of producing literature to counter the subversives among us. It is not personal, it is for the nations and the Moorish divine national movement. The social, spiritual and political proper person concepts and proper conduct initiatives which the Prophet encouraged the people to act upon, must be made common public information and should be readily available in every public library and on display in any of the various bookstores. However, history and the records show that a few subversive characters/persons deceitfully presented themselves as honorable and sincere members within the Moorish temples and thereby successfully gained positions of authority and power within the Moorish movement. Some of these traitorous, disingenuous, and selfish persons set about their work and intent of slowing down or neutralizing the Moorish divine national movement. Upon analyzing Moorish literature and information, the oral and written words of many honorable sheikhs and sheikhesses, the limited records made available by the Federal Bureau of Investigation (FBI), a pattern of negative intent and actions can be easily discerned and recognized. The following are a few of those recognizable acts or actions which are derivative of the above said patterns of negative intent. Any and all attempts made at neutralizing the Prophet Noble Drew Ali, by way of suppression of the exposure of his pleas messages and literature, as it was all directed to all loyal, faithful Moors and to the people at large. The artificially injected divisions and schisms presently existing among Moorish holy temples of science, the Moorish Science Temples of America, and the Moorish. The Moorish American Institute was founded by C.M. Bay in 1965. It was organized and headed under the name of Clock of Destiny National Cultural Club. Its doors were open to students who sought the teachings of Noble Drew Ali by C.M. Bay at 8916 Cedar Avenue, Cleveland, Ohio. C.M. Bay continued those teachings from 1965 to 1969 at the above location. At that time, Cleveland, Ohio was the only city where the lessons of C.M. Bay were being taught. After the establishment of Clock of Destiny National Cultural Club, C.M. Bay moved forward to form another group. At one time there were as many as four different organizations headed under the Clock of Destiny National Cultural Club operating in the city of Cleveland. Even though C.M. Bay was closely affiliated with James Johnson Bay in 1956, and considered him as a vital functioning entity for the distribution of this knowledge, James Johnson Bay formed the now existing Moorish American Institute in 1970, which was housed at 2844 Woodhill Road, Cleveland, Ohio. The Institute has always maintained original teachings of Noble Drew Ali passed down through the various teachers since 1965 and prior to the establishment of the Moorish Science Temple and its acquisition to religious connotations. As direly expressed, so as not to cause confusion to those who are seeking religious principles, Moorish American Institute is not a religious organization or church. Our sole structure is based upon logic of universal knowledge and scientific definitions thereof. Moorish American Institute specializes in the teaching of Moorish history, zodiac science, yoga, and many other sciences that tend to aid humanity in understanding the universe which surrounds, and is within us. When the true Moorish history is known to the Asiatics, they will no longer have a reason to resent the Europeans. Upon completion and through understanding of the student's 10-week introductory course, he/she will then have acquired enough tools to enable the student to be issued a Moorish American Institute nationality card. At this point in time, students are then advised to continue their pursuit of even higher studies through the circle of mothers and sons. Within this circle, the student acquires a broader scope of universal law in effect, wherein he/she will become totally able to utilize the tools and skills obtained in order to display intelligence, uprightness, and to become productive individuals, mentally, physically, and spiritually, and to help others like themselves continue the struggle to revive and reorganize that which has been lost from us during the time of Asiatic rulership over the masses. It should be noted to all prospective students of interest that during the course of learning, one will come to know things that the average layman may term deviating or slick. Caution is advised to all, in that this knowledge should never be exploited or hustled for personal gain over those who are not aware that it even exists, nor how to best apply it for their own personal benefit and/or success, be it to themselves, or to the nation as a whole. Failure to adhere to such a warning will only result in the destruction of the perpetrator. C.M. Bay authored Clock of Destiny 1 and Clock of Destiny 2, a great humanitarian treatise, which was filed in the Library of Congress, with obvious intent to be public material, and for preservation. He also wrote Circle of Life, wherein one can do a personal chart based on the planetary energies at one's birth, and the zodiac constitution, as well as humanitarian episodes lessons. Zodiac Constitution. Highly qualified, penned by C.M. Bay a 3rd, 33rd, and 360-degree, Free Moorish Master Mason, Master Astrologer, Ph.D., LL.D., and Constitution Lawgiver. Masterwork copyrighted and registered in Library of Congress, Copyright Office, and Department of Justice, at Washington, D.C., United States Republic of North America. About the fez. The fez is the ancient and modern national headdress of the Moabites/Moors. The fez is a brimless headdress most commonly produced in scarlet red with an ebony/black tassel. The red fez is matched by the red field displayed in the Moorish national standard flag. The fez is also produced in black, white, and other color variations indicating other meanings, social order positions, etc. The black fez is the highest degree. It is worn by the mufti or Mohammedan judge, Moorish United Front towards Islam, enforcement and security. The one who wears it symbolizes that he/she knows law in full, and is able to defend it, including knowledge of martial arts, defense physically and spiritually, likened to the martial arts degree of the black belt. The fez is worn as a symbol of the womb. The top of it has a nipple shape that symbolizes the navel. The strands of the tassel are 360-degree, as in 360-degree degrees of knowledge. The tassel is not pinned down as it is in the secret societies. Properly, the free-flowing tassel is indicative of one who is born of the womb, endowed with and aspiring to and beyond 360 degrees of knowledge. They navigate upon the earth and their potential is not limited, not pinned down, or kept secret, however it is sacred. The 4 sets of air holes are equal to the number of woman 9, and add to 13, the number of times a woman cycles per year, which is in tune with the cycle of the moon. The following is an explanation, found in Lesson Book Number 1, written by Taj Tariq Bey of the Moors Order of the Round Table. Fez, the national headdress of the Asiatic Moorish nation of North, South, and Central Al-Moroccs, Americas, including the adjoining islands. The fez is typically of red felt, with an indigo black tassel. The fez is the headdress of the ancient ones, the Moabites/Moors, also spelt Moor. It is geometrically formed to represent the eternal zodiac. The body at the fez symbolizes the womb of the cosmos and the womb of woman, mother. The 1-inch finial which extends out of the center of the fez is the number 1 and the 9th letter in the phonetic Moorish alphabet I. This also symbolizes the navel, I. The cord extending from the I, symbolizes the universal umbilical cord of universal life and represents the oneness of all life. It also represents the tie to the source of humanity, Zodiacus, the first woman. The circular, round, ball of the tassel represents the mundane circle or earth. The cord wrapped about the tassel strands hold the form of the circle arid represent the unity of life through the zodiac constitution of humanity. It also represents the cyclical and reciprocal nature of life. The strands of the tassel represent the 360 degrees of the zodiac. The highest law errant authority in civilization. The zodiac crown of light, the national headdress of the mothers and fathers of the human family, founders of civilization, and masters of the cosmos science. 33rd and 360-degree master masons and eastern stars. This is a part of the hidden truth which has been buried in the dark corner of the north gate. The fez, symbol of the eternal zodiac, is also called a tarbouche, a tiara, a corona sol, and other names, which describe its royal status. The wearing of the fez regarding masons of clandestine orders. Fez is also the name of the old Moorish capitolium and city, which is located in northeast Morocco. Morocco, Moroccan, and Moors are one and the same pedigree and peoples. American is a dialectical corruption of the name Al-Moroccan, which means descendant or descendants of Moroccan. The lack of consciousness of law and history, on the part of any so-called Negro/Black Mason, concerning the ancient history of the Americas, has stagnated or retarded their ability to see through the veil of their own hoodwinking. Is Fez the city in Europe? Is the Fez the national headdress of Europeans, or is the Fez the national headdress of Moors? Who is wearing the Fez only by ritual? The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States, but all duties, imposts, and excises shall be uniform throughout the United States. The Constitution for the United States of America, Article I, Section 8, Clause 1, 1:8:1. Horizontal divider 12. People are not goods and imports. Persons are not the subjects of commerce, and not being imported goods. They do not fall within the meaning founded upon the Constitution, of a power given to Congress, to regulate commerce, and the prohibition of the states for imposing a duty on imported goods. Ibid. Gibbons v. Ogen 9 Wheat 1, 5 Cond Republic 562. Horizontal divider 12. Page navigation. People are not goods and imports. Qualifications and proof. United States admits IRS is not government. General pertinent information. Big news regarding IRS collective lien notice. Swanson Flow Systems vs Commissioner. SSN is account number. SSN public notice. Sales tax not for natural people. Income taxes. Volunteer taxpayer. Congressman Hurdle cannot tax private sector. Senator Foreman taxes are voluntary. IRS Rep Mills taxes are voluntary. IRS incorporation papers. More on SSN privacy case law. Felony to force use of SSN. Horizontal divider 12. Mandatory public notice in regards to SSN and IRS withholding. Many, or some of us, have heard that the W-4 withholding is voluntary, and even though we have stated this, and many others have, it has gone unnoticed and unheard. Maybe because we have not read or seen any documented proof. Off on this page is a wealth of information. Still, our conditioning, and lack of study, has it so that we are not aware of how unconstitutional it is for anyone to demand that one must participate and make either SSN or IRS deductions. This is in accordance with the American Constitution of 1791, which is the law of the land, for all entities, associations, corporations, etc., established upon the land. Constitutionally, withholding of anyone's compensation for exchange of their energy is in fact unconstitutional, as the tax is imposed on the energy of the people, and it is an unconstitutional act for any corporation on record as not even being an agency of the federal government. In fact, not too long ago, you would see the postings in the employment office and at the workers' lunch area, that expressed rights as it relates to sexual harassment in the workplace, fair wage rates, and other various types of discrimination and issues relative to the rights of the worker. As well, there is another body of information that is supposed to be posted, as a requirement of all employers, and that is 2 public notices expressing that the W-4 withholdings, inclusive of the SSN and IRS, are voluntary. Have you seen it? Click below so you can review it. Pay close attention to the last line. Additionally, your employer, whoever that is, has an agreement with the respective state in which they have established their business, and they have agreed to offer you the W-4 upon your hiring. They have also agreed to be fined or sanctioned by the respective state if they, the employer, does not offer you the W-4 form. What you need to know is that an offer may be made, but you have the right to refuse such offer and you are not to be terminated as a result of it, as those deductions are in fact voluntary, thus is your choice and at your will and can be terminated at your will. There is absolutely nothing unlawful about not wanting to make voluntary contributions. Because the people have not known this, it has become common practice and expected income for corporations and has escalated to many being in fact threatened with termination by their employer. The employer may be beholding to the corporate state it was established under and they have agreed to comply as an agent of same. But that does. And through covetousness shall they with feigned words make merchandise of you, whose judgment now of a long time lingereth not and their damnation slumbereth not. Covetous, inordinately desirous, especially of something belonging to someone else. Greedy, acquisitive, grasping, avaricious mean having a strong desire for possessions, grasping, adds to covetousness the implication of selfishness and often suggest the use of wrongful or unfair means. Horizontal divider 12. Police, city, nor state cannot deprive natural people of their unalienable/inalienable absolute right to travel. Liberties are broad, however, in its most strictest sense it means the following. Personal liberty, the right or power of locomotion, of changing one's situation, or moving one's person to whatsoever place one's own inclination may direct without imprisonment or restraint unless by due course of law. Upon this constitutional republic form of government, the only thing you owe the public is due care. Under the United States Republic's constitutional system of government and upon the individuality and intelligence of the citizen, the state does not claim to control one's conduct to others, leaving one the sole judge as to all that affects oneself. Mugler v. Kansas 123 U.S. 623, 659-60. The right to travel, the right to mode of conveyance, the right to locomotion are all absolute rights, and the police cannot make void the exercise of rights. State v. Armstead, 60 S. 778, 779, and 781. The right of a citizen to travel upon the public highways and to transport one's property thereon, either by carriage or automobile, is not a mere privilege, which a city may prohibit or permit at will, but a common right, which he/she has under the right to life, liberty, and the pursuit of happiness. Thompson v. Smith 154 SE 579. The state is prohibited from violating substantive rights. Owens v. City, 445 U.S. 662, 1980, and it cannot do by one power, e.g. police power, that which is, for example, prohibited expressly to any other such power, e.g. taxation/eminent domain, as a matter of law. U.S. and UTV Daniels, 22 p. 159, nor indirectly that which is prohibited to it directly. Fairbanks v. U.S. 181, U.S. 283, 294, 300. The right to park or travel is part of the liberty of which the natural person, citizen cannot be deprived without due process of law under the Fifth Amendment of the United States Constitution. Kent v. Dulles 357 U.S. 116, 125. Horizontal divider 12. Highwayman. A bandit, one who robs travelers upon the highway. Source, Black's Law 4th edition dictionary p.862. It is not the duty of the police to protect you. Their job is to protect the corporation and arrest code breakers. Sapp vs. Tallahassee, 348 so 2nd 363, Reef vs. City of Philadelphia 477 F 1262. Lynch vs. NC Department of Justice 376 SE 2nd. 247. Note, they are policy and code enforcers/highwaymen, who also act as mercenaries. Your right to travel upon the land is not a policy, nor is it embodied in a code. It is a substantive right of birth, that cannot be abridged or leaned upon. thus unalienable and inalienable. You are the traveler, unless you are doing commerce, you are not a driver. It seems minuscule, however it is the truth of fact. Words are very important as that is what jurisdiction is, right words. Horizontal divider 12. Page contents. Sheikhs and Grand Sheikhs position, just praetorium residential judicata additional travel case laws personal liberty case laws denial of case law affidavits quasi-criminal courts reason for treason do you know your rights? Moor's writ of protection to General Assembly DMV failure to disclose Bruce McCarthy manufacturer certificate of origin driver's license fraud suspended driver's instrument what is a surcharge? Policeman code of ethics what is conspiracy? About dismissal affidavits ticket dismissal affidavit vehicle traffic and judges. Magistrates. Horizontal divider 12. Ball and middle spinning. Senator Franklin, Georgia proposal to abolish driver's license 2011. Ball and middle spinning. Analysis of Senator Franklin, Georgia proposal. Horizontal divider 12. Ball and middle spinning. Letter to Judge from Senator, regarding right to travel, 2006. Ball and middle spinning. Letter to Arizona Department of Public Safety from Senator, 1995. Posted July 26, 2010. Horizontal divider 12. Any government entity and officers of said entity do not operate as a separate government. They are trustees/public officials of the established law of the land for everybody. It is necessary to clear up a very confusing and misleading belief. Any government entity and officers of such entities established in this land, North American continent, are trustees/public officials of the inheritance of the Moors the land, the resources of the land, etc. The European colonist and any government entity and officers do not have a government on their own. This is the land of the Moors. Lemuria/Northwest Amexem/Northwest Africa/North America. We the people of the United States, the Moorish nation state, do ordain and establish this Constitution for the United States of America. This being done with several processes in bringing others into the American national constitutional fold of government, however everyone is not the American national, aboriginal and indigenous to the land, one of them being the pre-mandate, the Treaty of Peace and Friendship. Then the Constitution was established as the law of the land as to the laws governing one's behavior in the land. The United States of America is a corporation and corporations do not tell the natural people what to do. The natural people have already established the laws that govern all. Many Moors think in error that they must start a new government, a new nation and they are in grave error as this is their inheritance, their illustrious estate, and they are the aboriginal and indigenous people who establish the Constitution as the law of the land for everybody. And it is a republic not a democracy. Those who support democracy are committing treason against the people. The European colonists are naturalized citizens here. As public officers/trustees they have a fiduciary duty to protect and preserve the rights of the natural people. This is why Prophet Noble Drew said to enforce the Constitution, the North American Republic Constitution for the United States of America. Residential judicata, a matter adjudged, a thing judicially acted upon or decided, a thing or matter settled by judgment. A phrase of the civil law, constantly quoted in the books. Rules that final judgment or decree on merits by court of competent jurisdiction is conclusive of rights of parties or their privies in all later suits on points and matters determined in former suit. And to be applicable, requires identity in thing sued for as well as identity of cause of action, of persons and parties to action, and of quality in person for or against whom claim is made. The sum substance of the whole rule is that a matter once judicially decided is finally decided. Note, this is in regards to stare decisis case laws, which apply to all states and several states, etc. This is distinguished with estoppel as it is the basis upon a cause and need for an estoppel. The intent of an estoppel in its broadest sense is penalty paid by one perpetrating wrong de facto court administrators by known fraud or by affirmative act which, though with, or without, fraudulent intent, may result in legal fraud on another. This is what is being done in most of the de facto fraudulent courts, in that they violate the law against the people, yet they are deemed to know the law by their very position and seats they sit in. Officers of the court have no immunity, when violating a constitutional right, from liability. For they are deemed to know the law. ON. V. Independence, 100 SCT 1398, 445 U.S. 622. Administrators defined government succinctly. Governments are corporations, inasmuch as every government is an artificial person, an abstraction, a creature of the mind only. A government can deal only with artificial persons. The imaginary, having no reality or substance, cannot create or attain parity with the real. Penhallow v. Dones. The position of sheikhs and grand sheikhs is supported in law and in Article 3 of the Constitution. Jus praetorium, in civil law. The discretion of the praetor, as distinct from the leges, or standing laws. That kind of law which the praetors introduced for the purpose of aiding, supplying, or correcting the civil law, for the public benefit. Note, this is the position the sheikhs and grand sheikhs are supposed to hold and effectuate in the spirit of making law and enforcing law for the Moorish nation, as the Moorish nation is the authorizing nation-state and encompasses the whole body of law use, by way of use sanguine, by blood, and being in this land, which is the estate and dominion of Moors. The Grand Sheikh's position is supported in Article 3 of the Constitution for the United States of America, ministers and consuls. State governments are but trustees with a derived authority. 4 Week 402. Horizontal Divider 12. Posted January 10, 2014. Additional info on fraudulent activities in regards to driver's license instruments and the natural people. We have added additional travel case laws and information for your review, study, and application. There are another set of case laws that are and have always been at the end of this page in PDF format entitled Vehicle Traffic and Judges, along with a ticket dismissal document. We have copied the Do You Know Your Rights document from the Open Readings Downloads page and attached it here as well. Within it are 13 Supreme Court case laws, most of them involve traveling. We have also added a PDF that gives you supports when a state court denies your affidavits and tells you the Supreme Court rulings do not apply to them because they are from another state. This is a farce. Pursuant to Article 6, all law and all Supreme Court rulings apply to the several states, to all the states. The issue would then become a matter of diversity of citizenship, as a natural person would follow the laws of the land, and so must any government entity. Those who are members/citizens of a corporate state obviously agree to follow the policies, statutes, etc. of said state, of which the corporate state's policies are not law and they apply to a specific class of persons, and those persons are not the natural people. Remember, persons can mean corporations, as it is in the first clause of the 14th Amendment. The information contained within the denial of affidavits, of case laws is what you need to know. We also have attached information in regards to jurisdiction of a court, in pursuance to Article 3, and this is for when they tell you that they are a quasi-criminal court, of which there is no such lawful sanction for. It is in the definition a semblance of that which is real. It is a colorable office, exercising color of law and operating under color of authority, which means it is not a valid court, and it has no judicial authority granted to it from the legislature, as the legislation does not grant judicial authority to ministerial, incompetent courts. Driving is a commercial activity and the license instrument is for drivers only. For commerce, going to the store, to visit a friend, etc., is not commercial activity. As a natural and substantive right, you have the right to travel upon the land without license, registration, tags, insurance, etc. Of course, you owe the public due care, and you must remedy any injury you make to another or another's property. However, to be exploited and violated in a manner that causes you injury via stealing your rights and your property, including your body being imprisoned, or rather kidnapped, is another issue. To send revenue collectors on the highway, feigning as police officers, when they are private police enforcers carrying guns and enforcing policies, and are breaking the law themselves, which prove they are not law enforcers, is another issue. For those who think they must have a DMV teach their children due care, we suggest you rethink that, and recognize that your child can learn to operate a conveyance, be it an automobile, a truck, a tractor, etc., without the exploitation of a private corporation for profit called the DMV, feigning as a government entity. In fact, the permit is sufficient, unless it has adhesions that place you or your child in a state's jurisdiction that operates under color of authority and with the intent to exploit the law. Horizontal divider 12. 1 Green ball. Additional travel case laws. Horizontal divider 12. 1 Green ball. Personal liberty case laws. Personal liberty is the right to locomotion, the right to travel freely without restriction unless by due process of law. It is a fundamental substantive right, a right of birth, a birthright. Come hear the truth about your nationality and birthrights. Horizontal divider 12. 1 Green ball. Denial of affidavits regarding case laws. Horizontal divider 12. 1 Green ball. Quasi-criminal court. Horizontal divider 12. 1 Green ball. Reason for treason. Horizontal divider 12. 1 Green ball. Do you know your rights? 13 points of law. Horizontal divider 12. Posted October 10, 2010. Writ to General Assembly and Order of Protection. By Sister Anita L. The PDF below is a writ to the Connecticut State General Assembly by Sister Anita E.L. Enclosed in it is a questionnaire for the General Assembly to answer, as it was originally sent to the respective state's DMV and the commissioner of said DMV was unable or unwilling to answer it. You may adopt it and send to the local state DMV operating in your territory. Be sure to have it sealed. Also included in the PDF is an order of protection. All Moors can copy it down and use it, as it is for all Moors based on, but not limited to the facts that Moors are not and cannot be citizens of the corporate United States of America, or any of its enclaves, as indicated in the original and organic 13th Amendment with 20 sections and in accord with the Treaty of Peace and Friendship and the United States Republic Constitution. Documents contained within this PDF are printed on August 5, X11. Parchment paper stands out best for the order of protection. Horizontal divider 12. 1 Green ball. Writ to General Assembly and Order of Protection for Moors. Horizontal divider 12. Posted October 25, 2010. Division of Motor Vehicles Failure to Disclose. By Sister Anita L. According to the state, one is required to obtain a certificate of title and to register their private property, conveyance, with the Motor Vehicle Department. Attached is an interesting written dissertation between Bruce McCarthy, a citizen of Missouri, and the Missouri Motor Vehicle Department. McCarthy was requesting clarification as to their requirements regarding obtaining a title, which equates to asking what law supports their position and compels anyone to have to obtain a certificate of title from them, and register their vehicle with them. The Motor Vehicle Department, states that in order for one to show proof of ownership of their personal property, they must receive a certificate of title from the state, and then they must register it, turning it into a motor vehicle, which then places it as their Motor Vehicle Department property under commerce. Essentially, factually, and lawfully, in doing so, one is surrendering ownership of their property to the State Department, of which the property was not bought from the state, nor does the state have the bill of sale or receipt you do from whomever and wherever you bought it. To add insult to the injury and the fraud, one is paying to sell their property to the state, via title cost and other taxes. Essentially, the unsuspecting, unknowing citizen is enriching the corporate state, allowing them to gain further assets perpetually and annually via registration, insurance, tags, etc., which are taxes. McCarthy's poses an interesting question to the State Department of Motor Vehicles: what proof of ownership exists prior to one obtaining a certificate and registering their personal property with the Motor Vehicle Department? The written exchange is very informative and unveiling. As Moorish American national citizens, we care to address a few points for you to keep in mind when reading the article. Point number 1, as a Moorish American national, you cannot be a member/citizen of any Union state. Per United States Republic Original 13th Article of the Bill of Rights. No one of African descent can be citizens. Point number 2, it is implied within this dissertation and in numerous communications/directives from the various member states, as well as the federal government, that states relate to the land. However, they do not, as the land is the inheritance of the Moors and was never given, exchanged, nor can it ever be sold to anyone. Therefore, whenever you read anything that says in the state of Missouri, or elsewhere, know that this does not include any portion of any land on the American continent. It only refers to a political allegiance, of which Moorish American is a political allegiance/jurisdiction for Moors in America. Point number 3, the state of Missouri, state of Connecticut, state of New York, state of New Jersey, state of, whatever, etc., are federal enclaves. They are subsidiaries of the federal government. Therefore, whatever applies in Missouri applies in every federal enclave and is not specific to any one federal enclave. This trickery, misrepresentation is used to mislead the people and keep them thinking they are dealing with separate and independent Union states. Yet, they are not. All of the Union states have been taken over and converted to federal enclaves. Point number 4, always keep in mind that the government was created for the people, by the people, for one purpose, and that is to secure, preserve, and protect the unalienable rights of the people. Therefore, no government can hinder, compromise, enslave, abrogate, or convert any of the rights of the people. Per the United States Republic Declaration of Independence. To secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Where rights secured by the Constitution are involved, there can be no rule-making or legislation which would abrogate them. Miranda v. State of Arizona, 86S.CT 1602 at 1636, 384 U.S. 436 at 491, U.S. Arizona 1966. The following are additional case laws to keep in mind. While reviewing the manufacturer's statement of origin in PDF form at end of this document, a state cannot impose restrictions on the acceptance of a license that will deprive the licensee of his constitutional rights. Ruckenbrod v. Mullins, 102 Utah 548, 133p.2d 325, 144 ALR 839. There can be no sanction or penalty imposed upon one because of the exercise of a constitutional right. Scherer v. Cullen, 481 F 945, 9th Sir 1973, Spivak v. Klein, 385 U.S. 511, 1967, Garrity v. New Jersey, 385 U.S. 493, 1967, Boyd v. U.S., 116 U.S. 616, 1886, Malloy v. Hogan, 378 U.S. 1, 1964. No state shall convert a liberty into a privilege, license it, and attach a fee to it. Murdoch v. Penn, 319 U.S. 105. A writing is void ab initio in the case of fraud in the inception, and it need not be formally rescinded as a prerequisite to right of avoidance. Benaxi v. Massachusetts Bonding INS Co., 1943, 58 CA 2D 657664. When a citizen is attempting to enforce the Constitution, as herein shown, he is doing so not for himself alone but also for others as a private attorney general vindicating a policy that the Constitution writers considered of the highest priority. Newman v. Piggy Park Enterprises, 390 U.S. 400, 88 SCT 964, 966, 19 L. ed. 2D 1263, 1265, 1969, Otis v. Crown Zellerbach Corp., 398 F2D 496, 499, CA 5, 1968, and Jenkins v. United Gas Corp., 400 F2D28, 33 N10, CA 5, 1968. An administrative regulation, of course, is not a statute. U.S. v. Mursky, 1960, 361 U.S. 431. Statutes must be known. Vagueness of wording is aggravated by prolixity and profusion of statutes, regulations, and administrative machinery, and by manifold cross-references to interrelated enactments and rules. Kioshian v. Board of Regents of U of St of NY, 385 U.S. 603, 604, 87 SCT 675, 684, 17 L ed 2D 629, 1967. Please keep the above points and case laws in mind while reviewing this 30-page document. The below manufacturer's statement of origin, by Bruce G. McCarthy, consists of approximately 33 letters of correspondence between him and the Division of Motor Vehicles. It demonstrates the process used by the DMVs to take ownership of your automobile. It is a great study for comprehension. We have put in it a PDF format for you to print or download. 1 Willie Lynch test. Manufacturer's statement of origin. Horizontal divider 12. Driver's license fraud. By Taj Tariq Bey. The highest court in the land, possessing original jurisdiction, has ruled that no state can make any laws or rules that abrogate the people's rights or the supreme law of the land. However, due to extreme levels of debauchery, misprision, and fraud permeating all levels of government, by dishonest politicians, judges, and prosecutors, the natural people have been consistently robbed and suffer the destructive results of abuse of authority. Criminals wearing black robes, and faking as Article 3 judges, have created and acted as auctioneers, administering a system of deception that has led many unsuspecting natural people into believing that they, the accused, have violated the law, when in fact they have not. The thieves and criminal officers of municipal courts all over the land, have converted rights, secured and reserved for the people, into crimes. Thereafter, fining and jailing them, under a color of law and a color of authority. Color means, an appearance, a semblance, or simulacrum, as distinguished from that which is real. Color, fake, imitation, misrepresentation, and fraud are synonyms. Concerning the social position of the natural people, in their relationships with others, due care is an important issue, and involves having and maintaining a keen sense of responsibility to recognize the rights of others. This is the social duty of all citizens and natural people, when interacting publicly and with others. A lack of preserving civil responsibilities, or a blatant neglect of civilized principles, morals and ethics, would be detrimental to all. A fundamental knowledge of the de jure law of the land, constitution/treaties, which preserves and secures the rights of all natural beings and citizens, is a common social obligation, relegated to all members of a society. Ignorance, greed, colonialism, and the construction of fraudulent adhesion contracting, legal frauds, have caused many to divulge themselves as being far less than honorable, and reveals their true deceptive tendencies and will to violate the basic moral and ethical principles of civilization. Unkind actions and anti-constitutional legislation, created by the unclean hands of ill-trusted corporate administrators, have proven highly destructive to the unalienable rights of the natural people. Unalienable rights are rights which are not alienable. This means that such rights cannot be transferred or sold to another, etc. Political thieves, usually descendants of European colonists operating upon the American continents, have, by outright criminality, taken unlawful leave and advantages of the usurped seats of government, and have polluted the sanctity of their official oaths to uphold the Constitution and treaties and are unlawfully violating the natural people. Consequently, much of the ignorance, plaguing and stagnating the natural people, has more to do with deliberate misguidance, misprision, falsehoods, and miseducation. This is due to a designed lack of knowledge, deviously promoted and controlled by these same miscreants. Pseudo-government operatives, administrative, have knowingly, and with forethought, often substituted themselves for true, Article 3 judicial, sanctioned authorities. Organized criminal controllers of these misrepresented seats or offices of authority, have made and generated incalculable amounts of finance for unchecked municipal racketeers. Racketeering is a law term that applies to an organized conspiracy to commit the crimes of extortion or coercion, or attempts to commit extortion or coercion. Racketeering is the obtaining of money or property from another, without his consent, induced by the wrongful use of force or fear. The fear which constitutes the legally necessary element in extortion is induced by oral or written threats to do an unlawful injury to the property of the threatened person by means of explosives, fire, or otherwise, or to kill, kidnap, or injure him or her, or a relative of his or her family, etc. Perjury, of, oath perpetrators, being the unsanctioned administrators ministers of cities, towns, boroughs, inclusive of their contracted municipal court officers, have usurped judicial powers, for their own private benefit. Many have suffered bureaucratic forced servitude by their unlawful acts, as they have used jurisdictional powers, not delegated to them, to incarcerate people, and to colorably put people at risk, placing them into perpetual patterns of legal, yet not lawful, compromission, and bringing about losses of property, losses of finances, and constant abrogation of their unalienable rights and substantive rights. Poverty and theft by design, incorporating jail, as an industry, has been used to state agents and agencies to impose coercive extortion, initiated by lack of due process pleas made before unlawful private corporate tribunals. Most of these being misrepresented as legitimate courts. This politically protected criminality has hindered many natural people from enjoying or exercising rights secured by the Constitution/Treaty and the Bill of Rights. Criminals in government have thus imposed feudal fees upon the people, converting rights into crimes, and hindering them from traveling, etc. When the natural people, heirs apparent, possess, or gain a clear understanding and knowledge of how they have been robbed and exploited by these foreign, unworthy adulterers of the law, they can, and will, begin such necessary, anti-racketeering, actions and studies as needed to remedy their injuries and begin to turn around the conspiratorial extortions and foul acts of arbitrary committed on a daily basis. It must be clearly understood by all that the state's driver's license instruments are a corporate use tax relegated to foreign corporate privileges, and are customs payments made to the alleged sovereign, and deemed for commercial usage and privilege. When natural persons are operating their own private vehicles, conveyances, automobiles, or vessels, unless they are corporately carrying passengers for hire, they are not driving, they are traveling. Driving pertains to commercial activities. Traveling the public roadways and highways are natural and substantive rights, having nothing to do with privileges. This clear distinction between the words driving and traveling may seem to be trivial to some readers, however, that specificity has caused many to lose a substantial amount of freedoms and finance. For many poor families, this disingenuousness has manifested into politically instigated and targeted economic states of depression. Below is an example and explanation about the misuse of administrative and ministerial powers. These facts and concepts may help one to understand how to get out from under the foul yoke of being robbed by agencies and persons who have been, and are, using extortion tactics, guised under the misrepresented surcharges. Suspended driving instrument. Due to failure to pay surcharge. If you, the natural person, are operating with the state's imposed driving instrument, and had a surcharge imposed upon you, know that the contract instrument is essentially a surcharge for being stopped from exercising a right. It is important for one to know that such an imposed surcharge is an unlawful and unauthorized impost. Imposts are taxes, levies, or duties imposed upon foreign nations or corporations. Surcharges are compound or secondary fees or fines, levied against one for driving and are typically spread over monthly extortion payments for a few years or so. The ministerially adjudicated surcharges are usually paid, under threat of warrant or arrest, to a different entity, person, and address other than the state-contracted Department of Motor Vehicles, DMV. Such acts are actually active and constructive fraud, and are no more than collusive acts of conspiracy. If the natural person or citizen fails to pay the surcharges, ransoms, in the time or manner they, employees of the agencies/municipalities, have set, or imposed, they then notify the DMV to suspend the state's imposed license, which is rented annually for a fee. Such an action instituted against anyone, must be relegated to conspiracy to extort. The corporate municipal agents also notify the local courts, police officers, townships, cities, court systems, etc., to take unwarranted legal process actions against you, the accused violator. The usurping state, through its hired thieves, thusly uses color of law and color of authority to hinder you, the natural people and citizens, from traveling the public roadways and highways. This deduces the use of the driver's license to an instrument used to effectuate and veil organized theft and extortion. The thieves then conspire to systematically serve you, the alleged violator, with new tickets/suits/bills of exchange/summons, to appear or pay, or both. The colluders often threaten to, again, suspend the state's license and may also impose possible jail time. All of these administrative acts are unlawful. As an example, what is a surcharge? A surcharge is a bill that has been filed to open a claim, an exaction, an impost, or an encumbrance, beyond that which is just and right, or beyond one's authority or power. If a surcharge is beyond what is just or right, and is done without authority, doesn't such an act constitute racketeering and other criminal actions of fraud? One must always question jurisdiction and consider, by way of constitutional principles, who created these surcharge bills, and who opened these files. Furthermore, where was or is your copy of the bill? According to the rule of discovery, you are lawfully supposed to also have been presented with an original copy of the same. If a copy of the document/instrument, bill, cannot be produced by the prosecutors/accusers/claimants, with your signature, then such a bill is a fraud, unlawful, and unactionable. Thus, such acts are a nullity. A nullity or nollie is a term in law, which essentially regards and refers to an unlawful administrative court officer's decision or action as being nothing in law or void of law. Nullies are often attached to unconstitutional decisions made by officials acting under colorable processes. As an aside, in addition to these facts, such agencies cannot make judicial decisions, they do not possess the authority. Such powerful Article 3 jurisdictional authority is not in their capacity, and such unsanctioned courts and judges cannot violate the laws of the Constitution, by which they are bound to support and uphold by official oaths. See Article 6 of the Constitution and Oath of Ethics. Administrative judges or ministerial officers, traffic court judges, do not have, or possess, the authoritative or lawful power at all to make judicial decisions. They are ministerial in status and character. Thus, they are incompetent, and are knowingly violating the established law of the land. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. Burns v. Sup. CT. SF. 140 calories 1. A judge ceases to sit as a judicial officer because the governing principle of administrative law provides that courts are prohibited from substituting their evidence, testimony, record, arguments, and rationale for that of the agency. Additionally, courts are prohibited from substituting their judgment for that of the agency. Courts in administrative issues are prohibited from even listening to or hearing arguments, presentation, or rationale. ASIS v. US. 568 F2D 284. The state is prohibited from violating substantive rights. Owens v. City, 445 U.S. 662, 1980, and it cannot do by one power, e.g. police power, that which is, for example, prohibited expressly to any other such power, e.g. taxation/eminent domain, as a matter of law. U.S. and UTV Daniels, 22 p. 159, nor indirectly that which is prohibited to it directly. Fairbanks v. U.S. 181, U.S. 283, 294, 300. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation, which would abrogate them. Miranda v. Arizona 384 U.S. 436, 125. State courts, like federal courts, have a constitutional obligation to safeguard personal liberties and to uphold federal law. Stone v. Powell 428 U.S. 465, 96 SCT 3037, 49 L. ed. 2d 1067. The obligation of state courts to give full effect to federal law is the same as that of federal courts. New York v. Eno 155 U.S. 89, 15 SCT 30, 39 L. ed. 80. An administrative agency may not finally decide the limits of its statutory powers. This is a judicial function. Social Security Board v. Nyarotko 327 U.S. 358, 66 SCT 637, 162 ALR 1445, 90 L. ed. 719. Lex semper dabit remedium equals the law will always give a remedy. The reader is, at this juncture of this treatise, presented with the responsibility to use reason and to make clear distinctions between that foul, colorable body of fraud-based legislation and policies, which are not law, and that of the rightful supreme law of the land, constitution and treaties. Another example of fraud is that the perpetrators of the surcharge division may say that you owe them finance. Do you have a contract with them? Did they loan you anything? There exists no lawful, willful instrument, bearing your signature to such a contract law-violating agreement. If you, the accused, ever ask the agent, S/representative, S/accuser, S, to provide such required contractual or documented evidence, they will not, they do not, and they cannot. They are criminals, and are loath to produce self-incriminating evidence against their own self-incorruption and proof of their perjury of oaths. If the case or action, initiated by them, is based upon those instruments, then they must, by due process of law, provide it or them. Otherwise, there is no lawful claim or case before the court. Even if you, the accused, did allegedly owe them, or anyone else, finance, their acts of notifying other private law systems, or making contracts with other agencies, and signing on your behalf, to collect such alleged debts, is tantamount to extortion and identity theft. When they, through their agency, contractors, or agencies, notifies local, regional, and state, court systems and court officers, speaking for them, to take an action against you for failure to pay them, then they are committing conspiratorial extortion. All parties involved are then acting as a collection agency. This includes the police officer, S, or policy enforcer, S, who stopped you in the first place or instance. The initiating agent, policeman, is acting in the capacity of a collection agent for the private corporate businesses, insurance companies, etc. Thus, the policeman is an active partner or part of the conspiracy. According to the codes of law for the United States of North America, all officers and officials are responsible for any acts committed under color whether he or she knows it or not, and whether he or she is doing what he or she is told by superiors or others, to do or to initiate an unwarranted or colorable act. An example of conspiracy, corruption, and perjury of oath becomes obvious when one reads the following Law Enforcement Code of Ethics, which all law officers must take. PLESOAth2.jpg. After reading the Oath of Ethics, let us examine another area of fraud. The State Motor Vehicle Agency, DMV, repeatedly and unlawfully acts in the above stated capacity as well. Their officers, contractors, and employees often, and regularly, receive notices from the other surcharge divisions to adjudicate actions geared to suspend the state's license instrument for failure to pay them their prescribed amount of extortion payments, whereas they have, by color, converted the constitutional and treaty-secured rights of the natural people into crimes, in order to raise revenues. The DMV then arbitrarily suspends your rights converting license, which is conspiratorial extortion. This promotes threats of arrest, incarceration, and the like. This is especially evident because the DMV also charges you a ransom fee to reinstate the fraud-based license, which they, themselves, have imposed upon the natural people. The Constitution principles and obligations, which bind all judges, legislators, representatives, and other judicial officers of the courts, superior and inferior, do not change or alter their obligations. The surcharge division is sanctioned by the courts to act on their behalf. The judge even knows all about them and how they work, which proves collusion because he is not supposed to uphold them. They are the ones who supposedly have a claim against you. His actions and degree of knowledge involving this company proves conflict of interest as well, and most important, they, the accuser against you, the surcharge or DMV agency, is not even in the courtroom to substantiate their claim against you. This is unlawful. The mailing locations, the accused, you, are given the alleged address of the surcharge division as the recipient of fees and imposts that you must pay. Then the Department of Motor Vehicles commands and threatens you to send finances or fees to them, which is another party, with a different address. Conspiratorial extortion. We haven't added the courts and the court fees, etc., they are in on the extortion as well, pretending that they are executing law. Ignorance of the law is no excuse, and in this case the one who suffers from that knowledge is you. This is why we are sharing this information to assist, and to enforce the constitutional principles that protect the people, as in enforcing it, no one will be molested, and their rights will not be turned into a crime. Note, turning rights into a crime is a big money maker for them, and let's face it, for some of our own, because as long as we continue to sell the birthright by selling it on paper, we are committing a crime, slave trade. Keep in mind that the word fee is relative to feudal law, and feudal law is the opposite of allodial. Such an act is repulsive to constitutional principles. The surcharge division or agency is different and separate from the Department of Motor Vehicles, proving conspiracy to extort and will and intent. The state of New Jersey is an artificial person or entity, as is any corporate state, created on paper by legal process, and should always be referred to as such. Note, the state of New Jersey, Incorporated, changed the name of their motor vehicle agency from New Jersey Division of Motor Vehicles, DMV, to New Jersey Motor Vehicle Commission, MVC, not to be confused with MVS, which is their surcharge division. In the state of New York, the surcharge agency is referred to, or called, the Ticket Violations Bureau. So what is conspiracy? Conspiracy is a combination or an agreement made or initiated between two or more persons, for accomplishing an unlawful end or a lawful end by way of unlawful means. The essence of conspiracy is an agreement, together with an overt act, to do an unlawful act, or to do a lawful act in an unlawful manner. Actors may drop out, and others may drop in, the details may change from time to time, and the members need not know each other or the part played by others. A member need not know all the details of the plan or the operations. He must, however, know the purpose of the conspiracy and agree to become a party to a plan to effectuate that purpose. Further, conspiracy is a consultation or agreement between two or more persons either falsely to accuse another of a crime punishable by law, or wrongfully to injure or prejudice a third person or any body of men, in any manner, or to commit any offense punishable by law, or to do any act with intent to prevent the course of justice, or to effect a legal purpose with a corrupt intent, or by improper means. Another example of the practiced fraud is when the officers or agents initiate and or go into the publicly funded courtrooms, using the courts to enforce color of law. They will insistently start telling you, the accused, how much you are going to pay them for the so-called listed infractions and violations. They, the judges, prosecutors, and other court officers, try to roll right over you, while, in the same instance, violating the due process restrictions placed upon them by law. You, the accused, must be aware that they, the judges, prosecutors, policemen, etc., are knowingly ignoring, violating, and trampling over established due process obligations in stare decisis, secured for the natural people and citizens, by law. See Amendments 4, v. 6, 7, 8, 9, and X, etc. Don't let their corruption go on unchallenged or unrebutted. Do not be afraid of the alleged trial, as the transcripts, containing your proper questioning and statements, at the pseudo-trial would expose them and their criminality to others and to the Supreme Court, original jurisdiction. Transcripts and documented records related to the process will, in future examinations, expose your lawful position, versus their unlawful practices. These facts have been, and are, usually suppressed by them, the officers of the fraud-based courts. They do not want that information exposed to the public or to a higher court, by way of mandamus. If you, the accused, think you are going to a legitimate trial, as the conspiring officers have implied, and threatened you with, then consider this: pre-produce 12 copies of the documents and records for the alleged jury of your own national peers. Demand that you preserve your rights to participate in the selection of the jury, with your Moorish consul present, ministers/grand sheikhs, etc. They have the authoritative right to be a part of the due process rights preserved for them to select, screen, question, and critique the alleged jury of your peers. One clear and pertinent question already looms over the process: who are the people that the officers of the court are alleging to be your peers? Are they truly Aboriginal Americans, or are these persons actually colonial impostors and foreigners posing, fraudulently, as Americans, Al-Moroccans? The plot begins to thicken, doesn't it? Review the laws of evidence as expressed in the legal definition of identity. Furthermore, and in the interest of universal justice, it is important for all Moorish Americans to know, factually, that traffic courts are administrative courts. These private corporate courts cannot lawfully have or initiate a trial, exercising judicial powers. They are essentially kangaroo courts. It is also important to know that you, the accused, already have and possess rights to travel the public roadways and highways of the land. If the natural people were to all collectively exercise these rights, we wouldn't be easily subjected to these unlawful processes. There is more information in stare decisis law presented on this subject. Upon further research, you will find many Supreme Court rulings preserving the substantive rights of the people. In regards to not utilizing the fraud-based driving instruments imposed upon the people, the information contained herein must be understood by the people collectively in order for them to lawfully exercise rights already belonging to them. Keep in mind, those of you who currently have those imposed instruments of converted rights, that just because you do have them in your possession, doesn't mean or establish that you have knowingly or willingly given up or waived any of your unalienable rights. Always sign any instruments placed before you by agencies, or any officers of the corporate state of New Jersey, or any other states, with all rights reserved. See how to live within contracts on the Open Readings page. Another dirty trick, initiated by corporate thieves in seats of municipal governments, is when they ask you, do you waive your right to counsel? Do not fall for this deception. You may possibly assume that you are denying their court-appointed attorney, when in reality, if you agree to waive your right to counsel, you have done just that, waived your right. This is why they will not let any other person be your counsel when you present yourself in propria persona. Do not transfer or waive any rights, or give leave to any colorable persons or entities present or not present in the administrative court. This deceptive offer is designed to gain jurisdictional authority by oral agreement. It is a jurisdictional contract offer, given under coercion and imposed duress. Never waive your right to counsel, rightfully, counsel, and in fact, state for the record your name and nationality, and state that you do not, did not, and do not intend to ever waive any of your secured rights to due process. The valid venue of proper jurisdiction must be secured by the officers of the court, upon your demand. As per the Constitution, you have a pre-existing right to counsel. Do not allow the judge or prosecutor, both being officers of the Barristers Association, solicit from the bench, sales, and offers from that conflict of interest, private club. Do not allow these colored persons decide who will be your consul/counsel. They are already operating in a verifiable state of conflict of interest. Do not let or trust them to tell you the truth about their obligations, or to inform you that you have to have someone who is, allegedly, licensed to practice law. The Congress does not, and the Constitution does not, license lawyers, because there is no such thing as a license to practice law. The law, Constitution, is common to every free national being. There is no political or religious test or requirement to have a license in order to exercise, enjoy, or to command the enforcement of the law, Constitution, Bill of Rights and treaties. Do not believe me, ask these administrative accusers to show you documented proof by exhibit, their license to practice law. They, in turn, will not, they cannot, and they do not, because such instruments do not exist. And this is the fact. They, the attorneys or other officers of the court, may show you, under the rule of discovery, a bar association membership card, which they also are loath to do. However, that instrument is not a license, and is far from an alleged license. Such instruments are private club member, dues-paying, agreements, which have nothing to do with constitutional obligations, Articles 3 and 6, and are merely membership cards issued by private corporate interests, and officers of the Barristers Association, a private and exclusive club. The responsibilities to be active and to study do not end at this juncture. Peace. About dismissal affidavits. The following affidavits/writs are for ticket dismissals and present law, supports for dismissal. The natural person is advised to submit the affidavits/writs to the prosecutor and other court officers prior to the court date. In fact, most of the time, send your writs in by certified mail within 3 days after you receive the municipality's instruments. With proper correspondence, you will, sometimes, receive a favorable reply, and won't have to come into the non-Article 3 courtroom. If you are in a situation wherein you bring writs with you, be sure to serve a copy to the clerk for filing with the case. Some clerks may try to tell you that they cannot receive your writs, however, it is a violation of the clerk's fiduciary duties to deny the writs of evidence related to the case. Be sure to have the ticket/summons/suit number, S, listed at the top of your writs/affidavits, listing them and all other documented entries with numbers, such as Exhibit 1, Exhibit 2, Exhibit 3, etc., etc. Remember, your exhibits/writs/affidavits are instruments of facts, and when marked as exhibits it makes them a part of the case, and the officers of the court are obliged to receive them, otherwise they are tampering with evidence. The reason they don't want to receive it, is because they are in fact obligated, and they would be responsible, and would be compelled by law to respond. If you don't submit it, you would be irresponsible. It is important to submit paperwork, as it becomes your exhibits, and is your paper trail, whether they accept, or act on it or not. The paper trail is necessary, copying it to at least 3 different persons/corporations/agencies. In particular, the clerk, the judge of the said city/municipality/township, and a copy to the State Attorney General's office, as well as the State Secretary, as a minimum of 3, and the Governor's office, particularly when dealing with so-named higher courts such as federal. This notifies other departments and makes it difficult for all of them to ignore their fiduciary duties, and it sets up your paper trail for when you suit them, otherwise you have no proof of their violations, or of your actions. If you put them on file at the court, make sure they stamp your copy received with a date. 1 Willie Lynch test. 1 ticket dismissal. 1 grin ball. 2 Supreme Court cases, traffic and ministerial officers. https://u2.b/uuehacksjays. From the records of RV publications notes of the sojourn. Reason for treason. The following is a part to information submitted to a court, the clerk, and the judge/magistrate. Because of their denial of the law and acting as those statutes from their respective states. Constitution can be used to abrogate the supreme law of the land. This cannot be done pursuant to Article 6 of the Constitution for the United States of America, which was established and authorized by the people of the United States. Two different entities. It is important that you recognize that they are committing treason. In order to charge them with treason, there must be a minimum of 2 witnesses, however we suggest at least 3, triune principle in accord with nature. This information is certainly what you ought know, what you do with it, is another issue and is up to you. The fact that the people have not known this, or have not enforced it, as law, holds a great deal of, if not all of, the problem for the people. As for the officers of the court, and federal employees, and private policy enforcers, feigning as law enforcer, this is evidence that they are out of order, are violators of the law and are tortfeasors, which means wrongdoers, as well, they are warring against the people, which is treason. Treason is an international crime. Underscore 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 un. As a matter of fiduciary duty, judge/magistrate, judge/magistrate name, and any and all officers of the court, are obligated to protect the rights of the citizens. In fact, the only reason government is in place is to protect the rights of the citizens, and for no other reason. To utilize the court for anything other than that, is, in fact, treason. When a judge acts where he or she does not have jurisdiction to act, the judge is engaged in an act or acts of treason. U.S. v. Will, 449 U.S. 200,216, 101 SCT, 471, 66 LED 2 392, 406, 1980. Cohens v. Virginia, 19 U.S., 6 Wheat, 264, 404, 5 LED 257, 1821. No state legislator or executive or judicial officer can war against the Constitution without violating his undertaking to support it. Cooper v. Aaron, 358 U.S. 1, 78 S.CT 1401, 1958. Therefore, all requests made to this court are within the bounds of law, and supports the fundamental purpose of any and all government entities and their obligations to the citizens. The averment defines such bounds for this court. If the state of whatever state, which includes the whatever municipal court, have established, within their private capacity, or in consort with some other association, establishment, agency, subcharter, or chapter, etc., some additional rules, regulations, statutes, and ordinances, they must act within the law, and cannot abrogate the supreme law of the land, and must follow the defines of Article 6, and they must acknowledge any and all supportive Supreme Court stare decisis, which in fact, and in law, applies to them. An unconstitutional act is not law, it confers no rights, it imposes no duties, affords no protection, it creates no office, it is in legal contemplation, as inoperative as though it had never been passed. Norton v. Shelby County, 118 U.S. 425. Courtesy of rvbaypublications.com, sharing information. Page 1 of 1. Proclaiming is the publishing, and that is where the paperwork comes in. Anything in written form is but a brief expressing your position regarding a matter, whatever that matter may be, and that includes the card itself, which is a brief and lawful claim. Greetings of peace. Thank you for your interest and activity. However, the universe thanks you more. Nationality is not really a process except for if and when it starts in the mind, as you now already know, if you didn't before. It has apparently awakened in you, thus declaring it is to be clear yourself and does not necessarily require any paperwork, but does require study to be clear yourself, as you can only be what you know. Proclaiming is the publishing, and that is where the paperwork comes in. Anything in written form is but a brief expressing your position regarding a matter, whatever that matter may be, and that includes the card itself, which is a brief and lawful claim.
目覚めさせたよ。
Are you confused or unsure? That is why the international community put out the Declaration of Human Rights, the Declaration of the Rights of the Child and the Declaration of the Rights of Indigenous People, all to be disseminated in public schools, public institutions, etc. Yet of course that was not done, as these humane principles would go against the untoward intent of those who are feigning as if they have a lawful delegation and authority over the people and who want to continue slavery in a bureaucratic, paperwork, fiction manner. Even unto the Constitution there exist rules of laws that they break on a consistent basis. Yet, it is a responsibility of the people to know what law is and what law is not, and who is who in government. In so much as you need to know what government really is, and who governs you, as you are government, governing your mental, thus you are the one who governs and you must be civilized yourself, and with that you must have knowledge of civilization principles. In the Declaration of Human Rights, Article number 15 it states: A. Everyone has a right to a name and a nationality. B. Everyone has a right to change it. This is for adults, regardless to what their parents may have done in ignorance previously, which is why it states you have the right to change your nationality, although there exists no nationality with the birth certificate that your parents seem to have vested you in, and Negro, colored, black, etc., are not nationalities. The birth certificate was established with intentional deceit and fraud. Thus one can presently declare their nationality and exercise their rights of birth. There is much resistance because finances are made off of corporate property, and that is the false report that is given when a birth certificate is issued. Example, if you are identified as a corporation, by that certificate that you claim is you, but it is not and never was. Then you pay income taxes because the paycheck is considered income, when really it is wages. However, if you say it is income, then you are saying it is profit from a corporate investment, so then you are taxed as if you are the corporate investment. So, stop calling it income. Stop acting as if you are a corporation, a corporate person, and your wages will no longer be considered a corporate investment, and the excess after listing all you spent to maintain will no longer be considered the profit, that is taxed and shared with the respective corporate state of. See about taxes page. In the Declaration of the Rights of the Child, Principle 3 it states, "Every child has a right to a name and a nationality." This is for parents who wish to initiate such right from the onset of birth, ab initio. In the rights of indigenous people, those who were here before the modern European colonist, and before the forming of the corporate United States of America, who are really the Aboriginal and indigenous people. If you are Aboriginal, you are indigenous, but being indigenous does not necessarily mean you are Aboriginal. Moors are Aboriginal to all of the four corners of this earth. In Article 6, it states, "Every indigenous individual has the right to a nationality." Rights of indigenous people. Article 37. 1. Indigenous peoples have the right to the recognition, observance, and enforcement of treaties, agreements and other constructive arrangements concluded with states or their successors, and to have states honor and respect such treaties, agreements, and other constructive arrangements. Note, you are not indigenous because you are a part of a club or not, or of a private society, association, institution, etc. No man can change the descent nature of another. Aboriginal and indigenous is a status refinement, not a nationality. Those who are Aboriginal are first, as a means to come down from, to be first, from the beginning, as in Ib. Intio, from initial. As a divine spirit manifest in the flesh, you are Ib, coming down from the spirit manifested in the flesh as the Aboriginal to the land, the original man, as is supported in Genesis 1, manifested on the sixth day of creation. Not necessarily Genesis 2, which speaks of Adam and the descendants of Adam. Everyone now knows, Adam was not the first and only being, as others were here, when Cain fled into the land of Nod, after slaying Abel. The use of common sense and reasonable analysis is what is meant by "if I could just get you to thinking, you would free yourself." The sixth day of creation is Friday. Check the 101 teachings, wherein your manifestation into the flesh is a holy, and holistic, occurrence, thus properly symbolized as Friday, day named after heavenly body Venus, feminine, creating, energy, also known as Mot, Libra, Astarte, and many other feminine attributes. Thus Friday, Viernes, is the day man was formed in the flesh, mother's womb, and Friday is the day man departed from the flesh, from mother's womb. The question of where you came from is answered. The reason Friday is a holy day is also answered, and the reason this is divine and national activity is answered as well. Moors are the first navigators, mooring upon the waters and the land. This is why no matter where you go, or say, or think, you come from, you will find copper-colored, dark-skinned, and the further you go back, even darker, heavily melanated ancestors, Aboriginal people across the four corners of this earth, Asia. This fact is also supported in the Intercatera Divina Papal by Pope Alexander VI, as to how they found dark melanated people, during their 1,400 crusades. Translating to approximately 800 in Moorish/Islamic calendar. They set their sights on conquering the people by way of forcing their version of Christianity upon them at the penalty of killing them, because their God said it was right to do so in the name of Christianity if they do not convert to their version of religion, that they call Christianity unto today, which is pretty warped to think that someone would murder someone else for not converting to their version of religion. They got their version of Christianity from Christ, which is the crystal clear, pure, and cleansing rays of the sun, of which they endeavor to endure without being burnt even unto today, and that causes skin disease, melanoma, leprosy, of old terminology, otherwise known as cretins, those with skin disease. From Cretan came Christians and their version of Christianity. Read the beginning of Christianity chapter 46 of the Circle 7 Holy Quran, and learn why you must give back their religion and accept the old-time religion, as religion means to bind back, to re-allegiance yourself. It is nothing scary, nor is it anything to shun or throw out the baby with the bath water. These are documented facts and not opinions. However, they did not discover the land or the people, as they were already here. Let it be known that one who is Aboriginal is indigenous, however one who is indigenous is not necessarily Aboriginal. They may be born upon the land, thus native to it, but are not the Aboriginal natives. Moors are the Aboriginals, the indigenous, the natives and lineal descendants of the ancient ones. Thus, must go back to the mindset of their ancient foremothers and fathers, before modern European colonization. For those who think that is some outdated concept, then at least go back to knowing that your predecessors are the ancient foremothers and fathers of civilization and civilization principles. When you couple that with honoring your mothers and fathers, somehow, I trust that paints a different story and in fact changes your mindset. Some will succumb to anger, become emotional and upset that they have been lied to, but be not too hasty, always remain in an intelligent tone and know that the truth being told is what ensures it all goes back in the hands of Moors, first navigators. Thus it is imperative to get your mindset straight. Don't bring the hate, we must learn to love instead of hate, as love is the first principle, which brings truth to light. Truth brings peace to bear freedom from lies, encumbrances, and mental chains, and with freedom justice is done. In synopsis of above references to rights of indigenous people and as evidenced support from the international community as Moor and issues regarding Moors are in fact international, some primal supports for correcting concepts are: Article number 15 of the Declaration of Human Rights is for adults or self-governing beings who wish to correct their status by declaring and proclaiming their nationality. Principle number 3 of the Declaration of the Rights of a Child are for adults who have children, in which they wish to initiate claim of status from birth, ab initio. Article number 6 of the Declaration of the Rights of Indigenous People is for all of us as a collective. Article number 37 of the Declaration of Rights of Indigenous People are for any and all writs, constructive arrangements, notices, etc., that may be established. Below is a PDF of the preamble, purpose, and part I, consisting of 5 articles, of the Rights of Indigenous People for your review and study. Horizontal divider 12. Ball and middle spinning. Preamble and part I of Rights of Indigenous People. A. Willful or repeated violation. Any employer who willfully or repeatedly violates the requirements of Section 654 of this title, any standard, rule, or order promulgated pursuant to Section 655 of this title, or regulations prescribed pursuant to this chapter may be assessed a civil penalty of not more than $70,000 for each violation, but not less than $5,000 for each willful violation. B. Citation for serious violation. Any employer who has received a citation for a serious violation of the requirements of Section 654 of this title, of any standard, rule, or order promulgated pursuant to Section 655 of this title, or of any regulations prescribed pursuant to this chapter, shall be assessed a civil penalty of up to $7,000 for each such violation. C. Citation for violation determined not serious. Any employer who has received a citation for a violation of the requirements of Section 654 of this title, of any standard, rule, or order promulgated pursuant to Section 655 of this title, or of regulations prescribed pursuant to this chapter, and such violation is specifically determined not to be of a serious nature, may be assessed a civil penalty of up to $7,000 for each such violation. D. Failure to correct violation. Any employer who fails to correct a violation for which a citation has been issued under Section 658A of this title within the period permitted for its correction, which period shall not begin to run until the date of the final order of the Commission in the case of any review proceeding under Section 659 of this title initiated by the employer in good faith and not solely for delay or avoidance of penalties, may be assessed a civil penalty of not more than $7,000 for each day during which such failure or violation continues. E. Willful violation causing death to employee. Any employer who willfully violates any standard, rule, or order promulgated pursuant to Section 655 of this title, or of any regulations prescribed pursuant to this chapter, and that violation caused death to any employee, shall, upon conviction, be punished by a fine of not more than $10,000 or by imprisonment for not more than 6 months, or by both, except that if the conviction is for a violation committed after a first conviction of such person, punishment shall be by a fine of not more than $20,000 or by imprisonment for not more than 1 year, or by both. F. Giving advance notice of inspection. Any person who gives advance notice of any inspection to be conducted under this chapter, without authority from the Secretary or his designees, shall, upon conviction, be punished by a fine of not more than $1,000 or by imprisonment for not more than 6 months, or by both. G. False statements, representations, or certification. Whoever knowingly makes any false statement, representation, or certification in any application, record, report, plan, or other document filed or required to be maintained pursuant to this chapter shall, upon conviction, be punished by a fine of not more than $10,000, or by imprisonment for not more than 6 months, or by both. H. Omitted. I. Violation of posting requirements. Any employer who violates any of the posting requirements, as prescribed under the provisions of this chapter, shall be assessed a civil penalty of up to $7,000 for each violation. J. Authority of Commission to assess civil penalties. The Commission shall have authority to assess all civil penalties provided in this section, giving due consideration to the appropriateness of the penalty with respect to the size of the business of the employer being charged, the gravity of the violation, the good faith of the employer, and the history of previous violations. K. Determination of serious violation. For purposes of this section, a serious violation shall be deemed to exist in a place of employment if there is a substantial probability that death or serious physical harm could result from a condition which exists, or from one or more practices, means, methods, operations, or processes which have been adopted or are in 29 U.S. Code 666. Civil and criminal penalties. 42 U.S. Code 666. Requirement of statutorily prescribed procedures to improve effectiveness of child support enforcement. Requiring the use of the following procedures, consistent with this section and with regulations of the Secretary, to increase the effectiveness of the program which the state administers under this part. 1. A. Procedures described in subsection B. For the withholding from income of amounts payable as support in cases subject to enforcement under the state plan. B. Procedures under which the income of a person with a support obligation imposed by a support order issued, or modified, in the state before January 1, 1994, if not otherwise subject to withholding under subsection B, shall become subject to withholding as provided in subsection B, if arrearages occur, without the need for a judicial or administrative hearing. 2. Expedited administrative and judicial procedures, including the procedures specified in subsection C, for establishing paternity and for establishing, modifying, and enforcing support obligations. The Secretary may waive the provisions of this paragraph with respect to one or more political subdivisions within the state on the basis of the effectiveness and timeliness of support order issuance and enforcement or paternity establishment within the political subdivision, in accordance with the general rule for exemptions under subsection D. 3. Procedures under which the State Child Support Enforcement Agency shall request, and the state shall provide, that for the purpose of enforcing a support order under any state plan approved under this part. A. Any refund of state income tax which would otherwise be payable to a non-custodial parent will be reduced, after notice has been sent to that non-custodial parent of the proposed reduction and the procedures to be followed to contest it, and after full compliance with all procedural due process requirements of the state, by the amount of any overdue support owed by such non-custodial parent. B. The amount by which such refund is reduced shall be distributed in accordance with Section 657 of this title in the case of overdue support assigned to a state pursuant to Section 608, A. 3, or 671, A. 17, of this title, or, in any other case, shall be distributed, after deduction of any fees imposed by the state to cover the costs of collection, to the child or parent to whom such support is owed, and C. Notice of the non-custodial parent's Social Security account number, or numbers, if he has more than one such number, and home address shall be furnished to the state agency requesting the refund offset, and to the state agency enforcing the order. 4. Liens procedures under which A. Liens arise by operation of law against real and personal property for amounts of overdue support owed by a non-custodial parent who resides or owns property in the state, and B. The state accords full faith and credit to liens described in subparagraph A, arising in another state, when the state agency, party, or other entity seeking to enforce such a lien complies with the procedural rules relating to recording or serving liens that arise within the state, except that such rules may not require judicial notice or hearing prior to the enforcement of such a lien. 5. Procedures concerning paternity establishment. A. Establishment process available from birth until age 18. I. Procedures which permit the establishment of the paternity of a child at any time before the child attains 18 years of age. 2. As of August 16, 1984, Clause I. Shall also apply to a child for whom paternity has not been established or for whom a paternity action was brought but dismissed because a statute of limitations of less than 18 years was then in effect in the state. B. Procedures concerning genetic testing. I. Genetic testing required in certain contested cases. Procedures under which the state is required, in a contested paternity case, unless otherwise barred by state law, to require the child and all other parties, other than individuals found under Section 654(29) of this title to have good cause and other exceptions for refusing to cooperate, to submit to genetic tests upon the U.S. Supreme Court. Scott v. Sandford, 60 U.S. 19 How. 393 393, 1856. Scott v. Sandford. 60 U.S., 19 How. 393. Syllabus I.1. Upon a writ of error to a Circuit Court of the United States, the transcript of the record of all the proceedings in the case is brought before the court, and is open to inspection and revision. 2. When a plea to the jurisdiction, in abatement, is overruled by the court upon demurrer, and the defendant pleads in bar, and upon these pleas the final judgment of the court is in his favor. If the plaintiff brings a writ of error, the judgment of the court upon the plea in abatement is before this court, although it was in favor of the plaintiff, and if the court erred in overruling it, the judgment must be reversed, and a mandate issued to the Circuit Court to dismiss the case for want of jurisdiction. 3. In the Circuit Courts of the United States, the record must show that the case is one in which, by the Constitution and laws of the United States, the court had jurisdiction, and if this does not appear, and the judgment must be reversed by this court, and the parties cannot be consent waive the objection to the jurisdiction of the Circuit Court. 4. A free Negro of the African race, whose ancestors were brought to this country and sold as slaves, is not a citizen within the meaning of the Constitution of the United States. 5. When the Constitution was adopted, they were not regarded in any of the states as members of the community which constituted the state, and were not numbered among its people or citizens. Consequently, the special rights and immunities guaranteed to citizens do not apply to them. And not being citizens within the meaning of the Constitution, they are not entitled to sue in that character in a court of the United States, and the Circuit Court has not jurisdiction in such a suit. 6. The only two clauses in the Constitution which point to this race treat them as persons whom it was morally lawfully to deal in as articles of property and to hold as slaves. 7. Since the adoption of the Constitution of the United States, no state can by any subsequent law make a foreigner or any other description of persons citizens of. Page 60 U.S. 394. The United States, nor entitle them to the rights and privileges secured to citizens by that instrument. 8. A state, by its laws passed since the adoption of the Constitution, may put a foreigner or any other description of persons upon a footing with its own citizens as to all the rights and privileges enjoyed by them within its dominion and by its laws. But that will not make him a citizen of the United States, nor entitle him to sue in its courts, nor to any of the privileges and immunities of a citizen in another state. 9. The change in public opinion and feeling in relation to the African race which has taken place since the adoption of the Constitution cannot change its construction and meaning, and it must be construed and administered now according to its true meaning and intention when it was formed and adopted. 10. The plaintiff having admitted, by his demurrer to the plea in abatement, that his ancestors were imported from Africa and sold as slaves, he is not a citizen of the state of Missouri according to the Constitution of the United States, and was not entitled to sue in that character in the Circuit Court. 11. This being the case, the judgment of the court below in favor of the plaintiff on the plea in abatement was erroneous. 2. 1. But if the plea in abatement is not brought up by this writ of error, the objection to the citizenship of the plaintiff is still apparent on the record, as he himself, in making out his case, states that he is of African descent, was born a slave, and claims that he and his family became entitled to freedom by being taken by their owner to reside in a territory where slavery is prohibited by Act of Congress, and that, in addition to this claim, he himself became entitled to freedom by being taken to Rock Island, in the state of Illinois. Dred Scott v. Sandford, 60 U.S. 393, 1856. https://supreme.justicia.com/cases/federal/us/60/393/. Page 60 U.S. 399. Said Dred Scott and Eliza and Lizzie, the daughters of the said Dred Scott, were Negro slaves, the lawful property of the defendant. Whereupon, the court gave judgment for the defendant. After an ineffectual motion for a new trial, the plaintiff filed the following bill of exceptions. On the trial of this cause by the jury, the plaintiff, to maintain the issues on his part, read to the jury the following agreed statement of facts, see agreement above. No further testimony was given to the jury by either party. Thereupon the plaintiff moved the court to give to the jury the following instruction, viz. that, upon the facts agreed to by the parties, they ought to find for the plaintiff. The court refused to give such instruction to the jury, and the plaintiff, to such refusal, then and there duly accepted. The court then gave the following instruction to the jury, on motion of the defendant. The jury are instructed, that upon the facts in this case, the law is with the defendant. The plaintiff accepted to this instruction. Upon these exceptions, the case came up to this court. Mr. Chief Justice Taney delivered the opinion of the court. This case has been twice argued. After the argument at the last term, differences of opinion were found to exist among the members of the court, and as the questions in controversy are of the highest importance, and the court was at that time much pressed by the ordinary business of the term, it was deemed advisable to continue the case and direct a re-argument on some of the points in order that we might have an opportunity of giving to the whole subject a more deliberate. Page 60 US 400. Consideration. It has accordingly been again argued by counsel, and considered by the court, and I now proceed to deliver its opinion. There are two leading questions presented by the record. One, had the Circuit Court of the United States jurisdiction to hear and determine the case between these parties? And 2, if it had jurisdiction, is the judgment it has given erroneous or not? The plaintiff in error, who was also the plaintiff in the court below, was, with his wife and children, held as slaves by the defendant in the state of Missouri, and he brought this action in the Circuit Court of the United States for that district to assert the title of himself and his family to freedom. The declaration is in the form usually adopted in that state to try questions of this description, and contains the averment necessary to give the court jurisdiction, that he and the defendant are citizens of different states, that is, that he is a citizen of Missouri, and the defendant a citizen of New York. The defendant pleaded in abatement to the jurisdiction of the court, that the plaintiff was not a citizen of the state of Missouri, as alleged in his declaration, being a Negro of African descent, whose ancestors were of pure African blood and who were brought into this country and sold as slaves. To this plea the plaintiff demurred, and the defendant joined in demurrer. The court overruled the plea, and gave judgment that the defendant should answer over. And he thereupon put in sundry pleas in bar, upon which issues were joined, and at the trial the verdict and judgment were in his favor. Whereupon the plaintiff brought this writ of error. Before we speak of the pleas in bar, it will be proper to dispose of the questions which have arisen on the plea in abatement. That plea denies the right of the plaintiff to sue in a court of the United States, for the reasons therein stated. If the question raised by it is legally before us, and the court should be of opinion that the facts stated in it disqualify the plaintiff from becoming a citizen, in the sense in which that word is used in the Constitution of the United States, then the judgment of the Circuit Court is erroneous, and must be reversed. It is suggested, however, that this plea is not before us, and that, as the judgment in the court below on this plea was in favor of https://supreme.justicia.com/cases/federal/us/60/393/ Confusion brings attention. There is nothing new under the Sunday. All matters regarding the liberties of the people have already been scribed. All rules of engagement are already scribed. All we need to do is enforce it. That is what the prophet brought, and that is what he said. Any new laws made within the temple was for the members, for the purpose of guiding and preparing members to ultimately take their place amongst the affairs of man when they go out into the world and link themselves back to the family of nations. We need to try that on for a few generations at least, which is what getting it into the youth is all about. Consular courts are not a government. On our recent broadcast regarding consular court, we gave the definition and purpose of consular court directly from the congressional records and explained the repeal in 1956 and why. We remained neutral to the subject and did not give any specific components or concepts to the now various risings of consular courts. Do not be a blind follower. This topic is a perfect example of why we must study. Below is the direct link to our Tuesday, May 22, 18. MHHS National Principles in Action broadcast. We will be posting the PDFs from the congressional records for edification shortly hereafter. http://www.blog.com/mhhs-eyes-wide-open/2018/0-5/230/principles-in-action. The buzz about Moor's consulate court. We have been receiving inquiries as to a consular court having a signing this month. If you have had the experience of asking several different people and getting a different answer as to the purpose of it, you will have to wait until that event to know what they are presenting for the people. What we do know about consular courts is that they were originally established for foreigners to enforce treaties across the land. As for the Moroccan/American land, upon the establishing and enforcing of the Moroccan/American National Constitution, the supreme law of the land for the United States of America, corporation or corporate citizens, wherein within the Constitution all treaties are included to be enforced, Article 6. An admiralty law is also included, Article 3. Consular courts were established for foreigners until the Constitution and judiciary venues were set up in harmony with the law of the land and solidly taught and enforced. This is why they were repealed. Foreigners could claim their citizenship to the USA, natural people could not, cannot, and ought not, as they, USA, its founders are not your ancestors and you are not members/citizens of the USA Corporation, even though it operates on or upon the Moroccan/American soil. Thus, Article 12 of the original 13th Amendment states that descendants of Africans cannot be citizens of USA. Many may think this is some kind of bias due to lack of study and knowledge of the law and history. I trust now you will understand that it is not. As well, the Prophet said to enforce the Constitution so you are not molested by other citizens. If we spent time doing that, we would not have time to slander each other, nor would we keep looking for European processes. First, of course, we have to know the Constitution as a fundamental foundation, and if we were active with that, we would be the united front and force we are looking for. The Beys are the enforcers of the law wherever they may be with their regal retinue. Moors are not foreigners in their own land. They may be prisoners, mentally, but not foreigners. This is also why the Prophet said the supreme issue is to enforce the Constitution for the United States of America and to place your trust upon issue and names formed by your forefathers. We thank you for your patience during our recent technical difficulty. We look forward to your continued interest and activity and thank you for your support. However, the universe thanks you more. One of the interesting things that came more clear to us during our 24-hour downtime was transparent exposure to underhanded activities. We found some of the family took advantage of the opportunity in assuming we were out of business and made a full flyer that posted us as out of business, and they took joy and responsibility for us being down. They said if we come back up they would shut us down again. And mentioned how now they can disperse the proper lessons of Prophet Noble Drew Ali. We found this very interesting because for one, those lessons have been out for over 100 years, 2. We honor and respect those same lessons, and 3. Why weren't they dispersing the lessons all along whether we were existing or not? In fact, we thought, if they spent their time dispersing those lessons, they may not have time to slander anyone. Clearly they are not with rapblayz publications. In case we thought there were some other reasoning in the slander, thanks for letting us know it. Is pure unadulterated lower self-hatred, slander, and all things that harm that navigates their human temple, which is what the Prophet came to help uplift fallen humanity from, and is a violation of Act 3. In those same bylaws of the association, some need to either get a new navigator or a new body temple. We also found a group who put a message on Facebook, since rapblayz is down, send all of your papers to us. They were talking about proclamations in process intended to be sent to rapblayz and affiliates. Now that was a straight up redirect. It reverberates as we speak, as some are still confused about where to send them. That was a classic causing confusion. People often ask why does it seem that Moors are not united? And they come up thinking they will be the ones to bring the unity. Many are united in thought, in spirit and in deed, possibly some do not have eyes to see them and some do not want to be seen. However, that does not mean the energy of the unified messages cannot be heard. We recognize the answer in part to that question was served to us all from the universe. It is about the mindset, about the mental slavery. As the Prophet said, it is not money, but national principles that make the man definition of unity, in the law of estates. Stop right there, let's go no further. If you still call yourself Negro, colored, or black or act and think in the mindset of Negro, colored and black, then you will never find unity because status and estate mean the same thing. You will gain back your heritage and your lost estate in a conflict that cannot be told in words. Prophet Noble Drew Ali, Chapter 1, Circle 7 Holy Quran. Lastly, we appreciate all support and sincere love, however we also found that some say they are authorized affiliates of rapblayz publications, of which we had no knowledge of. Our affiliates are Moor's Heritage and History School, MHHS Eyes Wide Open, Blog Talk Broadcast, 5. Moorish Nation Public Records, moorishnews.wordpress.com, Mantis Views 29, Canaan Land Moors. Under the umbrella of the Moors Divine and National Movement of the World and Bill of Right No. 1. You are not indigenous because you are a part of a club or not a part of a club, or of a private society, association, or institution, etc. No. Man can change the descent nature of another. Aboriginal and indigenous is a status refinement, not a nationality. Those who are Aboriginal are first, as a means to come down from, to be first, from the beginning, as in abintio, from initial. As a divine spirit manifest in the flesh, you are a coming down from the spirit, manifested in the flesh as the aboriginal to the land, the original man, as is supported in Genesis 1, manifested on the sixth day of creation. Not necessarily Genesis 2, which speaks of Adam and the descendants of Adam. Everyone now knows, Adam was not the first, nor only being, as others were here at that time and when Cain fled into the land of Nod. After slaying Abel. The use of common sense and reasonable analysis is what is meant by, if I could just get you to thinking you would free yourself. The sixth day of creation is Friday. This is affirmed in the 101 teachings, wherein your manifestation into the flesh is a holy, and holistic, occurrence. Thus properly symbolized as Friday, day named after heavenly body Venus. Feminine, creating, energy, also known as Mot, Libra, Astarte, and other feminine attributes. Thus Friday, Viernes, is the day man was formed in the flesh, mother's womb, and Friday is the day man departed from the flesh, from mother's womb. The question of where you came from is answered, the reason Friday is a holy day is also answered, and the reason this is divine and national activity is answered as well. Moors are the first navigators, mooring upon the waters and the land. This is why no matter where you go, or say, or think you come from, you will find copper-colored, dark-skinned people as the Aboriginals and ancient ones. The further you go back, you will see even darker, heavily melanated Aboriginal people across all four corners of this earth, Asia. This fact is also supported in the Intercatera Divina Papal by Pope Alexander VI, as to how they found dark melanated people, during their 1,400 crusades. Translating to approximately 800 in Moorish/Islamic calendar. They set their sights on conquering the people by way of forcing their version of Christianity upon them at the penalty of killing them, because their God said it was right to do so in the name of Christianity if they did not convert to their version of religion, of which they call Christianity unto today. It is pretty warped and inhumane to think that someone would murder someone else for not converting to their version of religion. They got their version of Christianity from Christ, which is the crystal clear, pure, and cleansing rays of the sun, of which they endeavor to endure without being burnt even unto today, as that causes skin disease, melanoma, leprosy, of old terminology. They were otherwise known as Cretans. Those with skin disease. From Cretan came Christians and their version of Christianity. This is why you cannot be a Christian. Read the beginning of Christianity chapter 46 of the Circle 7 Holy Quran, and learn more regarding. Same as to why you cannot be a party to said Christianity and why you must give back their religion, which belongs to them for their salvation. You must accept the old-time religion, of which they have based their religion off of, centered around the sun, which is the Christ ray. We have strayed after strange gods of Europe, of which we know nothing about. Religion means to bind back, to re-allegiance yourself. It is nothing scary, nor is it anything to shun, or throw out the baby with the bath water. These are documented facts and not opinions. In their Christian crusade/conquest intent, they did not discover the land or the people, as they were already here. In fact, at Ellis Island today, they post that there were over 200 cultures, or tribes/family of people here when they got here, who are the Aboriginals of the land. Anyone who is Aboriginal is indigenous, of the ancient ones. Thus, they must go back to the mindset of their ancient foremothers and fathers, before modern European colonization. For those who think that is some outdated concept, then at least go back to knowing that your predecessors are the ancient foremothers and fathers of civilization and civilization principles. When you couple that with honoring your mothers and fathers, somehow, I trust it paints a different story and in fact changes your mindset. Some will succumb to anger, become emotional and upset that they have been lied to, but be not hasty, always remain in an intelligent tone and know the truth being told is what ensures it all goes back in the hands of Moors, first navigators. It is imperative to get your mindset straight. Don't bring the hate, because we must learn to love instead of hate, as love is the first principle, which brings the light of truth. Truth brings peace to bear freedom from lies, encumbrances, and mental chains, and with freedom justice is done. Confusion brings attention. There is nothing new under the Sunday. All matters regarding the liberties of the people have already been scribed. All rules of engagement are already scribed. All we need to do is enforce it. That is what the prophet brought, and that is what he said. Any new laws made within the temple was for the members, for the purpose of guiding and preparing members to ultimately take their place amongst the affairs of man when they go out into the world and link themselves back to the family of nations. We need to try that on for a few generations at least, which is what getting it into the youth is all about. Consular courts are not a government. On our recent broadcast regarding consular court, we gave the definition and purpose of consular court directly from the congressional records and explained the repeal in 1956 and why. We remained neutral to the subject and did not give any specific components or concepts to the now various risings of consular courts. Do not be a blind follower. This topic is a perfect example of why we must study. Below is the direct link to our Tuesday, May 22, 18. MHHS National Principles in Action broadcast. We will be posting the PDFs from the congressional records for edification shortly hereafter. http://www.blog.com/mhhs-eyes-open/2018/0-5/23/principles-in-nationality-in-action. Horizontal divider 12. The buzz about Moor's consulate court. We have been receiving inquiries as to a consular court having a signing this month. If you have had the experience of asking several different people and getting a different answer as to the purpose of it, you will have to wait until that event to know what they are presenting for the people. What we do know about consular courts is that they were originally established for foreigners to enforce treaties across the land. As for the Moroccan/American land, upon the establishing and enforcing of the Moroccan/American National Constitution, the supreme law of the land for the United States of America, corporation or corporate citizens, wherein within the Constitution all treaties are included to be enforced, Article 6. An admiralty law is also included, Article 3. Consular courts were established for foreigners until the Constitution and judiciary venues were set up in harmony with the law of the land and solidly taught and enforced. This is why they were repealed. Foreigners could claim their citizenship to the USA, natural people could not, cannot, and ought not, as they, USA, its founders are not your ancestors and you are not members/citizens of the USA Corporation, even though it operates on or upon the Moroccan/American soil. Thus, Article 12 of the original 13th Amendment states that descendants of Africans cannot be citizens of USA. Many may think this is some kind of bias due to lack of study and knowledge of the law and history. I trust now you will understand that it is not. As well, the Prophet said to enforce the Constitution so you are not molested by other citizens. If we spent time doing that, we would not have time to slander each other, nor would we keep looking for European processes. First, of course, we have to know the Constitution as a fundamental foundation, and if we were active with that, we would be the united front and force we are looking for. The Beys are the enforcers of the law wherever they may be with their regal retinue. Moors are not foreigners in their own land. They may be prisoners, mentally, but not foreigners. This is also why the Prophet said the supreme issue is to enforce the Constitution for the United States of America and to place your trust upon issue and names formed by your forefathers. Many are saying, spreading false information. Click here for our initial response to Consular Court Rising 2018 to 1 PG PDF. Horizontal divider 12. Time for a truth. As Mercury, communication energy, goes direct and unravels much misinformation. Who put black on the Prophet's death certificate? Certainly, it was not him. The following is a memorandum sent to RV Bay Publications for posting on this holy day, May 5, 2017, 1438. We thank the author, Sidi Salim Azim Bey, for considering this platform to share his research. It is time for truth. If you don't believe it, research it for yourself, and while you're at it, find yourself approved. I am distributing this memorandum for publication on the 155th anniversary of Cinco de Mayo to clear up some organized confusion that exists regarding the true background and status of the Moors originally domiciled here in North America, El Maghrib El Aqsa. Prophet Noble Drew Ali brought forth a divine truth that has not been placated by falsehood as it may appear online. History repeats itself, and Noble Drew Ali said he would repeat himself as well. The agitations, misinformation, disinformation, and overall confounding tactics of COINTELPRO agents disguised as faithful Moors has made it necessary for the faithful to provide some clarification and by design, wield the sword of truth and shame they. Updated information. The document below is now in PDF and it is a report on the rally that took place near the Philadelphia Corporation. It is an excellent study tool for your understanding/overstanding of the mortgage myth, written by Taj Tariq Bey. It is excellent information for your study, education, and qualification benefit. Therefore study it well before taking other actions. Study well, and become competent and qualified in your knowledge and position about some of the major things that takes place with mortgages and foreclosures within the offices of bank representatives and agents, and any other claimants. It is wise to know these things as they relate strongly to your right of claim to your estate and property. After testing yourself for competence, then you are ready to issue to the bank, mortgage company, claimants, trustees, etc., the official correspondence found below the rally document, named Foreclosure Writ/Discovery. Be sure when submitting your correspondence that you address a natural person by name who is the representative or agent operating through or for the bank entity, mortgage entity, or any other entity making claims on the estate or property. Therefore, every time you correspond, place the name of a natural person that you are dealing with, or is dealing with you before naming the entity. Place their name in front of the entity name, as they are the natural person representatives. This prevents them from their practiced deceit of hiding behind corporation persons. Once they default by failure of qualifiably answering the stated questions, and they must answer all of them specific to the questions asked, you are then lawfully qualified to send them a default notice. We have found there is no need to send a reconveyance letter as your inheritance cannot be bought, sold, or transferred, therefore they are not and never have been a trustee of your estate. As you study, look up the words ancestral estate, land, hereditament, corporeal hereditament and incorporeal hereditament. Also look up escheat and feudal law. In essence, study is required of you. 1. Foreclosure Rally. This article is a report on the foreclosure rally that took place near the Philadelphia Corporation, attended by and reported by Taj Tariq Bey. It is an excellent study tool and contains useful information for your inner standing/overstanding of the mortgage myth. 10 pages 8.5x11. There was a rally held on March 24 in the Philadelphia territory, to stop a sheriff's sale, scheduled for the 5th of April. I was invited to attend, wherein I offered my assistance as follows in this document, which includes information and questions for your review and consideration in an effort to help you better understand the mortgage myth. This information is for your review, study and utilization. At the end of this document, you will find a reconveyance letter, Word format, that you may utilize after you have submitted the questions contained in this document via a writ in the nature of discovery, or if you have already submitted a writ in the nature of discovery. This basically submits the people's, lawful, judicial, and final position regarding the matter, as you are the enforcer of the law, and must enforce the law when others encroach upon your rights. When we know better, we do better. A rally is a rapid reunion directed for a concentrated effort by an army, a group, a coalition, or a body politic, etc., after repulse, or being thrown into confusion, misconception, or disorganization. This rally is the result of plans to stop the sheriff's sale of over 2,000 properties, scheduled to be sold at auction, etc. on April 5, 2011. Among the sheriff's duties is the authority to execute writs according to the law. In this instance, the sheriff is enforcing the judicial jurisdiction and authority to execute, to carry out, and to discharge writs of execution and foreclosures. The auction and sale is to be held on behalf of the corporate city of Philadelphia, and in cooperation with other banks, corporate persons, and loan entities, unnamed, at this time. The home and property owners have honorably sought relief and a stay from the sheriff's writs of execution by way of the following, because it is The duty of the sheriff to protect the people and their interest, rights and property, not the corporations, which means he is really a policy and code enforcer, disguised as a sheriff. It is not the duty of the police to protect you. Their job is to protect the corporation and arrest code breakers. SAP vs. Tallahassee, 348 so 2nd 363, Reef vs. City of Philadelphia 477 F 1262, Lynch vs. NC Department of Justice 376 SE 2nd, 247. A. The people were stressfully awaiting decisions made by others, to conditionally apply for access to $105 million that has been approved to help 2. Pay the mortgages of the unemployed and the ill or impaired homeowners facing foreclosures in Pennsylvania Commonwealth. B. HUD is still preparing guidelines for the Emergency Homeowners Loan Program, EHLP, which was passed by the Congress for the United States, and scheduled to start October 1, 2010. C. The property owners are hoping that some sympathetic public servant or that an Article 3 judge will act to grant a stay or injunction, stopping the writs of execution planned to be enforced by the so-called sheriff, thus stopping the scheduled auction sale of April 5, 2011. Reality and fact, if the homeowners, who are subjects of the writs of execution enforcements by the so-called sheriff, are to ever get justice and remedy, they should, and must, at the least, answer the following case-relevant questions. Facts about the following amenable questions must be known, answered, and disclosed. The homeowner, S, borrower, S, and property owners should answer the questions with honesty, integrity, surety, and confidence. Legal notice: remember that in matters of agreement, S, contract, S, or fiduciary obligation, S, rules of law govern all issues in controversy. This is of special interest in matters of legal dispute, in questions of ownership claims, in issues about rights of property, and especially in questions involving valid or invalid contract, S. The same principles apply to solemn oaths, trustee obligations, and matters involving the fiduciary duties of public officials and public servants. These principles apply in all mortgage and loan cases. If you, the property owners, do not exercise your secured rights to discovery and disclosure, be aware that some less than honorable persons are bound to abuse or steal your rights, through profitable corporate entities, and thus, steal your private properties. Mortgages and loans are governed by contract laws. It is the responsibility of the contracting parties to measure and to adjudge these instruments by the rules that govern contracts. These equitable law principles supersede the present claims or actions related to the foreclosures, writs of execution or auction sales. Pertinent legal and lawful questions now stand unresolved as to whether or not contract law principles have been applied, upheld, reviewed and/or satisfied, before commencement of the threatening actions. Address this and any relative loan controversies by answering the following questions for your own records. Act to secure your rights to due processes in the foreclosure and writs of execution controversies. Act with due diligence to acknowledge and secure your rights, and to secure the rights of your families to ownership of private property, your homes. 3. Questions for discovery, disclosure, and remedies. 1. What are some of the instruments, documents, or articles of evidence lawfully needed and necessary for the banks, the loan officers, the debt collectors, or for the sponsoring corporate city of Philadelphia, to enter into evidence before competent judicial court, S, move to sanction the writs of execution or any Other actions used to seize or to claim confiscation, ownership of the homeowner, s. private properties. Are you aware of the existence of such requisite instruments? Were you given certified copies of any of these instruments before the action, s. were commenced? Did you, the homeowner, s. or borrower, s. publicize a claim for your undisclosed estate, s. or trusts, or were you given the opportunity to discharge the alleged debts? Did proper sanctioning courts and the sheriff rightly examine and investigate the following? For the record, as required by due process? A. Submission of original promissory note, s. front and back. __________. B. Submission of every allonge, front and back. _________. C. Shown to the court, s. evidentiary proof of the true holder, s. and filed documented proof of authority for someone to represent or to act for the lawfully verified and reachable holder, s. _________. Yes _________. No __________. I don't know __________. To the word mortgage means dead pledge. Affirm for the record what is dead about a mortgage and who is the pledge. I knew the meaning of a mortgage ___________. I did not know ___________. The is dead. Is the pledge. I do not know who the pledge island. ________. 3. Name the person or party that issued the mortgage, and is that party lawfully documented and identified as the present holder, s. of the alleged loan or promissory note. The verified holder is I don't know _________. 4. Did the bank representative, loan officer, or party issuing the loan, sell the mortgage/loan to another party? If so, how soon after were the mortgage/loan sold after their initial issue? Were you, the borrower, informed of a sale? Yes ________. No ________. 4. 5. How much money, specie, did the bank representative, s. or loan officer, s. place in the hand of the alleged borrower? Did a physical transaction of any money, specie, from the lender to the borrower ever take place during the commencement or execution of the mortgage agreement contract? Yes ________. No ________. How much money, specie, was given? ____________. 6. Did the bank please mail to the borrower the following certified and verified official copies of loan-related documents, prior to the meeting scheduled on April 1, 2009 for the borrower to make a physical inspection of the following documents and enable the borrower to verify and witness the same? This is a lawful demand and request, under the rule of discovery, and forwarded to Capital One Bank. Please provide the requested information in order that I may study all evidence regarding this matter within 10, 20 days of the receipt of this notice of discovery. Produce the following documents and associated instruments. 1. Produce the original promissory note, front and back, associated with the loan from your agency/entity/persons to the borrower. 2. Produce any allonge, bill of exchange, and/or promissory note, front and back, complete with any affixations or allocations attached to the borrower promissory note for endorsements. 3. Produce all bookkeeping journal entries associated with the loan to the borrower. 4. Produce the deed of trust associated with the loan to the borrower. 5. Produce the insurance policy in place on the borrower's promissory note associated with the loan. 6. Produce all call reports and related notes made for the period covering the loan. 7. Produce the deposit slip for the deposit of the borrower's promissory note associated with the loan. 8. Produce the original order authorizing the withdrawal of funds from the borrower's promissory note deposit account. 9. Produce the account number from which the money came to fund the check given to the borrower. 10. Produce verification that the borrower's promissory note was a gift to the lender from the borrower. 11. Produce the name and the address of the current holder of the borrower's promissory note. 12. Produce the name and address of the lender's CPA and auditor, for the period covering the execution. 13. Produce a copy of their legal authority to do business in the state of Connecticut. 14. Produce evidentiary authorization to levy surcharges. This is the borrower's good faith attempt to clear up any misrepresentations or confusion concerning this matter, before taking any further actions. A failure of the aforementioned entity or representatives to respond within the allotted 10 days of receipt of this writ in the nature of discovery will be deemed a dishonor of this notice and demand for disclosure. Thank you. Underscore 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 X relation e straw name. All rights reserved / without recourse / with prejudice. Mailing location. Foreclosure Rally. This article is a report on the foreclosure rally that took place near the Philadelphia Corporation, attended by and reported by Taj Tariq Bey. It is an excellent study tool and contains useful information for your understanding/overstanding of the mortgage myth. 10 pages 8.5x11. There was a rally held on March 24 in the Philadelphia territory, to stop a sheriff's sale, scheduled for the 5th of April. I was invited to attend, wherein I offered my assistance as follows in this document, which includes information and questions for your review and consideration in an effort to help you better understand the mortgage myth. This information is for your review, study and utilization. At the end of this document, you will find a reconveyance letter, Word format, that you may utilize after you have submitted the questions contained in this document via a writ in the nature of discovery, or if you have already submitted a writ in the nature of discovery. This basically submits the people's lawful, judicial, and final position regarding the matter, as you are the enforcer of the law, and must enforce the law when others encroach upon your rights. When we know better, we do better. A rally is a rapid reunion directed for a concentrated effort by an army, a group, a coalition, or a body politic, etc., after repulse, or being thrown into confusion, misconception, or disorganization. This rally is the result of plans to stop the sheriff's sale of over 2,000 properties, scheduled to be sold at auction, etc. on April 5, 2011. Among the sheriff's duties is the authority to execute writs according to the law. In this instance, the sheriff is enforcing the judicial jurisdiction and authority to execute, to carry out, and to discharge writs of execution and foreclosures. The auction and sale is to be held on behalf of the corporate city of Philadelphia, and in cooperation with other banks, corporate persons, and loan entities, unnamed, at this time. The home and property owners have honorably sought relief and a stay from the sheriff's writs of execution by way of the following, because it is the duty of the sheriff to protect the people and their interest, rights and property, not the corporations, which means he is really a policy and code enforcer, disguised as a sheriff. It is not the duty of the police to protect you. Their job is to protect the corporation and arrest code breakers. Sapp vs. Tallahassee, 348 so 2nd 363, Reef vs. City of Philadelphia 477 F 1262, Lynch vs. NC Department of Justice 376 SC 2nd 247. A. The people were stressfully awaiting decisions made by others to conditionally apply for access to $105 million that has been approved to help to pay the mortgages of the unemployed and the ill or impaired homeowners facing foreclosures in Pennsylvania Commonwealth. B. HUD is still preparing guidelines for the Emergency Homeowners Loan Program, EHLP, which was passed by the Congress for the United States, and scheduled to start October 1, 2010. C. The property owners are hoping that some sympathetic public servant or that an Article 3 judge will act to grant a stay or injunction, stopping the writs of execution planned to be enforced by the so-called sheriff, thus stopping the scheduled auction sale of April 5, 2011. Reality and fact: if the homeowners, who are subjects of the writs of execution enforcements by the so-called sheriff, are to ever get justice and remedy, they should, and must, at the least, answer the following case-relevant questions. Facts about the following amenable questions must be known, answered, and disclosed. The homeowner, S, borrower, S, and property. Owners should answer the questions with honesty, integrity, surety, and confidence. Legal notice: remember that in matters of agreement, contract, or fiduciary obligation, rules of law govern all issues in controversy. This is of special interest in matters of legal dispute, in questions of a good land and a land flowing with milk and honey. Deuteronomy 6.3, 11:9, etc. O land of wondrous story, old Canaan bright and fair. Though type of home celestial, where the saints and angels are. In earth felt admiration we address the hills divine, and gather consolation on the files of Palestine. In all our lamentations, in the hour of deepest ill, when sorrow wraps the spirit as the storm clouds wrap the hill, some name comes up before us, form they bright immortal band. As the shadow of a great rock falls upon a weary land, the dew of Hermon falling yet, revives the golden days. Sweet Sharon lends her roses still, to win the poet's lays. In every vale the lily bends, while o'er them wing the birds, whose cheerful notes to marvelously recall the Saviour's words. From Bethlehem awake the songs of Rachel and of Ruth. From Mizpah's mountain fastness mournful notes of filial truth. Magdala gives narration of he penitent thrice blessed, and Bethany of sister hosts who loved the gentle guest. Would we retrace the pilgrimage of Jesus Christ our Lord? Behold his footsteps everywhere, on rocky knoll and sward. From Bethlehem to Golgotha, his cradle and his tomb. He sanctified old Canaan and accepted it his home. He prayed upon the mountainside, he rested in thy grove. He walled upon the Galilee, when winds with billows strove. They land was full of happy homes, that loving hearts did own. E'en oxes and the birds of air, but Jesus Christ had none. Thou land of milk and honey, land of corn and oil and wine. How longs my hungry spirit to enjoy thy food divine. I hunger and I thirst afar, the Jordan rolls between. I faintly see thy paradise all clothed in living green. My day of life declineth, and my sun is sinking low. I near the banks of Jordan, through whose waters I must go. Oh, let me wake beyond the stream, in land celestial blessed, to be forever with the Lord in Canaan promised land. Barcodes and national IDs. Barcodes are for commercial products and ought never be on an allodial national ID. There are some who think so and either desire, create or accept cards with a barcode, however they either don't know, or they know and purposely infiltrate the concept. It appears many make the mistake of mixing commerce with birthrights, which will prove to be a grave error. This can only be attributed to lack of study, of which we have all suffered, or purposeful infiltration, of which is why we ought to study so we don't continue to suffer. Many take national principles and actions and bring commercial and corporate tenets into it because that is all we have known. We even had someone send us some information regarding state governments and how they have proclaimed that they do not recognize Aboriginal and Indigenous or national principles and people. Why ought they? They are corporations/companies and are quasi-national entities and agencies. Since when is an agency or corporation/company/government authority over the natural people? Their policies and procedures are for their corporate members or citizens, as citizen actually means member. The articles in the law of the land, which is for every person, natural and artificial, and describes what corporation/company, artificial, and other citizens/members who operate on the land, can and cannot do. The Bill of Rights, referred to as amendments, preserves the rights/liberties of the natural being. It is clear that many are not aware of that and they mix the two because they know neither, therefore are unable to discern the difference, nor do they know their own standing, status, which means their relationship to the community. Municipalities and state agencies are corporations. As such, they have no parity with real flesh and blood beings. Flesh and blood beings keep desiring to join themselves. Administrators defined government succinctly. Governments are corporations, in as much as every government is an artificial person, an abstraction, a creature of the mind. Only, a government can deal only with artificial persons. The imaginary, having no reality or substance, cannot create or attain parity with the real. Penhallow v. Dones. As for your national ID from your national family. Section 1028 of U.S.C. United States Codes, Title 18 designates 3 special non-federal identification documents and gives them preferred treatment. These 3 documents, in the absence of a national identity card, are the prime means by which an individual establishes his identity in the United States. The 3 documents are: A. Birth certificate, B. Driver's license, and C. Personal identification card. Thus, if you do not have a national ID, then commonly accepted IDs are accepted. Commonly accepted IDs are accepted because one does not have a national ID. A federal established government does not make national IDs, and states can never produce natural persons IDs either, as they are not nationals, they are quasi-national corporate/company venues, which is the whole point of the real ID. In reality, what is a state ID? Where do you get one from? Many go to the DMV, right? Well, that is not the state, that is an agency administering the federal driver's program by contract to do so, and what they are authorized to issue is a driver's license, not an ID. States are now being limited and are required to put on those instruments that it is not a federal ID. As for municipalities, they are second-tier contractors contracted by states to assist with administering of federal programs, such as the Motor Vehicle Safety Program. They create agencies to do so, such as the DMVs and a whole list of other agencies, all being regulated federally. Because of this lack of knowledge, many keep inserting corporate/company and commercial and commonly accepted stuff, without realizing the difference. From lack of knowledge we suffer, and from lack of study, we will continue to suffer. We trust this has been helpful. Background truth regarding name correction and proclamations. In regards to the name correction and judicial notice and proclamations that has been on this site for 10 years, we desire herein to make it clear that those documents were not written by anyone in the nature of belonging to anyone. In fact, they were written years before by an elder mother as 5 separate documents. Later, by the time we put them on the site for review and use, they had been condensed into one document consisting of 6 pages, with the exception of the name correction, which remained separate as 1 page, totaling 7 pages. We made them available not only for review and use, but because people were charging upwards of $1,500 notes to obtain them, and in some cases only had access to them if one became a member of whoever's association. As such, we established and made available a process based on the fact that all Asiatic beings falsely identified as Negro, colored and blacks are in fact Moors by bloodline and not by membership. Those documents have always been freely accessed on our site, and still are. After making them available, people were having them notarized and authorized by employees of foreign companies on the Moroccan/American soil, having nothing to do with national family affairs. Mother Anita L. and Ras Mariah Bey established a national identification and sealing process, and have kept it updated over the years. Embedded into the process are certain principles designed to assist the people in waking up and becoming independent once again, as that is what Moors must do. These documents have been on the rapblayz.com website for over 10 years. Used by Moors around the world and submitted to demonstrate the unity of Moors. The documents are correct in aspects of principles, heritage, culture, and customs, and have been used to demonstrate unity in all four corners of the world. There has been no change, and we see no need to make changes at this time. There have been those who altered the documents, thereby changing the energies and turning it into a colored document. There are also those who are literally taking the basic instructions regarding the process and redirecting the people to an alternate venues, which has nothing to do with upright, independent Moors in their national capacity, thus must be seen for what it is, which is an attempt to infiltrate and injure the people, once again. When coming from those who are green, it is almost understandable, but you cannot hang your turban or your fez there. When coming from seasoned Moors, it is not and cannot be taken in any other way than visible encouragement and willingness to divide the family. It certainly demonstrates warring against mother and her children. For this reason it is the young who are more likely to be captivated or rather captured and redirected. After all, the prophet said this is for the young and yet unborn. He also said, "Do not scatter my sheep." You are to declare your nationality, if you do nothing else, and in these days and times, proclaim your national name. That being done simplistically by you. If you are looking for your Savior, you must, now for certain, look within. Nature has no respect for person or station. Person meaning the mask you present and station meaning the title you have or have given yourself. We then must look at the works of both the green and the seasoned with a careful eye of intent, knowing there is no justification to substantiate any act of division. This is also an indication of taking advantage of Moors who are not studied to the point where they are being treated as if they are stupid, because they are not as studied as they need to be and ought be, in honor of their ancestors and their illustrious heritage and history. Therefore, without attaining that knowledge they can never take their place amongst the affairs of man. They remain stakes on the table for all comers, green or seasoned. We cannot emphasize more to the young and those who are just coming into this information, the strong directive of Noble Drew Ali, as to the importance of study, because some of your own are waiting to put you right back in slavery. They are also demanding your private and confidential information, which is a collection for a dossier. Be ever vigilant and wise and act according to the excellence of your ancestors. Guard yourself. We, here at rapblayz Publications, will continue to demonstrate family unity even in the face of blatant attempts at disunity rearing its head all around us. We thank you for assisting in the uplifting of fallen humanity one more at a time. INSH Allah, whose hands have blood on them. Recently, on Facebook, this first week of August, notes were posted in regards to a sister who was fatally shot, and her small child shot and injured, at their home near corporate Baltimore, by policy enforcers over a traffic stop. They came to her home with a so-called warrant, after the traffic stop, which is ex post facto. If a municipality sends their policy enforcers with a warrant, it is called a municipal warrant. A municipal warrant is a bill of attainder, and bills of attainders are forbidden for both the Congress and the state to create. Article 1 Section 9 and 10 of the American National Constitution of 1791, of which all people and entities derive authority from on this American land. No bill of attainder or ex post facto law shall be passed. Article 1 Section 9. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. Article 1 Section 10. Municipal warrant, a municipal warrant or order is an instrument, generally in the form of a bill of exchange, drawn by an officer of a municipality upon its treasurer, directing him to pay an amount of money specified therein to the person named or his order, or to bearer. 15 America and ENG in Law, 1206. Bills of attainder are forbidden to be created by states, or any entities of a state, and any enclave, agency, association, etc., registered under a state. You must recognize these facts, just as any arrest warrant and/or search warrant is described as to what it is, and what it looks like, in Article 4. Upon reviewing it, you will see it is not computer-generated, as it must have a raised seal and signature of a judge, a real judge. What is that you say? An Article 3 judge, of which the defines and obligations of same are described in Article 3, as well as in Article 6. The warrant also must have an attached sworn affidavit. Why, you say? Because in order for there to be any action taken by any so-called law enforcer, there must be a complainant/accuser and/or injured party, and that complainant must bring to light the nature of the complaint in written form, signed as a sworn affidavit. In order for there to be any action taken in regards to a crime, there must be an injured party, of which traffic infractions, if any, are not a crime, and the same goes that a sworn affidavit describing such injury of the injured party, must exist and be attached to any warrant. It is then carried out by a due process of law and not arbitrarily decided and created by municipal employees. For a crime to exist, there must be an injured party, corpus delicti. There can be no sanction or penalty imposed on one because of this constitutional right. Scherer v. Cullen 481 F 945. Those are the explicit limited obligations of a state, described to ensure the people are not exploited by others, especially by corporations. Therefore, the question to ask is, have the municipalities gone rogue, and have the states in which they are supposed to be registered under or contracted out to work for, turned a blind eye? Turning a blind eye is easy to do when the people themselves are blind. The sister, and many others, died without a crime being committed, and the blood of them is on the hands of the municipal employees, security guards or Roman soldiers, or Ku Klux Klan members who have infiltrated law enforcement via municipal venues, according to the FBI reports. Yet the Facebook poster, and the grand sheiks of certain infiltrated, out-of-order MSTA temples, have not pointed a finger at them, or threatened to check them for it. You do the math on that, as it sounds and smells cowardice. Additionally, what disturbed us, is that other Moors have posted that the blood of this shoveling out from the avalanche of lies. The investigation into the recent killing of 2 municipal employees/police at Baton Rouge, Louisiana, is attempting to point to the MSTA and members, or a member. The report says MSTA members are anti-government, however that is a blatant falsehood and misrepresentation, as Moors, whether in the temple or not, are upholders of the law, specifically respecting the American National Constitution of 1791, and are aware that any and all government entities' authority is derived from that same Constitution as the law of the American land. As well, any and all government entities have the duty to protect, secure, and preserve the rights/liberties of the people ascribed within the said Constitution, with specific limitations, and no entity can be government if they are violating the law of the land. Moors are Moors whether members or not in the MSTA. It is interesting because we need to always maintain the integrity of what Prophet Noble Drew Ali put forth. However, just because most of the M.S.T.A's current leadership may deny and rebuke their brethren and sisterin Moors, due to the confusion caused by the infiltration via COINTELPRO some years ago, no more ought allow the lessons of Prophet Noble Drew Ali to be lost in the avalanche of lies that are being heaped upon them, as was prophesied would happen in these days and times, by Prophet Noble Drew Ali himself. Moors are those who have been coined Negroes, coloreds, blacks and African Americans, making them a minority because of their minor mind, or lack of knowledge regarding humanity, their own heritage, national principles, history, and law, which cannot be separated, family and government, These coins of Negro, colored and black, do not apply to natural flesh and blood beings. Thus, the rallies and protest under Black Lives Matter is more of an organized predatory ground for municipal employees, police, and other participating highwaymen to generate revenue even when supposedly organized as a safe and peaceable assembly. It also breeds more murders, imprisonments, and some who may come up on the missing persons list. For all who think these recent happenings are a script out of Hollywood, a conspiracy, not real, or have been scripted to be played out. Look at this script, the King Alfred and updated Rex 84 plan written years ago, in regards to the minorities, and see if you think it is being played out today, right now. There will be many cities where the minority will be able to put into the street a superior number of people with a desperate and dangerous will. He will be a formidable enemy, for he is bound to the continent by heritage and knows that political asylum will not be available to him in other countries. The greatest concentration of the minority is in the Deep South, the Eastern Seaboard, the Great Lakes region and the West Coast. It is expected, therefore, that, when those objectives are denied the minority, racial war must be considered inevitable. When that emergency comes, we must expect the total involvement of all 22 million members of the minority, men, women, and children, for once this project is launched, its goal is to terminate, once and for all, the minority threat to the whole of the American society, and, indeed, the free world. We are confident that the minority could hold any city it took for only a few hours. The lack of weapons, facilities, logistics all put the minority at a final disadvantage. In this electrifying age of information, all is being exposed. Our message to the people and the citizens, the reporters, to all those concerned in regards to uplifting fallen humanity, and to the municipal employees, police, who are, and have been for a long time, blatantly violating law and divine law, if you are really looking for the devil in this, look within. We offer excerpts from Chapter 3 of the Circle 7 Holy Quran divinely prepared by Prophet Noble Drew Ali. If you are searching for a better understanding of what is going on with the murders of the people in the American land by municipal employees, read this article. Policeman purpose admitted by case law is to protect municipal corporations. Leave the natural people alone. No one ought to have to say to a municipal employee that they are a constitutionalist. The American National Constitution of 1791 is the law of the land for everyone, wherein municipal employees are bound by the oath of the Union state that hires them, as any and all government and public officials must do, as well and especially judicial officers and other public servants. They are bound to protect the liberties of the people and uphold the supreme law. Any and all other hired contractors by any state are also held to the law of the land and cannot impose their private corporate policies onto the natural people. The code they use in doing so is statutes. However, statutes are not law. Jus precarium, in the civil law, a right to the thing held for another, for which there is no remedy by legal action, but only entreaty or request. Note, the public servants/public officials, etc., are holding only by way of being trustees of the Moor/American estate, see International Treaty of Peace and Friendship 1787, and have been given obligations and duties as described in the Articles of the American Constitution of 1791. They however have no right of claim unless entreated to them by request and granted or permitted by the natural people, as the people are the government whether they realize it or not. By not realizing it, is why things are so out of order, and others who do not have good intentions, have taken advantage of those who suffer from a lack of knowledge. They have eschewed the ancestral estate and inheritance, yet they are but occupiers on it, and have no claim to it by any subdivisions of it. The people's position in law is jus praesens. Jus praesens, in civil law, a present or vested right, a right already completely acquired. It is so very clear that the municipal employees, being private security guards called police, who work for corporations that many think is government, are way out of order and are the outlaws. They have no right to seek out, to probe, to stalk and violate the people and the citizens, to generate finance to pay themselves to continue to seek out, probe, stalk and violate the people and the citizens. Such activity is human trafficking. Where are they getting instructions to do so? In this electrifying age of information, the truth is being exposed that they are in fact implementing human trafficking and genocide, murdering the people as if they were stock, at their will, usually done by way of violations of the people's unalienable constitutionally secured liberties, i.e. right to travel, misclassified as commercial traffic stops under the legalities of a driver's license. However, the driving instrument is a federal program for those who are doing commerce only, pursuant to Title 49, in the first place. Traveling is a substantive right that cannot be leaned upon, as it is unalienable/inalienable for the natural people. Are you a natural person, or are you an artificial person as is meant in the 14th Amendment First Clause, by definition? Corporations are persons as that word is used in the first clause of the XIVTH Amendment, Coyington and Elton. Co v. Sandford, 17s.ct 198, 164 U.S. 578, 41l.ed. 560, Smith v. Ames, 18s.ct 418, 169 U.S. 466, 42l.ed. 819, People v. Fire Association, 92 NY 311, 44 AM Reb. 380, U.S. v. Supply Co., 30 SCT 15, 215 U.S. 50, 54l.ed. 87, Contra, Central PR Co. v. Board, 60 calories 35. These are really elementary lessons that have been shared for a while now. However, it must still be necessary to impart these truths, as too many have, and are, still acting, expecting something, and marching, under the 14th Amendment when it is not meant for natural, flesh and blood. Shoveling out from under the avalanche of lies. The investigation into the recent killing of 2 municipal employees/police at Baton Rouge, Louisiana, is attempting to point to the MSTA and members, or a member. The report says MSTA members are anti-government, however that is a blatant falsehood and misrepresentation, as Moors, whether in the temple or not, are upholders of the law, specifically respecting the American National Constitution of 1791, and are aware that any and all government entities' authority is derived from that same constitution as the law of the American land. As well, any and all government entities have the duty to protect, secure, and preserve the rights/liberties of the people as scribed within the said constitution, with specific limitations, and no entity can be government if they are violating the law of the land. Moors are Moors whether members or not in the MSTA. It is interesting because we need to always maintain the integrity of what Prophet Noble Drew Ali put forth. However, just because most of the M.S.T.A's current leadership may deny and rebuke their own brethren and sisterin Moors, due to the confusion caused by the infiltration via COINTELPRO some years ago, no more ought allow the lessons of Prophet Noble Drew Ali to be lost in the avalanche of lies that are being heaped upon them, as was prophesied would happen in these days and times, by Prophet Noble Drew Ali himself. Moors are those who have been coined Negroes, coloreds, blacks, and African Americans, making them a minority because of their minor mind, or lack of knowledge regarding humanity, their own heritage, national principles, history and law, which cannot be separated, family and government. These coins of Negro, colored and black, do not apply to natural flesh and blood beings. Thus, the rallies and protest under Black Lives Matter is more of an organized predatory ground for highwaymen, municipal employees, police, to generate revenue even when supposedly organized as a safe and peaceable assembly. It also breeds more murders, imprisonment, and some who may come up on the missing persons list. For all who think these recent happenings are a script out of Hollywood, a conspiracy, not real, or have been scripted to be played out. Look at this script, the King Alfred Plan, updated REX84 Plan, written years ago, in regards to the minorities, and see if you think it is being played out today, right now. There will be many cities where the minority will be able to put into the street a superior number of people with a desperate and dangerous will. He will be a formidable enemy, for he is bound to the continent by heritage and knows that political asylum will not be available to him in other countries. The greatest concentration of the minority is in the Deep South, the Eastern Seaboard, the Great Lakes region and the West Coast. It is expected, therefore, that, when those objectives are denied the minority, racial war must be considered inevitable. When that emergency comes, we must expect the total involvement of all 22 million members of the minority, men, women, and children, for once this project is launched. Its goal is to terminate, once and for all, the minority threat to the whole of the American society, and, indeed, the free world. We are confident that the minority could hold any city it took for only a few hours. The lack of weapons, facilities, logistics all put the minority at a final disadvantage. In this electrifying age of information, all is being exposed. Our message to the people and the citizens, the reporters, to all those concerned in regards to uplifting fallen humanity, and to the municipal employees, police, who are, and have been for a long time, blatantly violating law and divine law. If you are really looking for the devil in this, look within. We offer excerpts from Chapter 3, Unity of Life. 9. The higher self is the embodiment of truth, the lower self is truth reversed, and so is falsehood manifest. 10. They leave the natural people alone. No one ought to have to say to a municipal employee that they are a constitutionalist. The American National Constitution of 1791 is the law of the land for everyone, wherein municipal employees are bound by the oath of the Union state that hires them, as any and all government and public officials must do, as well and especially judicial officers and other public servants. They are bound to protect the liberties of the people and uphold the supreme law. Any and all other hired contractors by any state are also held to the law of the land and cannot impose their private corporate policies onto the natural people. The code they use in doing so is statutes. However, statutes are not law. Jus precarium, in the civil law, a right to the thing held for another, for which there is no remedy by legal action, but only entreaty or request. Note, the public servants/public officials, etc., are holding only by way of being trustees of the Moor/American estate. See International Treaty of Peace and Friendship 1787, and have been given obligations and duties as described in the Articles of the American Constitution of 1791. They however have no right of claim, unless entreated to them by request and granted or permitted by the natural people, as the people are the government whether they realize it or not. By not realizing it, is why things are so out of order, and others who do not have good intentions, have taken advantage of those who suffer from a lack of knowledge. They have eschewed the ancestral estate and inheritance, yet they are but occupiers on it, and have no claim to it by any subdivisions of it. The people's position in law is jus praesens. Jus praesens, in civil law, a present or vested right, a right already completely acquired. It is so very clear that the municipal employees, being private security guards called police, who work for corporations that many think is government, are way out of order and are the outlaws. They have no right to seek out, to probe, to stalk and violate the people and the citizens, to generate finance to pay themselves to continue to seek out, probe, stalk and violate the people and the citizens. Such activity is human trafficking. Where are they getting instructions to do so? In this electrifying age of information, the truth is being exposed that they are in fact implementing human trafficking and genocide, murdering the people as if they were stock, at their will, usually done by way of violations of the people's unalienable constitutionally secured liberties, i.e. right to travel, misclassified as commercial traffic stops under the legalities of a driver's license. However, the driving instrument is a federal program for those who are doing commerce only, pursuant to Title 49, in the first place. Traveling is a substantive right that cannot be leaned upon, as it is unalienable/inalienable for the natural people. Are you a natural person, or are you an artificial person as is meant in the 14th Amendment First Clause, by definition? Corporations are persons as that word is used in the first clause of the XIVTH Amendment, Coyington and Elton. Co v. Sandford, 17s.ct 198, 164 U.S. 578, 41 L.ed. 560. Smith v. Ames, 18s.ct 418, 169 U.S. 466, 42 L.ed. 819, People v. Fire Association, 92 NY 311, 44. AM Republic 380, U.S. v. Supply Co., 30 SCT 15, 215 U.S. 50, 54 L.ed. 87, Contra, Central PR Co. v. Board, 60 calories 35. These are really elementary lessons that have been shared for a while now, however it must still be necessary to impart these truths, as too many have, and are, still acting, expecting something, and marching, under the 14th Amendment when it is not meant for natural, flesh and blood people. It is meant for artificial persons/corporations. Therefore, those who are leading under the 14th Amendment civil rights, etc., are either doing so knowing there will be no remedy, or they don't know, which means they are not qualified to lead anyone. Policemen are violating rights daily for generations upon generations of the uneducated people. There are but few people who know what the truth is about man, and that few know that it is foolish to try to impart it to the ignorant. Although the ignorant has finished college, he is a fool right on, being trained to jump through a hoop. The longer he stays in the schools, the better he can jump, and the more vivid will he defend his jumping. Moorish literature. Note 1, even the most elite have been fooled. Note 2, a bite of truth about Moorish information, and not what you may have been told to believe. We bring this forward because many think the police are enforcing law, however, they are enforcing policies for the corporations that hire them. Proven with the below substantive, unalienable rights/liberties of the natural people as it relates to traveling, which is not the same lawfully as driving. Everything that is lawful is legal, however, all that is called legal is not necessarily lawful. Driver. One employed in conducting or operating a coach, carriage, wagon, or other vehicle, with horses, mules, or other animals, or a bicycle, tricycle, or motor car, though not a street railroad car. A person actually doing driving, whether employed by owner to drive or driving his own vehicle. Wallace v. Woods, 340 MO 452, 102 S.W.2D 91, 97. The right to travel, the right to mode of conveyance, the right to locomotion are all absolute rights, and the police cannot make void the exercise of rights. State v. Armstead, 60 S 778, 779, and 781. The use of the highways for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right of which the public and natural beings cannot be rightfully deprived. Chicago Motor Coach v. Chicago 337 Illinois 200, 169 NE 22, ALR, Liger v. Chicago 139 IL. 46, 28 He 934, Boone v Clark 214 SW 607, 25 AM Jur, 1st, Highways, Sector 163. The right of a citizen to travel upon the public highways and to transport one's property thereon, either by carriage or automobile, is not a mere privilege, which a city may prohibit or permit at will, but a common right, which he/she has under the right to life, liberty, and the pursuit of happiness. Thompson v. Smith 154 SE 57. No state shall convert a liberty into a privilege, license it, and attach a fee to it. Murdoch v. Penn, 319 U.S. 105. If the state converts a liberty into a privilege, the citizen can engage in the right with impunity. Shuttlesworth v. Birmingham, 373 U.S. 262. A person driving an automobile cannot be stopped to see if he or she is licensed to drive, unless there is reasonable suspicion the person has engaged in criminal conduct. Delaware v. Prowse, 1979, 440 U.S. 648, 59 LED 2D 660. If the reason for pulling you over, hindering you, is because a tail light is out, that is not criminal, and once he/she informs you of that, their business with you is concluded. Thank you and have a good day is in order. Anything else is an arrest and intent to generate revenue. The only thing you owe to the public is due care. Traveling in an automobile on the public roads was not a threat to the public safety or health and constituted no hazard to the public, and such a traveler owed nothing more than due care, as regards to tort for negligence, to the public, and the owner owed no other duty to the public, e.g. state, he/she and his/her auto, having equal rights to and on the roadways/highways as horses and wagons, etc. This same right is still substantive rule, in that speeding, running stop signs, traveling without license plates, or registration are not threats to the public safety, and thus, are not arrestable offenses. Christie v. Elliott, 216 I 131, 74 He 1035, LRANS 1905-1910, California v. Farley 98. Said RPT 89, 20 CA 3D 1032, 1971. Possibly, the municipal employees, calling themselves police, may not like their job if they are forced to follow the law and serve the people and the citizens, instead of serving corporations and violating the law. They seem to like to. https://youtube.b/uuehacksjays. FEAR. FEAR, full evidence appearing real, is the number one tactic utilized in the media and in meeting or hearing rooms, as they are not courts. They use it to deter the natural people from enforcing their inalienable/unalienable birthrights liberties. Think about it, why would anyone have to deal with obvious violations against them, by what is said to be the government? One reason is because they are not the government, and even if you thought they were, it is well known, even advertised by them, that they are corporations, and corporations have no relationship or parity with the real flesh and blood beings. If they were operating as government entities, their purpose would be to protect, secure, and preserve the rights of the natural people. Clearly, that is not what is being done. Some time back, we became aware of some Moors who were adhering to the process of James McBride, a modern European who said he was operating the divine province, under the authority of the Vatican. That ought to have been enough said right there, but it wasn't, even though warned. Some Moors continue to participate. McBride was creating documentation to be sent out as lawful notice, and identification cards, according to him, this being done under the authority of the Vatican. Although, it ought to have been a clear signal to stop, do not pass go on this one, do not continue with such process. Yet, it was not, due to lack of knowing and will of wanton GTO be free from violations. Consequently, McBride did get charged with fraud and with creating false IDs. He said the IDs come from the same authority of the Vatican and that the people were ambassadors. Well, enough said. We know that his charge and conviction would be valid, and because it sounds much the same like what we are doing with the seating with Moors declaring and proclaiming and establishing IDs, it just may sway some people to believe the same in regards to us. However, that is not true for obvious reasons already established. You can find lawful support of that on the National Identification Card and Proclamation page. As for McBride, the Vatican would not authorize such activity, as they were in conjunction with the corporate governments, of which they themselves have since abandoned publicly, starting with the motu proprio of 2012 and 2014 and the visit this past fall equinox to the Congress floor to inform them they are but foreigners and aliens. The Pope, representing the Vatican, gave a speech in Elgish on the Congress floor, of which you can call up on the net and listen to it for yourself to verify this truth. We also have it on MHH's Facebook page, which is an open Facebook. Why Moors or any natural flesh and blood being cannot register or utilize vital statistics. Many think they must register their status correction, or name correction in judicial notice and proclamation. Thus, some have established a Moorish vital statistics, we like to call it the MVS. Others may have created registries and are telling you that you must be registered. No one has asked where the registry is being registered. Vital statistics may appear to be a branch of the county, municipality, or state, etc. However, it has its origins in the church, wherein the records of births of members/citizens of each union state was recorded for the church, and it is still that way today, even though many think church and state are separate. The current day preachers, pastors, reverends, etc., come out of their general clergy and step into secular clergy and report all marriages, making sure the marriage license that you retrieved from the local municipality or county is filled out and registered as property/members of the state. If you have children from that marriage, they must also be registered by default, beginning with the birth certificate, which is an instrument that proves human trafficking. See our article about the marriage license. This reporting is done under a quasi-national and municipal domicile, as that is what the church is also under to this day, particularly and especially those who have 501(c)(s), etc. In fact, the municipality is a religious organization with mincitaires who attend to the people and ministerial meeting rooms that they call courts, yet they are merely ministerial, possessing no judicial authority. They act as they do, just like an actor who was playing a part, except this is a part of the real-life illusion the people keep alive by having faith in it. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. Burns v. Sup. CT. SF. 140 calories 1. When acting to enforce a statute and its subsequent amendments to the present date, the judge of the municipal court is acting as an administrative officer and not in a judicial capacity. Courts in administering or enforcing statutes do not act judicially, but merely ministerially. Thompson v. Smith, 154 SE 583. The preachers, reverends, pastors, first get set up as a church after receiving permission through a license or a 501(c)(3), which provides they do not have to pay taxes. The 501(c) series or whatever assigned letter or number they have altered it to today, is their thank you for reporting and registering their congregation and the congregation's family under the corporate jurisdiction. For that service, not only does the church not have to pay taxes, they also cannot speak of civics, human rights, law of the land, etc., because it is a permission from a corporation. Yet, during election time they are asked to encourage the people of their congregation to vote for whoever they are instructed to push to win with the poll votes of the congregation. As a special note, most churches have had the full control of the donation plate. However, lately, because finances are getting tight, they have had to report their donation plate as well. Other stipulations have been added to certain donations made to the churches operating under 501(c)(s). The donation plate scrutiny started approximately 5 years ago in most churches. In short, registering is something you do with items and property not with flesh and blood beings. It is a means of your agreement to redefine your status and place you under jurisdiction of a quasi-national domicile, of which all states are quasi-national domiciles. They are not a national domicile or jurisdiction. Thus the beginning of confusion and truth and falsehood being strangely mixed for one who says they are an aboriginal and indigenous of a nation or family, and then agrees to quasi-national activities. That ought be enough to wake. Moors are not a part of any sovereign citizen movement. This video analect was put together by Rami Salam El, and was long overdue to be posted. We thank him much for his due diligence. This video is for anyone you hear speaking about Moors/Moorish Americans, Taj Tariq Bey, publications, or any active righteous Moors being sovereign citizens, or teaching it. Send this to them and demand a response from them. Demand proof of what they are claiming. In these days and times, it is time we hold people accountable. If they accuse someone publicly of something, they need to provide the proof. And if they can't, they need to make a public apology. And if they can't do that, then you should no longer even entertain a word they have to say. Peace and love. Rami Salam El. Clarifying reason to send to 7 locations. It has been brought to our attention, in error, that our purpose for suggesting you send notice to the 7 locations in regards to your proclamations and name corrections was to interfere with the trade on the stock market. Thumbs down 1.jpg. That is not the reason to send notice to the 7 locations. What happens on the stock market is relative to commerce. Birthright theft has nothing to do with commerce, as it is about bloodline and lineal descent, the proclaiming of your national status and allegiance, which sets the stage for all other matters in your life. Below is the reason as suggested and written by Taj Tariq Bey, of which we found to be proper, accountable, and lawful as it relates to notice. Due to the fact that the Union States corporate, state agencies and quasi-government agencies have instituted the colorable practices of birthrights theft, it is in the natural person's best interest to notify or to give declaratory affidavits of facts to all parties of interest. These shall serve as notice to principals and to agents, that there shall be no assumed jurisdiction in matters concerning Moorish American nationals. By Taj Tariq Bey. All Moors must declare their nationality. In these days and times Moors must proclaim * their national name. Prophet Noble Drew Ali, Act 6, in part. * proclaim, to publish, to make known. This page contains the What's New postings. These new items will be able to remain for a longer time on this page, and we will utilize dates to indicate when they were posted. We have moved our holiday collection writings to our new holiday/holy day page. The following is in support of the Sons of Allah MHHS blog talk class in regards to the number 9, given on September 19, 2015, numerologically equates to 9. Vbasits/the Moroccan Girl.jpg. The True Possessors of the Fez. Oil painting by William Merritt Chase. Titled The Moroccan Girl 1800s. Therefore, why would anyone say that women cannot wear the fez, especially since it is representative of the womb itself? For the truth, science, and mathematics on same see about the fez page. Do not let anyone tell you that which is not true, as the misinformation regarding the woman is intended to suppress the woman, and she is the grand architect that built Solomon's soul of man, temple, body, in the darkness, in the silence and with no tools, the womb. To cap up our November Sistars Standing on Law presentation, we offer the following quotes from the works of C.M. Bay's Clock of Destiny Book 1. If women on national scales possessed the applied knowledge of the secrets of the number 9, they would be supremely qualified to educate their children to the practical side of life during its 9 months maturity from conception to birth. Then, there would be no need for the institutions of religious mystery worship, idol, or image god. Jailhouses, prisons, and insane institutions would not be needed, for there would be no racial hatred or crime. The secrets of the number 9 and 12 signs of the zodiac involving woman and child, from conception to birth, is referred to in the book of John, Revelations, as the opening of the seven seals, from which has marked the very end of Christian theology and the rise of women, with civilization, namely, the Moorish or Asiatic women of the United States, who have been labeled Negro, colored people, by the sociologists of the Roman Cross Order. I am sorry to assert that the present grown UPS, especially 95% of both European and Asiatic Americans, will not turn loose the white image Christ doctrine and the Church, with its various denominations, until the United States of America has undergone its bloodbath, which is now in the making the most crucial bloodbath that the world has ever known. The doctrine of the white image was born in the United States of America, or colonial North America, through bloodshed, and will vanish after bloodshed which cannot be described in words. This destruction is necessary in order that the oncoming generation might escape mental bondage and dead idol, or image worship, which is definitely contrary to truth, wisdom, and economic and social progress. Message of the Ancestral Wines. vbesits/windswepterignews.jpg. When the Pope spoke on immigration and freedom of religion at Philadelphia during his visit on the fall equinox, full and red moon eclipse, the press put an article in the newspaper entitled "Windswept Speech," right original front page of newspaper, as the wind was whipping at his garb. We saw it as the ancestral wines in fact assisting in bringing a windswept message. Access the one-page PDF below for our interpretation of the ancestral wines message, thanks to the open eye of Ms. Raim L., one of rapblayz finest authors, who used an authoritative eye, guided by the ancestral spirits at work today in an undeniable force of truth. We wrestle not against flesh and blood, but against powers and principalities, princes of the air. St. Paul. Are you busy about enforcing the law or color of law? Color of law, the appearance or semblance, without the substance, of legal right. State v. Breckler, 185 Wisconsin 499, 202 N.D. 144, 148. Source, Black's Law Dictionary, pg 331. We gave that definition because we realize that many may not be aware that there is such a thing as color of law. That would be what you are learning in any law classes today. Also, many may think Black's Law Dictionary is indicative of a so-called black person, because the name is Henry Campbell Black. When you look up color of law, you will also find color of authority, color of office, and the definition of color itself, which is an appearance, semblance, or simulacrum, as distinguished from that which is real. Now you know why we never were colored people. In the 101s it tells you that color means something that is stained, varnished, or dyed, which means it hides or covers over the true substance of the thing itself. Everything that is legal is not necessarily lawful. However, everything lawful is legal. In regards to nationalizing, 2015. Greetings of peace. Thank you for your interest and activity. However, the universe thanks you more. Declaring your nationality or nationalizing begins in your mind, in being clear, and of course that also requires study to know who you are by natural descent, and then begin being who you are, and know the distinctions of who and what has jurisdiction, right words, over you. No one can change your descent nature, no one. There really is no such thing as nationalizing. It is about being clear or declaring to yourself first. That term is used loosely to indicate your awareness in self in honor of your ancient foremothers and forefathers who are, without doubt or contradiction, the mothers and fathers of civilization and civilization principles, inclusive of government, which is the people, governing their mental, and as first navigators upon the earth plane coming down from the spirit into the flesh, Moors, first navigators. There existed a treaty between the Moors of Great Britain and Morocco, Al-Maroc, modernly called America today, which brought Europeans/Slavics to the American land as workers on the original plantations. They were the indentured slaves for their freedom. And after a succession of acts, such as the Articles of Association, the Declaration of Independence, etc., the Treaty of Peace and Friendship, still enforced today, was then established to allow the modern Europeans inclusive of their Ellis Island descendants, to sail here freely. The organic American Constitution was also established and ratified in 1791, which is also still enforced today as the law of this land. It established the rules of behavior and engagement upon the land so that the people, all and any people, would not be molested by other citizens and their untoward acts or omissions of acts, especially the Union States/USA and their members/citizens, known today as United States of America, inclusive of any entities, associations, agencies/agents for the agencies, chapters/subchapters, charters/subcharters, corporations and trades, established, registered or in any way authorized by them or under them. Any public trustee/public official has the duty of preserving, protecting and securing the liberties and the unalienable/inalienable rights of birth of the people and the citizens. Unfortunately, because we, the natural people, have not enforced the law regarding our own protection of liberties, we have in fact been molested by those other citizens who are without doubt the lawbreakers and often operate as supposed government entities. Although these happenings may be because of what we were taught, or not taught, yet and still, ignorance of the law is no excuse. These actions of employees/agencies and agents of these feigned government entities, wherein they hinder, violate liberties, kidnap, falsely accuse and adjudicate, choke, beat, and slash or murder the people, is an act of a standing army of foreigners and immigrants, who quarter their forces in vehicles and sometimes horses, are being done by those who are tenants on this land. Trust, charters, patents, deeds, mortgages, are all indications of a tenant agreement, use of the land and resources. Read Magna Carta. These standing armies are in violation of Amendment 3, of the American Republic Constitution, established for and against those other citizens and is the law of the land. We must clearly see that a quiet war and atrocious violations of the law have been perpetrated and waged against the people, however it is bureaucratic and deceiving and perpetuated due to our lack of knowledge. It is particularly disturbing to know this is being done to generate income for their other citizens and corporations, coffers, and is disguised as law, but is commerce. Commerce is one of the reasons these other citizens were permitted to come freely after the treaty and the Constitution. These acts disguised as law, operating as commerce, are really human trafficking and if you become interested in making a name correction and judicial notice and public proclamation, under the Great Seal, the seal of the national government, and not under a seal of any state of the United States of America, Union States, which are all foreign quasi-national domiciles, we assist with that purpose. Please know their seals are not the Great Seal. Do not make the mistake of thinking so, or putting in written form that it has authority over you. We say this because there are people, groups, associations, etc., who are clearly not knowledgeable about government, advising people to ask foreigners to put their Great Seal on their paperwork. These types of actions prove lack of study and affirms that many wearing turbans and fezzes, or not, will put you back into slavery. Thinking their seal is the Great Seal, or is necessary in any way to authenticate allodial documentation from nationals, is keeping you in the same status you were in. If you have done this, we do get why they keep taking authority over you, and forging forth to maintain authority over those who insist on giving it to them by even asking for their consent. They are the original identity thieves and are now attempting to charge Moors with identity theft. Absurd. The name correction is to correct the Namdegir, because it has no L or Bay, which is the title to the American land estate, of which you are direct descendants and inheritors of. To remove those titles is an act of a quiet war against the natural people of the land, and is a remarkable silent weapon, bullet, disguised as a situation. This is especially so and only thrives if you are not aware. We suggest you read the page on the rapblayz website entitled National Identification Card and Proclamation. Upon reading the information in the documents for your two lawful public notices, name correction and judicial notice and proclamation, you will get more clarity as to all that pertains to you in making your claim and status correction. It has been publicly assumed and accepted that you are not a natural person, not Aboriginal and Indigenous to the land. Instead, it is assumed you are a corporate person, chattel property, resident/member/citizen of what you think is government, but are really corporations. However, corporations can only issue to other corporations, of which you say you are not a corporation. Therefore, if you ask for their permission, or for their seal of authentication on your allodial documents, affidavits, etc., you are saying you are in fact under their jurisdiction, and they know that, even if they do not tell you, and they will not tell you. The United States of America and all the states under it, or anything established under any state, have no legislative authorities. See Article 2 of the Organic American Republic National Constitution, ratified 1791. The law of the land. The states proper have executive authority, which means they can enforce the already existing rules of laws of the land, but cannot make any new ones. Therefore, they create statutes, English law, policies, procedures, and ordinances, which are corporate and are not law. See Article 6. Your compliance to them boldly says, by your admission, that you are a corpse, dead in the eyes of the law, civil liter mortis, and cannot speak for yourself and must have someone else to do so, as in an attorney, which can only speak for corps and corporations and matters that cannot speak for themselves. All of their courts are probate courts, which serves orphans, wards and minorities and those unable to speak for themselves from birth to death. An attorney is an officer of such courts only. Although they have assumed you are under their jurisdiction for whatever reasons, disclosed or undisclosed, there can be no assumptions in law. Therefore, you must declare your status, which is your relationship to the community, and also indicates your lawful and legal relationship, which sets the stage for jurisdictional matters and authority, and the manner in. This page contains articles designed to fertilize the seeds of thought into conscious deeds of life. Con equals with. Science equals sense. Conscience equals with. Common sense with science. Our thoughts are our seeds, and likened to a seed planted in the ground. Once planted, it grows under the sun and the moon. Thus plant your seeds, thought, and let them grow, manifest. New food for thought information. We like to think we have our hand on the pulse of the thoughts of the people, based on the questions they ask, because if it is all on your mind, it is all in the air. We will be providing very short analects of information for you to process. At this time, many are going to and fro in the earth. Some are seeking knowledge and others are seeking to devour. You must have discernment. Those who are seeking knowledge must first be a student, then they become a teacher, as the teacher only appears when the student is ready. This also means for those who choose a teacher, they must check to see if the one they have chosen has ever been a student themselves. If not, they may be misguided and ill-taught. Careful Moors, some of your own wearing turbans and fezzes will put you back into slavery. Eventually the new analects of information, designed to get you to thinking so you can free yourself, will be moved to the existing food for thought page. Keep up, things are moving fast. Memorandum 2. RV Bay Publications. Fr. Sidi Salim Azim Bey Effendi. DT. For publication on Holy Day May 5, 2017, 1438. I am distributing this memorandum in for publication on the 155th anniversary of Cinco de Mayo to clear up some organized confusion that persists regarding the true background and status of the Moors originally domiciled here in North America, El Maghreb El Aqsa. Prophet Noble Drew Ali brought forth a divine truth that has not been placated by falsehood as it may appear online. History repeats itself, and Noble Drew Ali said that he would repeat himself as well. The agitation, misinformation, disinformation, and overall confounding tactics of COINTELPRO agents disguised as faithful Moors has made it necessary for the faithful to provide some clarification and by design, wield the sword of truth and shame the devil. For the record, when Prophet Noble Drew Ali passed form in 1929, a great sellout occurred. Noble Drew Ali's own Supreme Grand Business Manager, Aaron Payne L., listed Prophet Noble Drew Ali's race as Black American on his death certificate. This was in essence for all practical and legal purposes a betrayal. Aaron Payne L. was a Moorish adept, attorney and graduate of the prestigious University of Chicago School of Law. This was surely not an error, for all adepts know that the true race of the Moors is Asiatic, and not black, see key number 90. After the Prophet passed form, the faithful Moors set out to murder Aaron Payne L. for treason. His home was protected by none other than the Chicago City Police. Police protection and or close relations is the telltale sign of a covert agent provocateur. The same corrupt Chicago Police Department that was responsible for the false arrest and abuse of Prophet Noble Drew Ali, was now protecting the man, Aaron Payne, who blatantly labeled the Prophet Noble Drew Ali a Negro posthumously, i.e. black. American necessarily means Negro in law according to Black's Law Dictionary 4th edition. Because Noble Drew Ali was a mastermind, he had given definitive assignments to several of his faithful Moors, and many today are still trying to figure out what is clear to the clairvoyant. But Allah reveals truth to whom He will. Time is also the best revealer, and Emile L., also an attorney, proved to be a faithful Moor in that he kept records that allowed the new Moors to find the breadcrumbs left by the Prophet. Elijah Poole Bey could often be found on the front row of Prophet Noble Drew Ali's temple meetings feverishly taking notes. He was very humble, soft-spoken, quiet, and most studious. Because of his demeanor, Noble Drew Ali gave him the assignment of keeping Islam alive in name and creed for the Moors, who were about to take yet another fall due to infighting and betrayal. Bro Poole Bey discarded Moorish nationality altogether and altered the racial aspect of the Prophet's teachings and began to refer to the Moors as the Asiatic black man, a misnomer. He also took on the name Elijah Muhammad, because he himself was to carry the torch of Islam as a reminder of our ancient creed. Elijah Muhammad gave his most trusted divine minister the title Bey. He is still alive today and is known as Brother Lucius Bey. Lucius equals Roman prenomen, or given name, which was derived from Latin lux light. Minister Lucius Bey is known as the Dean of the Honorable Elijah Muhammad's ministers in the nation of Islam, and with good reason. He also gave his most famous member Cassius Clay the title Muhammad Ali, and with good reason. He knew the truth. http://www.house.state.pa.us/rtkl/rtkl-for-1933HR75.pdf. Charles Mosley Bey A/K/A/CM Bey was a prominent Cleveland attorney who was under the jurisdiction of subordinate Temple No. 7, where Bro Childs Bey was the governor. CM Bey was so exceptional and proficient in law, he was barred from wearing his fez unlawfully by a judge in Ohio due to prejudice. This ultimately kept him from attending the court proceeding and was his only loss in the case of Ahmed L.A/K/Atonelli. Noble Drew Ali had assigned CM Bey with keeping Moorish sovereignty and autonomy alive and well, and that alone from a jurisprudence standpoint. As obedience is far better than sacrifice, Bro CM Bey later filed a copyrighted document in the Library of Congress in 1947 coded for the United States Title Code 22, Chapter 2, and Section 141 under judicial protection. He also recorded the tax immune Diplomatic status of the Moors in conjunction with the proper protection, afforded them via the MFN clause and the 1947 treaty between Italy i.e. Rome and the U.S.A number. Remember, Noble Drew Ali said, "I brought you everything it takes. To save a nation, take it and save yourself." See https://www.loc.gov/law/help/us treaties/bevins/must00004-03111.pdf. 5 years after this occurrence, the Nationality Act of 1952 was passed by the U.S. corporation, which unconstitutionally deprived individuals of prior nationality, stripping Moorish nationality from the Moors yet again, prevented them from taking advantage of their birthright tax immunity, property tax exemption, and political rights associated with citizenship of another state. Moroccan Empire, the Library of Congress filing of CM Bey was a huge blow to the European oligarchy occupying the land of the Moors as trustees of the U.S. corporation. It was also a huge blow to the dirty Moors who betrayed Noble Drew Ali and his teachings. CM Bey's full volume set includes information on Moorish nationality and Islamism as our original creed. It rebukes religion and also includes a nationality card, tax exempt affidavits, and other useful information absent from today's temples. It does not, however, include information on Prophet Noble Drew Ali or name him in any way. This was by design as Allah is the greatest of planners. The Nationality Act of 1952 was ultimately overturned by none other than the Supreme Court. Charles Kirkman Bey accompanied Noble Drew Ali in 1928 to Havana, Cuba, and attended the Convention on Private International Law where he was given the land mandate for the Americas. Kirkman Bey, his personal interpreter, is said to have spoken 92 languages. Well, this is codex by the adepts to indicate that Kirkman Bey was indeed a traitor and double agent. I.e. Key 92 of the Moorish Questionnaire 101s, Q. What title does Satan give himself? A. God. They. Number 92 is the numerical value of the Hebrew word Jachin according to Abelio, one of the two columns of the Temple of Solomon, the other being Boaz. 1K7,21, according to the Bible, Boaz and Jachin were two copper, brass or bronze pillars which stood in the porch of Solomon's temple, the first temple in Jerusalem. Jachin and Boaz, Hebrew. Two pillars which were set up in front of the sanctuary in Solomon's temple in Jerusalem. This is veiled symbolism for Moors who are awakened. According to Ohio State and County records, subordinate Temple No. 7 under the governance of Bro Childs Bey was sold to Standard Oil Company after the Prophet's transition in 1929, and a new entity was created, i.e. the Moorish Science Temple of America Inc. C. Kirkman Bey made unlawful changes as far as incorporating a separate entity from what the Prophet established in his 1928 Cook County affidavit. He also placed the title Sultan on his red fez, which was against Prophet Noble Drew Ali's instructions. The Freedom of Information Act requests also uncovered the fact that Colonel C. Kirkman Bey was also an informant for the FBI, put in place to deliver information on the Moorish movement and counteract its potency. The only full volume set left in the world of CM Bey's work, Clock of Destiny full volume set, is in the custody of the University of Denver Law Library. The former head professor of law, Dean Martin J. Katz, had it checked out as of the year 2012. This had been kept privately in his personal library for at least 5 years. The University of Denver has recently appointed Bruce Smith, J.D., Ph.D., as Dean of its Sturm College. Greetings of peace. Thank you for your interest and activity, however, the universe thanks you more. Nationality is not really a process except for if and when it starts in the mind, as you now already know, if you didn't before. It has apparently awakened in you, thus declaring it is to be clear yourself and does not necessarily require any paperwork, but does require study to be clear yourself, as you can only be what you know. Proclaiming is the publishing, and that is where the paperwork comes in. Anything in written form is but a brief expressing your position regarding a matter, whatever that matter may be, and that includes the card itself, which is a brief and lawful claim. These cards, whether obtained separately or all at one time, are not a sovereignty package, or a part of a sovereignty package. They are identification cards. We do not sell sovereignty, it is not for sale. We deal with birthrights, natural rights, liberties that come from the sheer act of being born. It is very interesting that if anyone were to get an identification and a driver's license and a school ID from a corporation, or any institution, they do not call it a sovereignty package. MMM GR_TNMGN Nimis Friday _N. Since the date of the letter which the late Congress, by their President, addressed to your Imperial Majesty, the United States of America have thought proper to change their government and institute a new one, agreeable to the Constitution, of which I have the honor, herewith, to enclose a copy. The time necessarily employed in the arduous task, and the disarrangements occasioned by so great though peaceable a revolution, will apologize, and account for your Majesty's not having received those regularly advised marks of attention from the United States which the friendship and magnanimity of your conduct toward them afforded reason to expect. The United States, having unanimously appointed me to supreme executive authority in this nation. Your Majesty's letter of August 17, 1788, which by reason of the dissolution of the late government, remained unanswered, has been delivered to me. I have also received the letters which your Imperial Majesty has been so kind as to write, in favor of the United States, to the Bashahs of Tunis and Tripoli, and I present to you the sincere acknowledgements and thanks of the United States for this important mark of your friendship for them. We greatly regret the hostile disposition of those regencies toward this nation, who have never injured them, is not to be removed, on terms of our power to comply with. Within our territories there are no mines, whether of gold or silver, and this young nation, just recovering from the waste and dissolution of a long war, have not, as yet, had time to acquire riches by agriculture and commerce. But our soil is bountiful, and our people industrious, and we have reason to flatter ourselves that we shall gradually become useful to our friends. The encouragement which your Majesty has been pleased, generously, to give to our commerce with your dominions, the punctuality with which you have caused the treaty with us to be observed, and the just and generous measures taken in the case of Captain Proctor, make a deep impression on the United States and confirm their respect for and attachment to your Imperial Majesty. It gives me great pleasure to have the opportunity of assuring your Majesty that, while I remain at the head of this nation, I shall not cease to promote every measure that may conduce to the friendship and harmony which so happily subsist between your empire and them, and shall esteem myself happy in every occasion of convincing your Majesty of the high sense, which in common with the whole nation, I entertain the magnanimity, wisdom, and benevolence of your Majesty. May the Almighty bless your Imperial Majesty, our great and magnanimous friend, with his constant guidance and protection. Maryland, Baltimore County, August 19, 1791. Sir, I am fully sensible of the greatness of that freedom, which I take with you on the present occasion, a liberty which seemed to me scarcely allowable, when I reflected on that distinguished and dignified station in which you stand, and the almost general prejudice and prepossession, which is so prevalent in the world, against those of my complexion. I suppose it is a truth too well attested to you, to need a proof here, that we are a race of beings, who have long labored under the abuse and censure of the world, that we have long been looked upon with an eye of contempt, and and that we have long been considered rather as brutish than human, and scarcely capable of mental endowments. Sir, I hope I may safely admit, in consequence of that report which hath reached me, that you are a man far less inflexible in sentiments of this nature, than many others, that you are measurably friendly, and well disposed towards us, and that you are willing and ready to lend your aid and assistance to our relief, from those many distresses, and numerous calamities, to which we are reduced. Now sir, if this is founded in truth, I apprehend you will embrace every opportunity, to eradicate that train of absurd and false ideas and opinions, which so generally prevails with respect to us, and that your sentiments are concurrent with mine, which are, that one universal Father hath given being to us all, and that he hath not only made us all of one flesh, but that he hath also, without partiality, afforded us all the same sensations and endowed us all with the same faculties, and that however variable we may be in society or religion, however diversified in situation or color, we are all of the same family, and stand in the same relation to him. Sir, if these are sentiments of which you are fully persuaded, I hope you cannot but acknowledge, that it is the indispensable duty of those who maintain for themselves the rights of human nature, and who possess the obligations of Christianity, to extend their power and influence to the relief of every part of the human race, from whatever burden or oppression they may unjustly labor under, and this, I apprehend, a full conviction of the truth and obligation of these principles should lead all to. Sir, I have long been convinced, that if your love for your Maryland, Baltimore County, August 19, 1791, selves, and for those inestimable laws, which preserved to you the rights of human nature, was founded on sincerity, you could not but be solicitous, that every individual, of whatever rank or distinction, might with you equally enjoy the blessings thereof, neither could you rest satisfied short of the most active effusion of your exertions, in order to their promotion from any state of degradation, to which the unjustifiable cruelty and barbarism of men may have reduced them. Sir, I freely and cheerfully acknowledge, that I am of the African race, and in that color which is natural to them of the deepest dye, and it is under a sense of the most profound gratitude to the Supreme Ruler of the universe, that I now confess to you, that I am not under that state of tyrannical thraldom, and inhuman captivity, to which too many of my brethren are doomed, but that I have abundantly tasted of the fruition of those blessings, which proceed from that free and unequaled liberty with which you are favored, and which, I hope, you will willingly allow you have mercifully received, from the immediate hand of that Being, from whom proceedeth every good and perfect gift. Sir, suffer me to recall to your mind that time, in which the arms and tyranny of the British Crown were exerted, with every powerful effort, in order to reduce you to a state of servitude. Look back, I entreat you, on the variety of dangers to which you were exposed. Reflect on that time, in which every human aid appeared unavailable, and in which even hope and fortitude wore the aspect of inability to the conflict, and you cannot but be led to a serious and grateful sense of your miraculous end. th_at_rtil_s of at SSO O to /_R20 1774. We, His Majesty's most loyal subjects, the delegates of the several colonies of New Hampshire, Massachusetts Bay, Rhode Island, Connecticut, New York, New Jersey, Pennsylvania, the three lower counties of Newcastle, Kent, and Sussex on Delaware, Maryland, Virginia, North Carolina, and South Carolina, deputed to represent them in a Continental Congress, held in the city of Philadelphia, on the 5th day of September, 1774, avowing our allegiance to His Majesty, our affection and regard for our fellow subjects in Great Britain and elsewhere, affected with the deepest anxiety, and most alarming apprehensions, at those grievances and distresses, with which His Majesty's American subjects are oppressed, and having taken under our most serious deliberation, the state of the whole continent, find, that the present unhappy situation of our affairs is occasioned by a ruinous system of colony administration, adopted by the British Ministry about the year 1763, evidently calculated for enslaving these colonies, and, with them, the British Empire. In prosecution of which system, various acts of Parliament have been passed, for raising a revenue in America, for depriving the American subjects, in many instances, of the constitutional trial by jury, exposing their lives to danger, by directing a new and illegal trial beyond the seas, for crimes alleged to have been committed in America, and in prosecution of the same system, several late, cruel, and oppressive acts have been passed, respecting the town of Boston and the Massachusetts Bay, and also an act for extending the province of Quebec, so as to border on the western frontiers of these colonies, establishing an arbitrary government therein, and discouraging the settlement of British subjects in that wide extended country, thus, by the influence of civil principles and ancient prejudices, to dispose the inhabitants to act with hostility against the free Protestant colonies, whenever a wicked ministry shall choose so to direct them. To obtain redress of these grievances, which threaten destruction to the lives, liberty, and property of His Majesty's subjects, in North America, we are of opinion, that a non-importation, non-consumption, and non-exportation agreement, faithfully adhered to, will prove the most speedy, effectual, and peaceable measure, and, therefore, we do, for ourselves, and the inhabitants of the several colonies, whom we represent, firmly agree and associate, under the sacred ties of virtue, honor, and love of our country, as follows. 1. That from and after the 1st day of December next, we will not import, into British America, from Great Britain or Ireland, any goods, wares, or merchandise whatsoever, or from any other place, any such goods, wares, or merchandise, as shall have been exported from Great Britain or Ireland, nor will we, after that day, import any East India tea from any part of the world, nor any molasses, syrups, panels, coffee, or pimento, from the British plantations or from Dominica, nor wines from Madeira, or the Western Islands, nor foreign indigo. 2. We will neither import nor purchase any slave imported after the 1st day of December next, after which time, we will wholly discontinue the slave trade, and will neither be concerned in it ourselves, nor will we hire our vessels, nor sell our commodities or manufactures to those who are concerned in it. 3. As a non-consumption agreement, strictly adhered to, will be an effectual security for the observation of the non-importation, we, as above, solemnly agree and associate, that from this day, we will not purchase or use any tea, imported on account of the East India Company, or any on which a duty bath been or shall be paid, and from and after the 1st day of March next, we will not purchase or use any East India tea whatever, nor will we, nor shall any person for or under us, purchase or use any of those goods, wares, or merchandise, we have agreed not to import, which we shall know, or have cause to suspect, were imported after the 1st day of December, except such as come under the rules and directions of the 10th article hereafter mentioned. For the earnest desire we have not to injure our fellow subjects in Great Britain, Ireland, or the West Indies, induces us to suspend a non-exportation, until the 10th day of September, 1775, at which time, if the said acts and parts of acts of the British Parliament hereinafter mentioned, 8 not repealed, we will not directly or indirectly, export any merchandise or commodity whatsoever to Great Britain, Ireland, or the West Indies, except rice to Europe. 5 Such as are merchants, and use the British and Irish trade, will give orders, as soon as possible, to their factors, agents, and correspondents, in Great Britain and Ireland. Not to ship any goods to them, on any pretense whatsoever, as they cannot be received in America, and if any merchant, residing in Great Britain or Ireland, shall directly or indirectly ship any goods, wares, or merchandise, for America, in order to break the said non-importation agreement, or in any manner contravene the same, on such unworthy conduct being well attested, it ought to be made public, and, on the same being so done, we will not, from thenceforth, have any commercial connection with such merchant. 6. That such as are owners of vessels will give positive orders to their captains, or masters, not to receive on board their vessels any goods prohibited by the said non-importation agreement, on pain of immediate dismission from their service. 7. We will use our utmost endeavors to improve the breed of sheep, and increase their number to the greatest extent, and to that end, we will kill them as seldom as may be, especially those of the most profitable kind, nor will we export any to the West Indies or elsewhere, and those of us, who are or may become overstocked with, or can conveniently spare any sheep, will dispose of them to our neighbors, especially to the poorer sort, on moderate terms. 8. We will, in our several stations, encourage frugality, economy, and industry, and promote agriculture, arts, and the manufactures of this country, especially that of wool, and will discountenance and discourage every species of extravagance and dissipation, especially all horse racing, and all kinds of games, cock-fighting, exhibitions of shoes, plays, and other expensive diversions and entertainments, and on the death of any relation or friend, none of us, or any of our families will go into any further mourning dress, than a black crape or ribbon on the arm or hat, for gentlemen, and a black ribbon and necklace for ladies, and we will discontinue the giving of gloves and scarves at funerals. 9. Such as are vendors of goods or merchandise will not take advantage of the scarcity of goods that may be occasioned by this association, but will sell the same at the rates we have been respectively accustomed to do, for 12 months last past. And if any vendor of goods or merchandise shall sell such goods on higher terms, or shall, in any manner, or by any device whatsoever, violate or depart from this agreement, no person ought, nor will any of us deal with any such person, or his or her factor or agent, at any time thereafter, for any commodity whatever. 10. In case any merchant, trader, or other person, shall import any goods or merchandise, after the 1st day of December, and before the 1st day of February next, the same ought forthwith, at the election of the owner, to be either reshipped or delivered up to the committee of the country or town, wherein they shall be imported, to be stored at the risque of the importer, until the non-importation agreement shall cease, or be sold under the direction of the committee aforesaid, and in the last mentioned case, the owner or owners of such goods shall be reimbursed out of the sales, the first cost and charges, the profit, if any, to be applied towards relieving and employing such poor inhabitants of the town of Boston, as are immediate sufferers by the Boston Port Bill, and a particular account of all goods so returned, stored, or sold, to be inserted in the public papers, and if any goods or merchandises shall be imported after the said 1st day of February, the same ought forthwith to be sent back again, without breaking any of the packages thereof. 11. That a committee be chosen in every county, city, and town, by those who are qualified to vote for representatives in the legislature, whose business it shall be attentively to observe the conduct of all persons touching this association, and when it shall be made to appear, to the satisfaction of a majority of any such committee, that any person within the limits of their appointment has violated this association, that such majority do forthwith cause the truth of the case to be published in the Gazette, to the end, that all such foes to the rights of British America may be publicly known, and universally contemned as the enemies of American liberty, and thenceforth we respectively will break off all dealings with him or her. 12. That the Committee of Correspondence, in the respective colonies, do frequently inspect the entries of their custom houses, and inform each other, from time to time, of the true state thereof, and of every other material circumstance that may occur relative to this association. 13. That all manufactures of this country be sold at reasonable prices, so that no undue advantage be taken of a future scarcity of goods. 14. And we do further agree and resolve that we will have no trade, commerce, dealings, or intercourse whatsoever, with any colony or province, in North America, which shall not accede to, or which shall hereafter violate this association, but will hold them as unworthy of the rights of freemen, and as inimical to the liberties of their country. And we do solemnly bind ourselves and our constituents, under the ties aforesaid, to adhere to this association, until such parts of the several acts of Parliament passed since the close of the last war, as impose or continue duties on tea, wine, molasses, syrups, panels, coffee, sugar, pimento, indigo, foreign paper, glass, and painters' colors, imported into America, and extend the powers of the Admiralty courts beyond their ancient limits, deprive the American subject of trial by jury, authorize the judge's certificate to indemnify the prosecutor from damages that he might otherwise be liable to from a trial by his peers, require oppressive security from a claimant of ships or goods seized, before he shall be allowed to defend his property, are repealed, and until that part of the Act of the 12 Guaranis 3. Ch. 24, entitled An Act for the better securing His Majesty's dockyards, magazines, ships, ammunition, and stores, by which any persons charged with committing any of the offences therein described, in America, may be tried in any shire or county within the realm, is repealed, and until the 4 acts, passed the last session of Parliament, viz. That for stopping the port and blocking up the harbour of Boston, that for altering the charter and government of the Massachusetts Bay, and that which is entitled An Act for the better administration of justice, N.C. and that for extending the limits of Quebec, N.C. are repealed. And we recommend it to the provincial conventions, and to the committees in the respective colonies, to establish such farther regulations as they may think proper, for carrying into execution this association. The foregoing association being determined upon by the Congress, was ordered to be subscribed by the several members thereof, and thereupon, we have hereunto set our respective names accordingly. In Congress, Philadelphia, October 20, 1774. Signed, Peyton Randolph, President. Source: Journals of the Continental Congress 1774 to 1779. Edited from the original records in the Library of Congress. By Worthington Chauncey Ford, Chief, Division of Manuscripts. Washington, D.C., Government Printing Office, 1905. Action of Second Continental Congress, July 4, 1776. The unanimous declaration of the 13 United States of America. When in the course of human events, it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth, the separate and equal station to which the laws of nature and of nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. We hold these truths to be self-evident, that all men are created equal, that they evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. Life, liberty, and the pursuit of happiness, that to secure these rights, govern, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles, and organizing its powers in such form, as to them shall seem most likely to affect their safety and happiness. improve air safety and happiness. Denke, indeed, will dictate that governments long established should not be changed. For light and transient causes, and accordingly all experience hath shown, that mankind are more disposed to suffer, while evils are sufferable, than to right themselves, by abolishing the forms to which they are accustomed. But when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty, to throw off such government, and to provide new guards for their future security. Such has been the patient sufferance of these colonies, and such is now the necessity which constrains them to alter their former systems of government. The history of the present King of Great Britain is a history of repeated injuries and usurpations, all having in direct object the establishment of an absolute tyranny over these states. To prove this, let facts be submitted to a candid world. He has refused his assent to laws, the most wholesome and necessary for the public good. He has forbidden his governors to pass laws of immediate and pressing importance, unless suspended in their operation till his assent should be obtained, and, when so suspended, he has utterly neglected to attend to them. He has refused to pass other laws for the accommodation of large districts of people, unless those people would relinquish the right of representation in the legislature, a right inestimable to them, and formidable to tyrants only. He has called together legislative bodies at places unusual, uncomfortable, and distant from the depository of their public records, for the sole purpose of fatiguing them into compliance with his measures. He has dissolved representative houses repeatedly, for opposing with manly firmness his invasions on the rights of the people. He has refused for a long time, after such dissolutions, to cause others to be elected, whereby the legislative powers, incapable of the annihilation, have returned to the people at large for their exercise, the state remaining in the mean time exposed to all the dangers of invasion from without, and the convulsions within. He has endeavored to prevent the population of these states, for that purpose, obstructing the laws for naturalization of foreigners, refusing to pass others to encourage their migrations hither, and raising the conditions of new appropriations of lands. He has obstructed the administration of justice, by refusing his assent to laws for establishing judiciary powers. He has made judges dependent on his will alone, for the tenure of their offices, and the amount and payment of their The style of this confederacy shall be the United States of America. 2. Each state retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right, which is not by this confederation expressly delegated to the United States, in Congress assembled. 3. The said states hereby severally enter into a firm league of friendship with each other, for their common defense, the security of their liberties, and their mutual and general welfare, binding themselves to assist each other, against all force offered to, or attacks made upon them, or any of them, on account of religion, sovereignty, trade, or any other pretense whatever. 4. The better to secure and perpetuate mutual friendship and intercourse among the people of the different states in this Union, the free inhabitants of each of these states, paupers, vagabonds, and fugitives from justice excepted, shall be entitled to all privileges and immunities of free citizens in the several states, and the people of each state shall free ingress and regress to and from any other state, and shall enjoy therein all the privileges of trade and commerce, subject to the same duties, impositions, and restrictions as the inhabitants thereof respectively, provided that such restrictions shall not extend so far as to prevent the removal of property imported into any state, to any other state, of which the owner is an inhabitant, provided also that no imposition, duties or restriction shall be laid by any state, on the property of the United States, or either of them. If any person guilty of, or charged with, treason, felony, or other high misdemeanor in any State shall flee from justice, and be found in any of the United States, he shall, upon demand of the governor or executive power of the state from which he fled, be delivered up and removed to the state having jurisdiction of his offense. Full faith and credit shall be given in each of these states to the records, acts, and judicial proceedings of the courts and magistrates of every other state. To all to whom these presents shall come, we the undersigned delegates of the states affixed to our names send greeting. Articles of Confederation and Perpetual Union between the states of New Hampshire, Massachusetts Bay, Rhode Island and Providence Plantations, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia. V. For the most convenient management of the general interests of the United States, delegates shall be annually appointed in such manner as the legislatures of each state shall direct, to meet in Congress on the first Monday in November, in every year, with the power reserved to each state to recall its delegates, or any of them, at any time within the year, and to send others in their stead for the remainder of the year. No state shall be represented in Congress by less than 2, nor more than 7 members, and no person shall be capable of being a delegate for more than 3 years in any term of 6 years, nor shall any person, being a delegate, be capable of holding any office under the United States, for which he, or another for his benefit, receives any salary, fees, or emolument of any kind. Each state shall maintain its own delegates in a meeting of the states, and while they act as members of the Committee of the States. In determining questions in the United States in Congress assembled, each state shall have 1 vote. Freedom of speech and debate in Congress shall not be impeached or questioned in any court or place out of Congress, and the members of Congress shall be protected in their persons from arrests or imprisonments, during the time of their going to and from, and attendance on Congress, except for treason, felony, or breach of the peace. 6. No state, without the consent of the United States in Congress assembled, shall send any embassy to, or receive any embassy from, or enter into any conference, agreement, alliance or treaty with any king, prince, or state. Nor shall any person holding any office of profit or trust under the United States, or any of them, accept any present, emolument, office or title of any kind whatever from any king, prince, or foreign state, nor shall the United States in Congress assembled, or any of them, grant any title of nobility. No 2 or more states shall enter into any treaty, confederation, or alliance whatever between them, without the consent of the United States in Congress assembled, specifying accurately the purposes for which the same is to be entered into, and how long it shall continue. No state shall lay any imposts or duties, which may interfere with any stipulations in treaties entered into by the United States in Congress assembled, with any king, prince, or state, in pursuance of any treaties already proposed by Congress, to the courts of France and Spain. No vessel of war shall be kept up in time of peace by any state, except such number only, as shall be deemed necessary by the United States in Congress assembled, for the defense of such state, or its trade, nor shall any body of forces be kept up by any state in time of peace, except such number only, as in the judgment of the United States in Congress assembled, shall be deemed requisite to garrison the forts necessary for the defense of such state, but every state shall always keep up a well-regulated and disciplined militia, sufficiently armed and accoutred, and shall provide and constantly have ready for use, in public stores, a due number of filed pieces and tents, and a proper quantity of arms, ammunition, and camp equipage. No state shall engage in any war without the consent of the United States in Congress assembled, unless such state be actually invaded by enemies, or shall have received certain advice of a resolution being formed by some nation of Indians to invade such state, and the danger is so imminent as not to admit of a delay till the United States in Congress assembled can be consulted, nor shall any state grant commissions to any ships or vessels of war, nor letters of marque or reprisal, except it be after a declaration of war by the United States in Congress assembled, and then only against the kingdom or state and the subjects thereof, against which war has been so declared, and under such regulations as shall be established by the United States in Congress assembled, unless such state be infested by pirates, in which case vessels of war may be fitted out for that occasion, and kept so long as the danger shall continue, or until the United States in Congress assembled shall determine otherwise. 7. When land forces are raised by any state for the common defense, all officers of or under the rank of colonel shall be appointed by the legislature of each state respectively, by whom such forces shall be raised, or in such manner as such state shall direct, and all vacancies shall be filled up by the state which first made the appointment. 8. All charges of war, and all other expenses that shall be incurred for the common defense or general welfare, and allowed by the United States in Congress assembled, shall be defrayed out of a common treasury, which shall be supplied by the several states in proportion to the value of all land within each state, granted or surveyed for any person, as such land and the buildings and improvements thereon shall be estimated according to such mode as the United States in Congress assembled shall from time to time direct and appoint. The taxes for paying that proportion shall be laid and levied by the authority and direction of the legislatures of the several states within the time agreed upon by the United States in Congress assembled. 9. The United States in Congress assembled shall have the sole and exclusive right and power of determining on peace and war, except in the cases mentioned in the 6th article of sending and receiving ambassadors entering into treaties and alliances, provided that no treaty of commerce shall be made whereby the legislative power of the about intercedere divina. The Church Bulla of 1493 AD. Divina is a password used by most European colonist descendants, who have overthrown, settled, or occupied other lands or countries. Divina, in most instances, appears unthreatening to the unknowing ear, when Europeans find cause to refer to their pseudo-religious doctrine, which is politically and socially inculcated with terse policies and regulatory constructs. However, it must be noted and brought to the attention of all Aboriginal natural peoples, that Divina was, and is, used as a war reference and control guide point for colonial Inquisition operations in North America. The formal name of the Divina doctrine of Christianity is Intercedere Divina. Its origin is from Pope Alexander VI, one of many iconic social/political/religious representative vicars dedicated to policies for world dominance. The Germanic form or word, God/Guth/Good/God, was introduced to the world during the Middle Ages, which is the period of European history that divides ancient and modern times, being 500 AD to 1450 AD. The naive converts among the Aboriginals, who have naively accepted their teachings, are deceived by the propagated beliefs that the Christians were embracing ideas of a universal creator, or supreme being, overflowing with teachings of filial and universal love, etc. Little did the convertios know that, in reality, Divina, from the European colonial conquest mindset, is an institutionalized religious, war-sanctioned tool, justifying genocide, rape, theft, sadistic human oppression, land thefts. With the advent of the Spanish Inquisition, Inquisitio, the maxims of inflicting creative forms of human torture, drowning, burnings, skinning, mutilations, death, and other horrors, became as normal to justified Christendom supremacy culture as their penchant for highly stylized rituals of prayer. These same self-righteous, self-appointed merchants of godliness, are also the supreme masters of sadism. The Aboriginal, natural peoples of the planet have suffered more deaths, slavery, artificially induced diseases, and other sadistic mistreatments, at the hands of these pseudo-religious propagandists, than by that of the most vile and deviant soldiers amongst the known military armies of the world. About the Willie Lynch Letter 1712. The Willie Lynch Letter, which is pseudonymous with Roman conquest culture, is adopted for social/political interfacings and interchagnies with Aboriginal and Indigenous peoples. Theory is the epitome of Roman/European colonial psychic warfare methodologies. It encapsulates the social and political aims of Christendom, in its economic, social, and political relationships to the suppressed and branded descendants of the fallen Asiatic Moorish Empire, and sets the standards for the means and attitudes to be taken, artificially maintained, and practiced by the dominant European colonialists occupying the Americas, particularly North America. Many sociologists and social engineers in North America have referred to the Willie Lynch Letter AD and its characteristics merely as a theory. However, a theory means a thought, a viewing or mental contemplation as distinguished from an actual action or doing. It must be determined by the reader or student of history and experience whether or not what is mentioned in the Willie Lynch Letter has manifested in North American servitude activities or not. If such activities and culture have manifested in slave culture in North America, then it cannot be a theory. Gentlemen, I greet you here on the bank of the James River in the year of our Lord, 1712. First, I shall thank you, the gentlemen of the colony of Virginia, for bringing me here. I am here to help you solve some of your problems with slaves. Your invitation reached me on my modest plantation in the West Indies, where I have experimented with some of the newest and still the oldest methods for control of slaves. Ancient Rome would envy us if my program is implemented. As our boat sailed south on the James River, named for our illustrious King James, whose Bible we cherish, I saw enough to know that your problem is not unique. While Rome used cords of wood as crosses for standing human bodies along the old highways in great numbers, you are here using the tree and the rope on occasion. I caught the whiff of a dead slave hanging from a tree a couple of miles back. You are not only losing valuable stock by hangings, you are having uprisings, slaves are running away, your crops are sometimes left in the fields too long for maximum profit, you suffer occasional fires, your animals are killed. Gentlemen, you know what your problems are, I do not need to elaborate. I am not here to enumerate your problems, I am here to introduce to you to a method of solving them. In my bag here, I have a foolproof method for controlling your black slaves. I guarantee every one of you that if installed correctly it will control the slaves for at least 300 years. My method is simple, any member of your family or any overseer can use it. I have outlined a number of differences among the slaves, and I take these differences and make them bigger. I use fear, distrust, and envy for control purposes. These methods have worked on my modest plantation in the West Indies, and it will work throughout the South. Take this simple little list of difference and think about them. On the top of my list age, but it is there because it only starts with an A. The second is color or shade, there is intelligence, size, sex, size of plantations, attitude of owners, whether the slaves living in the valley, on a hill, east, west, north, south, have fine or coarse hair, or is tall or short. Now that you have a list of differences, I shall give you an outline of action, but before that, I shall assure you that distrust is stronger than trust, and envy is stronger than adulation, respect, or admiration. The black slave, after receiving this indoctrination, shall carry on and will become self-refueling and self-generating for hundreds of years, maybe thousands. Don't forget, you must pitch the old black versus the young black male, and the young black male against the old black male. You must use the dark skin slaves versus the light skin slaves, and the light skin slaves versus the dark skin slaves. You must use the female versus the male, and the male versus the female. You must also have your servants and overseers distrust all blacks, but It is necessary that your slaves trust and depend on us. They must love, respect and trust only us. Gentlemen, these kits are your keys to control, use them. Have your wives and children use them. Never miss opportunity. My plan is guaranteed, and the good thing about this plan is that if used intensely for 1 year, the slaves themselves will remain perpetually distrustful. About the Christian Black Codes of 1724. The Christian Black Codes of 1724 are the resulting list of 54 Christian protocols and acts, written to augment and institutionalize the William Lynch theories of suppression and control methodologies. These socialization tools are generally referred to as the Black Codes. Article 1. Decrees the expulsion of the Jews from the colony. Article 2. Make it imperative on masters to impart religious instruction to their slaves. Article 3. Permits the exercise of the Roman Catholic Creed only, every other mode of worship is prohibited. Article 4. Negroes placed under the direction or supervision of any other person than a Catholic, are liable to confiscation. Article 5. Sundays and holidays are to be strictly observed. All Negroes found at work on these days are to be confiscated. Article 6. We forbid our white subjects, of both sexes, to marry with the blacks, under penalty of being fined and subjected to some other arbitrary punishment. We forbid all curates, priests, or missionaries of our secular or regular clergy and even our chaplains in our navy, to sanction such marriages. We also forbid all our white subjects, and even the manumitted or freeborn blacks, to live in a state of concubinage with slaves. Should there be any issue from this kind of intercourse, it is our will that the person so offending, and the master of the slave should pay each fine of 300 livres. Should said issue be the result of concubinage of the master, his slave, said master shall not only pay the fine, but be deprived of the slave and of the children, who shall be adjudged to the hospital of the locality, and said slave shall be forever incapable of being set free. But shall this illicit intercourse have existed between a free black and his slave, when said slave according to the forms prescribed by the Church, said slave shall thereby set free and the children shall become free and legitimate, and in such a case there shall be no application of the penalties mentioned in the present article. Article 7. The ceremonies and forms prescribed by the Ordinance of Blois and by the Edict of 1691, for marriage, shall be observed both with regard to free persons and slaves. But the consent of the father and mother of the slave is not necessary, that of the master shall be the only on required. Article 8. We forbid all curates to process or to effect marriages between slaves without the proof of the consent of their master, and we also forbid all masters to force their slaves into marriages against their wills. Article 9. Children, issued from the marriage of slaves shall follow the condition of their parents, and shall belong to the master of the wife and not of the husband, if the husband and the wife have different masters. Article 10. If the husband be a slave, and the wife a free woman, it is our will that their children, of whatever sex they be, shall share the condition of their mother, and be as free as she, notwithstanding the servitude of their father, and if the father be free and the mother a slave, then the children shall all be slaves. Article 11. Master shall have their Christian slaves buried in consecrated ground. Article 12. We forbid slaves to carry offensive weapons or heavy sticks under the penalty of being whipped, and of having said weapons confiscated for the benefit of the person seizing he same. An exception is made in favor of those slaves who are hunting or are shooting for their masters, and who carry with them a written permission to that effect, or are being designated by some known mark or badge. Article 13. We forbid slaves belonging to different masters to gather in crowds either by day or by night, under the pretext of a wedding, or for any other cause, either at the dwelling or on the grounds. of one of their masters, or elsewhere, and much less on the highways or in secluded places, under the penalty of corporal punishment, which shall not be less than a whip. In case of frequent offences of the kind, the offenders shall be branded with the mark of the flower de luce, and, should there be aggravating circumstance, capital punishment may be applied, at the discretions of the judges. We command all of our subjects, be they officials or not, to seize all such offenders, to arrest and conduct them to prison, although there should be not. About the United Nations, UN. The Aboriginal and Indigenous Natural Peoples, Moors, of North America, and of the world, have a vested interest in knowing about, learning about, and preserving their unalienable rights, substantive rights, and birthrights. Particular emphasis must be put on the fact that European colonist demo operations are constantly violating Constitution principles and international law. Officers, politicians, and policemen, etc., are repeatedly breaking the laws of nations, in order to effectuate their color of law practices of stealing the birthrights of the natural peoples of the land, particularly those of the Moorish Americans, who have been branded as Negroes, Blacks, Coloreds, West Indians, Latinos, etc. The United Nations, being the nation members, listed below, in agreed unity of law, deals with matters of human rights, supports and violations, and issues such proclamations of law, concerning these issues, through, and from, the General Assembly. People from different nations may, from time to time, file violation claims or complaints, etc., by way of the World Court, an organ of the United Nations. Therefore, it is incumbent upon active Moors, and all true American citizens, to be aware of the six different organs of the United Nations and of their general purposes and functions. About the Universal Declaration of Human Rights 1948. Whereas recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. Whereas disregard and contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind, and the advent of a world in which human beings shall enjoy freedom of speech and belief and freedom from fear and want has been proclaimed as the highest aspiration of the common people. Whereas it is essential, if man is not to be compelled to have recourse, as a last resort, to rebellion against tyranny and oppression, that human rights should be protected by the rule of law. Adopted and proclaimed by General Assembly Resolution 217A, 3, of December 10, 1948. On December 10, 1948, the General Assembly of the United Nations adopted and proclaimed the Universal Declaration of Human Rights, the full text of which appears in the following pages. Following this historic act, the Assembly called upon all member countries to publicize the text of the Declaration and to cause it to be disseminated, displayed, read, and expounded principally in schools and other educational institutions, without distinction based on the political status of countries or territories. Preamble. Whereas recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. Whereas disregard and contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind, and the advent of a world in which human beings shall enjoy freedom of speech and belief and freedom from fear and want has been proclaimed as the highest aspiration of the common people. Whereas it is essential, if man is not to be compelled to have recourse, as a last resort, to rebellion against tyranny and oppression, that human rights should be protected by the rule of law. Whereas it is essential to promote the development of friendly relations between nations. Whereas the peoples of the United Nations have in the Charter reaffirmed their faith in fundamental human rights, in the dignity and worth of the human person and in the equal rights of men and women, and have determined to promote social progress and better standards of life and larger freedom. Whereas member states have pledged themselves to achieve, in cooperation with the United Nations, the promotion of universal respect for and observance of human rights and fundamental freedoms. whereas a common understanding of these rights and freedoms is of the greatest importance for the full realization of this pledge. Now, therefore, the General Assembly proclaims this Universal Declaration of Human Rights as a common standard of achievement for all peoples and all nations, to the end that every individual and every organ of society, keeping this declaration constantly in mind, shall strive by teaching and education to promote respect for these rights and freedoms, and by progressive measures, national and international, to secure their universal and effective recognition and observance, both among the peoples of member states themselves and among the peoples of territories under their jurisdiction. Article 1. Article 1. All human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. Article 2. Article 2. Everyone is entitled to all the rights and freedoms set forth in this declaration, without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. Furthermore, no distinction shall be made on the basis of the political, jurisdictional, or international status of the country or territory to which a person belongs, whether it be independent, trust, non-self-governing, or under any other limitation of sovereignty. Article 3. Article 3. Everyone has the right to life, liberty, and security of person. Article 4. Article 4. No one shall be held in slavery or servitude. Slavery and the slave trade shall be prohibited in all their forms. Article 5. Article 5. No one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. Article 6. Article 6. Everyone has the right to recognition everywhere as a person before the law. Article 7. Article 7. All are equal before the law and are entitled without any discrimination to equal protection of the law. All are entitled to equal protection against any discrimination in violation of this declaration and against any incitement to such. About the Declaration of Rights of Child. Preamble from the United Nations 1959. Whereas the peoples of the United Nations have, in the Charter, reaffirmed their faith in fundamental human rights and in the dignity and worth of the human person, and have determined to promote social progress and better standards of life and larger freedom. Whereas the United Nations has, in the Universal Declaration of Human Rights, proclaimed that everyone is entitled to all the rights and freedoms set forth therein, without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. Preamble. Whereas the peoples of the United Nations have, in the Charter, reaffirmed their faith in fundamental human rights and in the dignity and worth of the human person, and have determined to promote social progress and better standards of life and larger freedom. Whereas the United Nations has, in the Universal Declaration of Human Rights, proclaimed that everyone is entitled to all the rights and freedoms set forth therein, without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. Whereas the child, by reason of his physical and mental immaturity, needs special safeguards and care, including appropriate legal protection, before as well as after birth. Whereas the need for such special safeguards has been stated in the Geneva Declaration of the Rights of the Child of 1924, and recognition of the rights of the child of 1924d in the Universal Declaration of Human Rights and in the statutes of specialized agencies and international organizations concerned with the welfare of children. Whereas mankind owes to the child the best it has to give, now therefore, the General Assembly proclaims this Declaration of the Rights of the Child to the end that he may have a happy childhood and enjoy for his own good and for the good of society the rights and freedoms herein set forth, and calls upon parents, upon men and women as individuals, and upon voluntary organizations, local authorities, and national governments to recognize these rights and strive for their observance by legislative and other measures progressively taken in accordance with the following principles. IPLs. Principle I. The child shall enjoy all the rights set forth in this declaration. Every child, without any exception whatsoever, shall be entitled to these rights, without distinction or discrimination on account of race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status, whether of himself or of his family. Principle 2. The child shall enjoy special protection, and shall be given opportunities and facilities, by law and by other means, to enable him to develop physically, mentally, morally, spiritually, and socially in a healthy and normal manner and in conditions of freedom and dignity. In the enactment of laws for this purpose, the best interests of the child shall be the paramount consideration. Declaration of the Rights of the Child, GA-Res. 1386, 14 UN. GAOR Sup. Number 16, at 19, UN Doc. A/4354, 1959. Principle 3. The child shall be entitled from his birth to a name and a nationality. Principle 4. The child shall enjoy the benefits of Social Security. He shall be entitled to grow and develop in health. To this end, special care and protection shall be provided both to him and to his mother, including adequate prenatal and postnatal care. The child shall have the right to adequate nutrition, housing, recreation, and medical services. Principle 5. The child who is physically, mentally, or socially handicapped shall be given the special treatment, education and care required by his particular condition. Principle 6. The child, for the full and harmonious development of his personality, needs love and understanding. He shall, wherever possible, grow up in the care and under the responsibility of his parents, and, in any case, in an atmosphere of affection and of moral and material security. A child of tender years shall not, save in exceptional circumstances, be separated from his mother. Society and the public authorities shall have the duty to extend particular care to children without a family and to those without adequate means of support. Payment of state and other assistance towards the maintenance of children of large families is desirable. Principle 7. The child is entitled to receive education, which shall be free and compulsory, at least in the Aboriginal Lihitlahi. This page contains vital holistic information regarding natural health. It gives close attention to the diseases that now plague the Aboriginal and Indigenous natural peoples of North America, and the world. These maladies are due to their adopted practices of consuming the wrong foodstuffs. Health is to the body as the spirit is to the soul. Noble Drew Alley. This page will be navigated by Sister Anand L., who gives poignant lessons on health. See weekly calendar page. Anand demonstrates how to eat to live, and how not to eat and live an improved and higher quality of life. The Declaration of the Rights of the Child of 1959. GA-Res. 1386, 14 UN GAOR Sup. Number 16, at 19, U.N.Doc A/4354, 1959. Article 24. Indigenous peoples have the right to their traditional medicines and health practices, including the right to the protection of vital medicinal plants, animals, and minerals. They also have the right to access, without any discrimination, to all medical institutions, health services, and medical care. Immunization. Forced poisoning. It is your unalienable, constitutionally secured right, to refuse to be injected with poison. No alleged government can, under threat, duress, or coercion, and trickery, force, or compel you to do otherwise. One must be conscious of the fact that there exists the intent to reduce the population, particularly of the Aboriginal and Indigenous peoples. Many of these immunizations are designed to take effect later, bringing numerous medical challenges, including death. They are designed to take effect later to trick the people into not connecting the illness/death to the immunization injection/process. Usually informing them that you and/or your child will not be participating in vaccinations because it is against your religion, has been sufficient. However, if it becomes necessary to lawfully document your position, you may utilize the below writ. The Moorish National Republic. The Moorish Divine and National Movement of the World. Aboriginal and Indigenous Natural Peoples of Northwest Amaxime, North America. Affidavit of Fact. Unlawful Demand of Immunization. February 22, 2011. For the record, on the record, and let the record show, I am Free National Name, a Moorish American National Aboriginal, Indigenous Natural Divine Being manifested in human flesh to the Americas, in propria persona, sui juris, and not a nom de guerre, strawman or any other artificial corporate construct, as written or scribed in all capital letters and written by the unclean hands of others. I am sovereign to this land and preserve all my rights. It is against my religion, as protected by the United States Republic Constitution Article I of the Bill of Rights, to engage in any way with the immunization process. In addition, as immunization is a voluntary process, I therefore choose not to participate in the process. Any further discussion or any retaliation regarding my religion as it related to the immunization process will constitute a violation of my constitutional/treaty secured rights. The sole obligation of government, as stipulated in the United States Republic North American Constitution Article 4 Section 4, as a republican form of government is to secure, protect, and preserve the rights of the people domestically and internationally. Miranda v. Arizona, 384 U.S. 436, 1966, 491, 86 SCT 1603. Where rights secured by the Constitution are involved, there can be no rule-making or legislation which would abrogate them. Norton v. Shelby County, 118 U.S. 425 p. 442. An unconstitutional act is not law, it confers no rights, it imposes no duties, affords no protection, it creates no office, it is in legal contemplation, as inoperative as though it had never been passed. Notice to agent is notice to principal. Notice to principal is notice to agent. Affiant, free national name, ex-relationy straw name, a living, breathing, flesh and blood, natural being woman, do affirm that affiant has scribed and read the foregoing facts, and, in accordance with the best of affiant's first-hand knowledge and conviction, such are true, correct, complete, and not misleading, the truth, the whole truth, and nothing but the truth. In honor, I am authorized representative, natural person, in propria persona. All rights reserved. UCC 1-207/1-308, U.C.C.1-103. Connecticut Territory. C/O. CC, United Nations, United States Justice Department. Geneva, Switzerland, United States Attorney General Eric H. Holder. State of Connecticut Governor, International Criminal Court. Daniel P. Malloy, The Hague, the Netherlands. Witness. A free and sovereign Moorish American national, Northwest Amaxime/Africa/America. All rights reserved. Witness. A free and sovereign Moorish American national, Northwest Amaxime/Africa/America. All rights reserved. Drinking near sustenance. The Master Cleanse is not just for weight loss programs. Many have heard of the Master Cleanse drink, usually utilized when cleansing the body, however there are many who drink it all the time, as it has all the nutrients the body needs to sustain itself. All solid foods are broken down into liquids before the body can utilize any nutrients or anything of value from it. Thus, it is logical to simply put sustenance inside your body in the form of liquid in the first place. By doing so, it is less taxing on the digestive organs, as 35% of the body's energy is utilized when digesting solid foods. This is why it is advised not to swim after eating. Drinking your sustenance does not deplete the body of its energy. In fact, it offers instantaneous nutrients and instantaneous energy. The drink, commonly called the Master Cleanse, has important, life-sustaining ingredients. In the below article we will share those ingredients and their benefits and instructions to make the Master Cleanse yourself. The following report is done by Hamatil. The Lemonade Diet / Master Cleanse. The healing benefit of the elements in the lemon, cayenne pepper, and the maple syrup working together are as follows. It contains 49% potassium, which strengthens and energizes the heart, stimulates and builds the kidneys and adrenal glands. Oxygen, which builds vitality. Carbon acts as a motor stimulant. Hydrogen activates the sensory nervous system. Calcium strengthens and builds the lungs. Phosphorus knits the bones, stimulates and builds the brain for clearer thinking. Sodium encourages tissue building. Magnesium acts as a blood alkalizer. Iron builds the red corpuscles to rapidly correct the most common forms of anemia. Chlorine cleanses the blood plasma. Silicon aids the thyroid for deeper breathing. The lemon is the natural cleansing agent for the body, and the natural iron, copper, calcium, carbon, and hydrogen found in the grade B maple syrup, which acts as a natural sweetener, supplies more building and cleansing material. It truly is a perfect combination for cleansing, eliminating, healing, and building. The cayenne pepper has an expanded list of cross benefits to the body and is nicknamed the prince amongst all other herbs. Below is a complete nutritional breakdown of 1 tablespoon of cayenne pepper. DV equals daily value. Calories 17 kilocalories. Vitamin A 2185 IU, 44% DV. Vitamin C 4.0 milligrams, 7% DV. Vitamin E 1.6 milligrams, 8% DV. Niacin 0.5 milligrams, 2% DV. Vitamin B6 0.1 milligrams, 6% DV. Calcium, Ca 7.8 milligrams, 1% DV. Iron, Fe 0.4 milligrams, 2% DV. Magnesium, Mg 8.0 milligrams, 2% DV. Phosphorus, P 15.4 milligrams, 2% DV. Potassium, K 106 milligrams, 3% DV. Sodium, Na 1.6 milligrams, 0% DV. Zinc, Zn 0.1 milligrams, 1% DV. Copper 0.0 milligrams, 1% DV. Manganese 0.1 milligrams, 5% DV. Selenium 0.5 microgram, 1% DV. Health benefits of cayenne pepper. 1. Cayenne pepper and the heart. Cayenne pepper removes the plaque adhering to arteries and cleans them. You can help a person from suffering from a heart attack by giving him cayenne pepper in a cup of water. It supplies vital nutrients to the heart, raises the body temperature, improves blood circulation by thinning the blood, removes toxins from the blood and rebuilds blood cells. 2. Cayenne pepper and hypertension. Cayenne pepper helps to make blood pressure levels normal. It regulates the flow of blood from the head to the foot and equalizes blood pressure. It also equalizes blood pressure in the arteries and veins instantly. It removes blockages present in the arteries and thus, improves the flow of blood. Since cayenne pepper reduces the risk of atherosclerosis, it simultaneously lowers the risk of hypertension. 3. Cayenne pepper and cancer. The capsaicin in cayenne pepper has the ability to kill cancer cells. Cayenne pepper can therefore help in the treatment of leukemia and cancers of the lungs, pancreas, and prostate gland. Research shows that capsaicin causes cancer cells to kill themselves in a process known as apoptosis. 4. Cholesterol levels and cayenne pepper. Cayenne pepper rids the body of LDL, bad cholesterol. 5 digestive problems in cayenne pepper. Although cayenne pepper is spicy, it heals stomach and intestinal ulcers. It improves digestion by stimulating the peristaltic movement of the intestines. It heals digestive problems such as abdominal cramps, acidity, and gas. It also helps in the excretion of urine and feces. 6. Relief from arthritic pain. The capsaicin present in cayenne pepper works on the sensory nerves and relieves pain caused by rheumatism and arthritis. 7. Cayenne pepper and infections. Cayenne pepper has antifungal properties and can help you fight fungal infections. It's useful in treating respiratory infections such as sore throats. 8. Other benefits. Cayenne pepper has thermogenic properties, and putting it in shoes and socks is effective in preventing frostbite in extremely cold weather. Putting cayenne pepper powder directly into a bleeding wound can stop it from bleeding and will help the wound to heal without a scar or 1. Drinking your sustenance. The Master Cleanse is not just for weight loss programs. Many have heard of the Master Cleanse drink, usually utilized when cleansing the body. However, there are many who drink it all the time, as it has all the nutrients the body needs to sustain itself. All solid foods are broken down into liquids before the body can utilize any nutrients or anything of value from it. Thus, it is logical to simply put sustenance inside your body in the form of liquid in the first place. By doing so, it is less taxing on the digestive organs, as 35% of the body's energy is utilized when digesting solid foods. This is why it is advised not to swim after eating. Drinking your sustenance does not deplete the body of its energy. In fact, it offers instantaneous nutrients and instantaneous energy. The drink, commonly called the Master Cleanse, has important, life-sustaining ingredients. In the below article we will share those ingredients and their benefits and instructions to make the Master Cleanse yourself. The following report is done by Hamatil. The Lemonade Diet / Master Cleanse. The healing benefit of the elements in the lemon, cayenne pepper, and the maple syrup working together are as follows. It contains 49% potassium, which strengthens and energizes the heart, stimulates and builds the kidneys and adrenal glands. Oxygen, which builds vitality. Carbon acts as a motor stimulant. Hydrogen activates the sensory nervous system. Calcium strengthens and builds the lungs. Phosphorus knits the bones, stimulates and builds the brain for clearer thinking. Sodium encourages tissue building. Magnesium acts as a blood alkalizer. Iron builds the red corpuscles to rapidly correct the most common forms of anemia. Chlorine cleanses the blood plasma. Silicon aids the thyroid for deeper breathing. The lemon is the natural cleansing agent for the body, and the natural iron, copper, calcium, carbon, and hydrogen found in the grade B maple syrup, which acts as a natural sweetener, supplies more building and cleansing material. It truly is a perfect combination for cleansing, eliminating, healing, and building. The cayenne pepper has an expanded list of cross benefits to the body and is nicknamed the Prince amongst all other herbs. The following is a complete nutritional breakdown of 1 tablespoon of cayenne pepper. DV equals daily value. 2. Health benefits of cayenne pepper. 1. Cayenne pepper and the heart. Cayenne pepper removes the plaque adhering to arteries and cleans them. You can help a person from suffering from a heart attack by giving him cayenne pepper in a cup of water. It supplies vital nutrients to the heart, raises the body temperature, improves blood circulation by thinning the blood, removes toxins from the blood and rebuilds blood cells. 2. Cayenne pepper and hypertension. Cayenne pepper helps to make blood pressure levels normal. It regulates the flow of blood from the head to the foot and equalizes blood pressure. It also equalizes blood pressure in the arteries and veins instantly. It removes blockages present in the arteries and thus improves the flow of blood. Since cayenne pepper Reduces the risk of atherosclerosis. It simultaneously lowers the risk of hypertension. 3. Cayenne pepper and cancer. The capsaicin in cayenne pepper has the ability to kill cancer cells. Cayenne pepper can therefore help in the treatment of leukemia and cancers of the lungs, pancreas, and prostate gland. Research shows that capsaicin causes cancer cells to kill themselves in a process known as apoptosis. 4. Cholesterol levels in cayenne pepper. Cayenne pepper rids the body of LDL, bad cholesterol. 5. Digestive problems in cayenne pepper. Although cayenne pepper is spicy, it heals stomach and intestinal ulcers. It improves digestion by stimulating the peristaltic movement of the intestines. It heals digestive problems such as abdominal cramps, acidity and gas. It also helps in the excretion of urine and feces. 6. Relief from. About the editor of this page. Annette A.L. comes from a family of herbalists. At a very young age she was taught, by her grandmother, to identify, recognize, and use herbs as a natural method to keep the body in balance. She always had an affinity to spirituality, which inspired her search for truth. Her studious journey began, not unlike most held to servitude in North America, with the forced influences of Christianity. She, however, realized very quickly that she had outgrown the restraints of the colonial indoctrination, when she could not, after sincere inquiry, obtain sensible, additional information, likened to the profound fundamentals which her grandmother readily shared with her. She began studying many ancient philosophies and realized that what she was searching for was already within. The kingdom of heaven is within. Seek ye first the kingdom of heaven and all things will be added unto you. Today Annette's premise is, all is an illusion. We individually and collectively participate in creating our own individual and collective realities. Everything, at its most basic level, has one commonality: energy. Annette has always studied Moorish history and law, though in her earlier learnings was not always aware of it. This was due to the fact that many names and historical facts had been altered or changed to give the false impressions necessary for colonial rule. The outcome of such misprision created the false mental pictures that the ancient and modern culture influences were the history of some other people. Through her dedicated studies, she learned that much of what she had been taught as truth was actually false. Much of the allegorically hidden history, particularly that involving the natural peoples of North America, North American history, was actually a veiled version about her own ancient peoples, the mothers and fathers of civilization. The ancient ones knew of and taught about the treats of the earth. In instructional and obvious succession, they taught true civilization principles. Unfortunately, after inquisition and conquest, they and their descendants have fallen from grace. They now display disdain, disassociation, and disrespect of their former knowledge of nature's laws and of the study of self. Upon her inspired reawakening, she began a great purging of the incomplete teachings, and outright untruths. Her brave and determined will to learn assisted her in a fairly smooth transition to a higher consciousness. She demonstrates an astute consciousness to an effective body of concepts in regards to healthy living, and often prepares her foods through dehydration, including healthy pizza. She mostly drinks her food sustenance, instead of eating solids. She says, all food turns into liquid before the body can make use of it. The body has a more difficult task of digesting when trying to break down solids, particularly solids that are laden with unnatural chemicals and preservatives, as they cause tremendous hardship, strain, and damage to the body. The improper foods that we eat bring about high blood pressure, diabetes, cancer, early aging, etc. These unnatural conditions, in turn, become hereditations that are passed down to our children offspring, resulting in early deaths and diseases. Our latter years are coming much too quickly, and consequently our lifespans, and the lifespans of our progeny are diminishing. When our bodies are sick, by way of improper foods, it negatively affects our spirits, and the spirits of those around us. ANID's present mission and goal is that of moving towards a greater and more substantive knowledge of ourselves and our original existence, namely, breatharianism. Epidemics. Can you see the truth of it? By ANID L. September 14, 2006. FDA warning on serious foodborne E. coli 0157H7 outbreak. 1 death and multiple hospitalizations in one state. August 29, 2007. Bagged spinach recalled over salmonella fears. A California produce company recalled bagged fresh spinach Wednesday after it tested positive for salmonella. There were no immediate reports of illness linked to the tainted spinach, distributed by Metz Fresh LLC of King City, California. The recall comes nearly a year after an outbreak of another pathogen, E. coli, in fresh spinach killed 3 people and sickened another 200. June 6, 2008. Salmonella linked to tomatoes. The FDA and DCD first warned last week of dozens of people in 9 states who had gotten sick after eating certain types of raw, red tomatoes. Connecticut, April 24, 2009. 6 communities: Bloomfield, Windsor, Hartford, West Hartford, and parts of East Granby and Windsor Locks. Contaminants found in drinking water. Public advised to boil water, however contaminants are not harmful to people. April 27, 2009. Swine flu breakout linked to Mexico spreads to New York, California, Texas, Kansas, Ohio. What can we do? It seems every year there is a food epidemic. A food scare. What is going on? The better question to ask is, why are we so surprised? Aren't we aware that this is slow, methodical programming? Where is the information coming from? Do we actually know for sure if this is really happening based on what is being told to the public? Why are we so trusting, and why are we not being scientific about ourselves, our world, and our universe? One premise we all need to remember is, everything happens based on what we eat and breath. We may not always be able to control what we breath, however, if we discipline ourselves regarding what we eat, it will take care of what we may not be able to control in regards to what we breath. The first thing to remember is bacteria, germs, and parasites are our friends. We are supposed to be able to coexist with them. They in fact serve a purpose contrary to what is told and promoted. If we are eating foods that help to create a healthy body environment, which regenerates and repairs as it should, bacteria, germs, parasites, infections, and illness cannot and will not affect us, as it would not be possible. If you have a healthy body, you can be in the center of an epidemic and you will not be affected in any way whatsoever. If, however, you are not eating foods that are conducive to a healthy body, which includes healthy bone, muscle, and tissue, bacteria, germs, and parasites will appear to eat the unhealthy bone, muscle, and tissue, as this is their function. The human body creates hydrochloric acid. Hydrochloric acid is created during the process of food consumption. Its purpose is to kill any and all unnecessary bacteria, germs, and parasite that attempt to invade the body via the foods that we consume, hence the destruction of any harmful bacteria such as E. coli, salmonella, and worms. Hydrochloric acid in humans is very low because most of us eat the wrong foods. Our food source is supposed to be fruits and vegetables. Our bodies and the level of hydrochloric acid is not designed to destroy parasites that may be found in meat. This includes chicken and fish. Because we consume incorrect types of foods, usually in large amounts, many of us have little to no hydrochloric acid, which leaves us open to all sorts of bodily invasions. Not to mention our immune system is struggling to support us with no help from the foods we choose to consume. To assist with hydrochloric acid production, one item that can be added to the diet is cayenne pepper. Cayenne pepper will help the body adjust and improve its hydrochloric level. Although there are many herbs that assist in improving our body, if we implement a program of change, and continue to consume incorrect food, at some point those incorrect foods will outweigh the good of the herbs, and over time the effectiveness will decrease until there is no effect at all. Many people have changed to an intake of flesh consisting of only chicken and fish. Some of no flesh at all, or maybe a vegetable protein substitute with the continued consumption of grains, cereals, cooked foods, and continue consuming dairy products. You may want to reconsider all dairy products. Dairy products consist of extreme amounts of mucus. The milk of the cow contains large amounts of mucus for their calf. This is not designed for the human race, and consequently contributes to the breakdown of the immune system and ultimately the body. You may want to also reconsider or start a program to move away from protein substitutes, grains, and less sprouted, cereals, and cooked foods. What has been going on for quite some time now, is an attack on the immune system. Many things, in addition to food, break down the immune system, such as antibiotics, most all medications, drugs, and so-called immunizations. However, food is the number one source that we participate in with great enjoyment, disregard, and little thought. We have become so programmed that we no longer hear the voice inside us that tells us you shouldn't eat that. We miss or ignore the signs such as allergic reactions that tell us you shouldn't eat that. Unbeknownst to us, the universe is forcing us to make a change, now. Many of these epidemics are coming into existence because we are a programmed stubborn people, and we seem to only move when pain and suffering is present. It is a very bitter pill, however we must move back to knowledge of who and what we are, and what our body needs to function as the replica of the universe it is. Our body is our first temple, of which residing within it is our soul, thus it is Solomon's temple, soul of man's temple. We must make this acknowledgement and corrections now. Consider everything, and make changes accordingly while you still have the time to do so. A new paradigm is upon us, the climate and the vibration of the planet is changing. If our bodies are not healthy and in tune with the vibrations, we will not withstand the shift. A very wise man once said, "Discipline yourself, or you will be disciplined." The plea to the nation is also found on the About Noble Drew Alley page on this site. However, we put it here recently as an ancillary to the Sistars Standing on Law blog talk, as we recognize a plea to a nation or any nation is absolutely a plea to women because she comes here with the nation in her womb. This being done to wake up the mothers, daughters, sisters into recognizing their necessity of being involved in this movement and activity to hear the truth about nationality and birthrights, as both allude to women being involved, as she not only builds the body, temple, for the soul of man during the 40 weeks in her womb, she also is where one's nationality is determined from by nature, natural law and international law, supported by maxims of law. As society starts with family, so does the authority to govern family. As depicted on the cover of the 101 questionnaire, she is unconscious physically and her son is holding her until she wakes up. When she wakes up, the great meeting will be on. Test for those who participated in Sisters Standing on Law class. Comprehending the American National Constitution of 1790. For all those who listened to, studied, participated in the 13+1 month study of the American Constitution 1791 and would like to take the test for this series, you will need to download the below 1774 letter to the people of Great Britain and analyze it for all references made in the letter to the people of Great Britain that are embodied within the American Constitution 1791, consisting of the 7 Articles and 10 Bill of Rights and the 11th and 12th Bill of Rights reiterations. Once you have completed this, you will need to email it to mhhsayswideopen@gmail.com and put completed test in the subject line. Please know this is not something to rush, as the letter is extensive and the American Constitution of 1791 covers all violations of the liberties of the people. Good luck with this project. I trust it will be as exciting for you as it was for us. Peace and love. MHHS Eyes Wide Open. In association with RV Bay Publications, Moorish Nation Public Records, Moorish News. Case law in regards to waivers of right. Waivers of constitutional rights, not only must they be voluntary, they must be knowingly intelligent acts done with sufficient awareness. Brady v. U.S., 397 U.S. 742, 748. Note: This means you must either say on a record that you do in fact waive a right, or you must put it in written form stating the same. If you have not done either, then someone, somewhere is assuming you have. However, in law there are no assumptions. This is a good indication that who you may be dealing with, i.e. a so-called court of law, is not lawful. Instead they are using trickery and deceit and the fact that you have no knowledge of self or of law. If someone has made an assumption regarding you, you must clear that up as a matter of fact. In addition, if you are dealing with someone who says you cannot enter an affidavit, or that you must enter written documents on a certain size and type of paper, etc., then you must not allow that to occur either, as they are denying the law, taking jurisdiction over you and seeing if you are going to submit to their jurisdiction by doing what they tell you to do, and if you do, that means you do not know and you absolutely think they have a power and authority that they do not have. Their limited statutory jurisdiction simply does not apply to you, but only to their corporations, members, and employees. Any establishment, whether government or not, serves the people and cannot deny the people's rights while doing so. Wake up, you sleepy-headed Moors. Fraud. Fraud includes any intentional perversion of truth for the purpose of inducing another in reliance upon it to part with some valuable thing belonging to him or to surrender a legal right. A false representation of a matter of fact, which deceives and is intended to deceive another so that he shall act upon it to his legal injury. It consists of some deceitful practice of willful device, resorted to with intent to deprive another of his right, or in some manner to do him injury. Emphasis added. Black's Law Dictionary 5th edition, page 594. Click the below PDF for information in regards to fraud. It is also highly suggested that all mothers, daughters, and sisters read the Secret Book of John, also referred to as the Secret Revelation of John and the Apocryphon of John. It is important to acknowledge that most religious texts are writings of the ancient ones that have been adopted into various religious sects, without recognizing the source as the same, the ancient ones. The Secret Book of John can be found in a book, The Secret Teachings of Jesus, wherein there are 5 other books inside of it, none of which were included in the commonly utilized King James Version of the Bible, Biblios Heliotek, Record of the Son. We have provided it below in PDF format, 11 pages. It is in support of how and why the opening of the 7th seal is the awakening of woman and absolutely assist in concepts of creation and civilization in heaven and on earth. As above so below. Humanity is born and the child of humanity. 1. The teaching of the Savior, and the revelation of the mysteries. And the things hidden in silence, even these things which he taught John, his disciple. And it happened one day, when John, the brother of James, who are the sons of Zebedee, had come up to the temple, that a Pharisee named Arimaneus approached him and said to him, "Where is your master whom you followed?" And he said to him, "He has gone to the place from which he came." The Pharisee said to him, "With deception did this Nazarene deceive you, pl. And he filled your ears with lies, and closed your hearts, and turned you from the traditions of your fathers. When I, John, heard these things, I turned away from the temple to a desert place. And I grieved greatly in my heart, saying, How then was the Savior appointed, and why was he sent into the world by his Father, and who is his Father who sent him, and of what sort is that eon to which we shall go? For what did he mean when he said to us, This eon to which you will go is of the type of the imperishable eon, but he did not teach us concerning the latter, of what sort it is. Straightway, while I was contemplating these things, behold, the heavens opened and the whole creation which is below heaven shone, and the world was shaken. I was afraid, and behold I saw in the light a youth who stood by me. While I looked at him, he became like an old man. And he changed his likeness, again, becoming like a servant. There was not a plurality before me, but there was a likeness with multiple forms in the light, and the likenesses appeared through each other, and the likeness had 3 forms. He said to me, John, John, why do you doubt, or why are you afraid? You are not unfamiliar with this image, are you? That is, do not be timid. I am the one who is with you, always. I am the Father, I am the Mother, I am the Son. I am the undefiled and incorruptible one. Now I have come to teach you what is and what was and what will come to pass, that you may know the things which are not revealed and those which are revealed, and to teach you concerning the unwavering race of the perfect man. Now, therefore, lift up your face, that you may receive the things that I shall teach you today, and may tell them to your fellow spirits who are from the unwavering race of the perfect man. And I asked to know it, and he said to me, the monad is a monarchy with nothing above it. It is he who exists as God and Father of everything, the invisible one who is above everything, who exists as incorruption, which is in the pure light into which no eye can look. He is the invisible spirit, of whom it is not right to think of him as a god, or something similar. 4. He is more than a god, since there is nothing above him, for no one lords it over him. For he does not exist in something inferior to him, since everything exists in him. For it is he who establishes himself. He is eternal, since he does not need anything. For he is total perfection. He did not lack anything, that he might be completed by it, rather he is always completely perfect in light. He is illimitable, since there is no one prior to him to set limits to him. He is unsearchable, since there exists no one prior to him to examine him. He is immeasurable, since there was no one prior to him to measure him. He is invisible, since no one saw him. He is eternal, since he exists eternally. He is ineffable, since no one was able to comprehend him to speak about him. He is unnameable, since there is no one prior to him to give him a name. He is immeasurable light, which is pure, holy, and immaculate. He is ineffable, being perfect in incorruptibility. He is not in perfection, nor in blessedness, nor in divinity, but he is far superior. He is not corporeal nor is he incorporeal. He is neither large nor is he small. There is no way to say, what is his quantity, or, what is his quality, for no one can know him. He is not someone among other beings, rather he is far superior. Not that he is simply superior, but who are the sons of light? There are many sons who have the light, and that is because it was given to them by their mothers. They are called the sons of light. They will be amongst the first to tell the news of goodwill to men and peace on earth, because an age has passed and a gate unto another age flies open in preparation for the age of soul. Many refer to this as the new paradigm. The vibration in the cosmos and here on earth has quickened as the gate flies open at a seemingly touch of time. We refer you to read chapter number 2 of the Circle 7 Holy Quran, divinely prepared from ancient text by Prophet Noble Drew Ali, tailored to address immediate issues of today. Chapter 2 is called The Education of Mary and Elizabeth in Zoan, Egypt. Friday, May 22, 2020, 11:38 p.m. Divine law and nature's law are relative and supreme. Home. National identification cards, proclamations and sealing. Shoveling out. Food for thought. Mantis Views 29. How to use this site. Weekly events. Calendar events. What's new? Open readings downloads. What to study. Moor's responsibility. The Forgotten Scrolls. Proclamations by states. Congressional records. Public records, true and divine. Writs of freedom. Quo warranto/averment of jurisdiction. Use of pro se. Law definitions. Jurisprudence. Mortgage myth. Moors heritage and history classes. Canaan land Moors. About Noble Drew Ali. About CM Bay. About the Fez. About taxes. Holiday, holy day. Driver's license fraud. Failure to identify. Prisoners in your own land. Aboriginally healthy. Sistars standing on law. Return of the matriarch. Religious controversy. Astrology cosmology. Prose, poetry and literary scripts. Frequently asked questions. Product details, PayPal orders. Orders via money orders. Shipping policies. Contact us. Scroll, spinning. U.S. Republic Constitution includes Declaration of Independency. Treaty of Peace and Friendship. Inter Caetera Divina. Divine law and nature's law are relative and supreme. The common laws that govern civilization are derived from a study of these laws. Most of the important documents of the world, treaties, agreements, and legitimate contracts and covenants are written in the spirit of divine law for the purpose of governing the mental. Horizontal divider 12. Click on any numbered items on this page, read, print or download, for your review. Contents, click on your choice to access directly or peruse the page. American Constitution 1789, 90, Treaty of Peace and Friendship 1787 Articles of Confederation 1781 Declaration of Independence 1776 Articles of Association 1774 Ben Banneker Letter to Jefferson 1791 George Washington Letter to Sultan 1789 Inter Caetera Divina 1493 Willie Lynch Papers 1712 Christian Black Codes 1724 About United Nations Declaration of Human Rights 1948 Declaration of Rights of Child 1959. Horizontal divider 12. This page contains constitutions, treaties, agreements, church bullas, contracts, and other important national and international documents and correspondences. Most were written in the spirit of preserving principled government, with emphasis on the protection of substantive rights, birthrights, and basic human rights and principles for all. However, many dishonorable and disingenuous men have violated these noble and ancient principles, which are also embodied within the Constitution for the United States of America. Many people mistakenly think these rights preservations do not apply to them. Says who? The governed are still, and always have been, the source where delegated governmental authority is derived. The preservation and protection of the people's rights are why government exists. If and when government officials fail to uphold and support the Constitution, upon which they have taken their official oaths to uphold and support, then they are in violation of law, have abandoned their fiduciary duties, have quit their jobs, and thereupon possess no lawful authority. All government officials, including local policemen and firemen in the cities and boroughs, must take an official oath on the Constitution. If the natural people and citizens lack knowledge, they will often fail to recognize when an ordinance or statute, passed by politicians, violates the supreme law of the land. No ordinances or statutes, or laws of any of the several states, can contradict or violate the supreme law of the land, see Article 6, and be held as constitutional. Physical, mental, and spiritual oppression has taken such a negating toll on the misinformed and miseducated masses, that many have become apathetic, and appear not to care, showing a lack of interest in their own welfare or that of their progeny. A misinformed, and miseducated people are limited in knowledge to protect their substantive rights. Naivety subjects them, and their children, to multiple abuses against their rights. They can, and sometimes do, complain. More often than not, they get involved with selfing associations that rarely produce solutions. If one does not know the nature or cause of their condition or problem, one is not likely to find or effectuate solutions. Many others, who remain civically inactive, are even more unlikely and unable to solve their social and political problems. They often remain stagnated, while waiting for someone else to fix their condition. Consequently, this passive state of mind deems it almost impossible for them to protect or defend themselves from colorable acts of colorable government. Knowledge redeems, and improves the capacity of any active natural person or citizen to better serve man and mankind. Enforcing the Constitution is a civic duty, responsibility, and progressive action. Supporting principles of justice is the duty of all civilized people. This lends encouragement and support to a civilized world. Did you know that the first Constitution was the Articles of Association, 1774, the second was the Articles of Confederation, 1781 to 1788, the third was the Declaration of Independence, 1776, and the fourth is the present United States Constitution, adopted, 1789. Article 6 of the United States Constitution demonstrates the connectivity and unity in law of all the foregoing constitutions, Articles of Associations, Articles of Confederation, Declaration of Independence, Treaty of Peace and Friendship, and all treaties made under the authority of the Constitution, are the supreme law of the land. Scholars, and the erudite of jurisprudence recognize these documents of law as being one constitution. As for Moorish Americans, relate the Treaty of Peace and Friendship from this perspective. Article 6 of the Constitution for the United States of North America. All debts contracted and engagements entered into, before the adoption of this Constitution, shall be as valid against the United States under this Constitution, as under the Confederation. This Constitution, and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation, to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. 1 Willie Lynch Test. 1 American Constitution for United States of America, North Continent, 1789. Horizontal Divider 12. About the Treaty of Peace and Friendship 1787 AD. Between Morocco and the United States. By Taj Tariq Bey. When reading, studying and/or analyzing the Treaty of Peace and Friendship between the Moors and the United States of 1787 AD, one must be cognizant of the history and truth involving the relationship between the two political entities. A sound and prudent knowledge of the history of Europe and its adoption of governmental principles from the Moors is crucial to any serious historian. The logical recognition of the ancient presence of the Asiatic Moabite/Moorish presence in the Americas, coupled with world history, will definitely clear up most misrepresentations as have been effected by the destructive hands of the reconstructors of American history and the traditional condition of ignorance as caused by the colonial book burners and slaveholders. See Article 6 of the Constitution for the United States of America. 1 Willie Lynch Test. 2 Treaty of Peace and Friendship 1787. 1 Willie Lynch Test. 2 A authentic Treaty of Peace and Friendship from Congressional Records. Horizontal Divider 12. About the Articles of Confederation 1781 to -1788. The Articles of Confederation are referred to in the Constitution in Article 6, as a treaty or agreement entered into before the adoption of this Constitution. Therefore, it can be stapled to the Constitution, as it was not overridden or eliminated. During this Constitution, it clearly noted that all men are created equal, and since that Constitution, articles, were never changed, there is no need for the 14th and 15th Amendment. 1 Willie Lynch Test. 3 Articles of Confederation 1781 to -1788. Horizontal Divider 12. About the Declaration of Independence 1776. The Declaration of Independence is one of the 4 constitutions. The European was in fact in slavery and they were of 3/5 ths of a man. They were treated with despotism and wanted to be considered as equal. Thus, This famous and important document of their unanimous declaration led to the fairer treatment of them with humane principles. The purpose of these contemporary interfacings and writings involved bringing them into the constitutional fold of government. Much of the unspoken and uncommunicated history of this period involves the systematic subversion of the union agreements between the Moors/sovereigns and the European colonial companies/guilds. The Europeans used force of arms, the power of the pen, and their newly learned Masonic principles of government, and conjoined them with negative law, to overthrow the Moors. This betrayal of trust led to the practiced Inquisition policies which have become the institutionalized dead culture, corrupted politics that marks the negative side of North America's colonial human rights abuses practices. These practices have been falsely mislabeled as racism. The greater negative part of the dead culture includes land thefts, birthrights thefts, color of law activities, and the systematic slaughtering of the Aboriginals/Indigenes. These Niceno-Constantinopolitan war rituals, inclusive of mental warfare strategies, are particularly apparent in acts and symbolisms during harvest celebration, which came to be known and celebrated as Thanksgiving. The labels, Negro, colored, black, etc., were coined to misclassify the natural people and take them outside of the fundamental principles of proper person status. 1 Willie Lynch Test. 4 Declaration of Independence 1776. Horizontal divider 12. About the Articles of Association. The Articles of Association are what is referenced when saying the Constitution of 1774, which has not changed. Therefore is again, an agreement entered into prior to the Constitution. Upon reviewing it, you will see that these are rules of engagement for the European colonist, who were British subjects in America and were given some sort of comfort and exile in America, of which they mention America as being dominioned by the British and their ancient civil principles. In this document it says to dispose the inhabitants to act with hostility against the free Protestant colonies. Moors did not want the colonists to be here and sabotaged some of the efforts for imports, particularly the British, Moors, of which the Slavic Europeans were subjects or rather slaves of. Again, further proof these are not the dominions of foreign Europeans and they cannot become Americans, by default. Only by naturalization, and there exists no flag of their nation, as is not their nation, they are as subjects with granted privileges, including land grants, but not the true possessors. As naturalized citizens, they possess no political authority. The people who were already here were not colonists obviously. The Congress is mentioned and already existed, and the people who were here were not Indians, thus not members, and no need to be members, of the Bureau of Indian Affairs. It is clear that the people did not want the colonists to be here, to have any privileges, so in a sense Moors suffered a karmic consequence. However, it is what it is and the karmic debt is over. Now Moors must be who they are and be free and accessible to their own ancient civil principles, of which ancient civil principles and prejudices are mentioned in the document, and so is ancient limits. It all makes so much sense and proves a willingness to accept others in the land, with a limited authority and not at the expense of losing all connection with self. Unfortunately this is not honored by those who were granted privileges, they prefer to say they don't know who or what a Moor is. 1 Willie Lynch Test. 5 The Articles of Association. Horizontal divider 12. About the letter from Benjamin Banneker, Chief Justice Ben Bay, to Thomas Jefferson 1791. The letter to Thomas Jefferson from Chief Justice Benjamin Banneker Bay clarifies his participation in teaching government to the colonist, in creating the almanac that he gave as a gift to Thomas Jefferson, and his participation in designing the White House for the use of the colonist as a connection to their motherland as defined in What a Colonist Is. The European colonists are not Americas, they are European colonists who have managed through trickery, deceit, and murder to sit in the seats of power. These seats ought to be occupied by the true American, those who think they are Negro, colored, blacks, etc., and who think their homeland is limited to Africa in the East, as we know it to be today. 1 Willie Lynch Test. 6 Letter from Benjamin Banneker to Thomas Jefferson 1791. Horizontal divider 12. About letter from George Washington to the Sultan of Morocco 1789. The letter to the Sultan of Morocco, from President George Washington, is one of the favorites amongst the documents of American history, as it clearly indicates the newly formed United States of America, under the first Masonic president, George Washington, was subordinate to and dwelling on the dominions of the Moroccan Empire. Anything other than that holds no standing, as to why George Washington would write a letter as such to the Sultan of Morocco. It indicates without contradiction that the Moors were in the superior position, that George Washington was the newly appointed President of the United States of America in the North American continent, under the rule and dominion of the Sultan of Morocco. 1 Willie Lynch test. 7 Letter from George Washington to Sultan of Morocco, 1789. Horizontal divider 12. About Intercedere Divina. The Church Bulla of 1493 AD. Divina is a password used by most European colonist descendants, who have overthrown, settled, or occupied other lands or countries. Divina, in most instances, appears unthreatening to the unknowing ear, when Europeans find cause to refer to their pseudo-religious doctrine, which is politically and socially inculcated with terse policies and regulatory constructs. However, it must be noted and brought to the attention of all Aboriginal natural peoples, that Divina was, and is, used as a war reference and control guide point for colonial Inquisition operations in North America. The formal name of the Divina doctrine of Christianity is Intercedere Divina. Its origin is from Pope Alexander VI, one of many iconic social/political/religious representative vicars dedicated to policies for world dominance. The Germanic form or word, God/Guth/Good/God, was introduced to the world during the Middle Ages, which is the period of European history that divides ancient and modern times, being 500 AD to 1450 AD. The naive converts among the Aboriginals, who have naively accepted their teachings, are deceived by the propagated beliefs that the Christians were embracing ideas of a universal creator, or supreme being, overflowing with teachings of filial and universal love, etc. Little did the convertios know that, in reality, Divina, from the European colonial conquest mindset, is an institutionalized religious, war-sanctioned tool, justifying genocide, rape, theft, sadistic human oppression, land thefts. With the advent of the Spanish Inquisition, Inquisitio, the maxims of inflicting creative forms of human torture, drowning, burnings, skinning, mutilations, death, and other horrors, became as normal to justified Christendom supremacy culture as their penchant for highly stylized rituals of prayer. These same self-righteous, self-appointed merchants of godliness, are also the supreme masters of sadism. The Aboriginal, natural peoples of the planet have suffered more deaths, slavery, artificially induced diseases, and other sadistic mistreatments, at the hands of these pseudo-religious propagandists, than by that of the most vile and deviant soldiers amongst the known military armies of the world. 1 Willie Lynch test. 8 Bull Intercedere Intent, 1493. Horizontal divider 12. About the Willie Lynch letter 1712. The Willie Lynch letter, which is pseudonymous with Roman conquest culture as adopted for social/political interfacings and interchagnies with Aboriginal and Indigenous peoples. Theory is the epitome of Roman/European colonial psychic warfare methodologies. It encapsulates the social and political aims of Christendom, in its economic, social, and political relationships to the suppressed and branded descendants of the fallen Asiatic Moorish Empire, and sets the standards for the means and attitudes to be taken, artificially maintained, and practiced by the dominant European colonialists occupying the Americas, particularly North America. Many sociologists and social engineers in North America have referred to the Willie Lynch letter AD and its characteristics merely as a theory. However, a theory means a thought, a viewing or mental contemplation as distinguished from an actual action or doing. It must be determined by the reader or student of history and experience whether or not what is mentioned in the Willie Lynch letter has manifested in North American servitude activities or not. If such activities and culture have manifested in slave culture in North America, then it cannot be a theory. 1 Willie Lynch Test. 9 Willie Lynch Letter 1712. Horizontal Divider 12. About the Christian Black Codes of 1724. The Christian Black Codes of 1724 are the resulting list of 54 Christian protocols and acts, written to augment and institutionalize the William Lynch theories of suppression and control methodologies. These socialization tools are generally referred to as the Black Codes. 1 Willie Lynch Test. 10 Christian Black Codes of 1724. Horizontal Divider 12. About the United Nations, UN. The Aboriginal and Indigenous Natural Peoples, Moors, of North America, and of the world, have a vested interest in knowing about, learning about, and preserving their unalienable rights, substantive rights, and birthrights. Particular emphasis must be put on the fact that European colonist demo operations are constantly violating Constitution principles and international law. Officers, politicians, and policemen, etc., are repeatedly breaking the laws of nations, in order to effectuate their color of law practices of stealing the birthrights of the natural peoples of the land, particularly those of the Moorish Americans, who have been branded as Negroes, Blacks, Coloreds, West Indians, Latinos, etc. The United Nations, being the nation members, listed below, in agreed unity of law, deals with matters of human rights, supports and violations, and issues such proclamations of law, concerning these issues, through, and from, the General Assembly. People from different nations may, from time to time, file violation claims or complaints, etc., by way of the World Court, and Class Number 4. Mail Fraud, page 1. Sunday, July 14, 2013/1 p.m. 3 p.m. Blog Talk, Centash's Civil Alert Rising Radio. Chat room or call in, 858-357-8450. 1. What is mail fraud? 2. What is the fine for mail fraud? 3. When mail is received, what is the general form of the information? 4. A valid stamp must be what? 5. What does the red postage mark mean? 1. Mail is applied to the post office. This term means the carriage of letters, whether applied to the bag into which they are put, the coach or vehicle by means of which they are transported, or any other means employed for their carriage and delivery by public authority. Winan B. Shapert, 6 Daily, NY. 500. It may also denote the letters of other matters so carried. The term mail, as used in Reverend St. U.S. Section 5469, U.S. Comp. St. 1901, p. 3692, relative to robbing the mails, may mean either the whole body of matter transported by the postal agents, or any letter or package forming a component part of it. U.S. v. Inabnet, D.C., 41 Federal 130. Mail also denotes armor, as in the phrase a coat of mail. In Scotch law, rent, a rent or tribute. A tenant who pays a rent is called a mail payer, mailer, or mailman, skene. Mail matter. This term includes letters, packets, etc. received for transmission, and to be transmission, and to be transmitted by post to the person to whom such matter is directed. U.S. v. Huggett, C.C. 40 Fed. 641, U.S. v. Rapp, C.C. 80 Federal 820. 2. Postmaster General, the United States. Postmaster General is the Chief Executive Officer of the United States Postal Service. The office, in one form or another, is older than both the United States Constitution and the United States Declaration of Independence. Benjamin Franklin was appointed by the Continental Congress as the first Postmaster General, serving slightly longer than 15 months. Until 1971, the Postmaster General was the head of the Post Office Department, or simply Post Office until the 1820s. 2. From 1829 to 1971, he was a member of the President's Cabinet. The cabinet post of Postmaster General was often given to a new president's campaign manager or other key political supporter, and was considered something of a sinecure. The Postmaster General was in charge of the governing party's patronage, and was a powerful position which held much influence within the party. For example, James Farley used his position as Postmaster General during Franklin D. Roosevelt's New Deal administration to reward party loyalists within Congress who supported Roosevelt's initial 100 days legislation with federal patronage for their states. Federal appointments, except for a small handful, were screened by Farley before the president could approve the appointments due to the patronage position of the Postmaster General. In 1971, the Post Office Department was reorganized into the United States Postal Service, an independent agency of the executive branch. Thus, the Postmaster General is no longer a member of the cabinet and is no longer in presidential succession. During the American Civil War, the Confederate States of America Post Office Department provided mail service for the Confederate States, headed by a Postmaster General, John Henninger Reagan. The Postmaster General is second highest paid U.S. government official, based on publicly available salary information, after the President of the United States. 18 U.S.C. 112, Protection of Foreign Officials, Official Guests, and Internationally Protected Persons. A. Whoever assaults, strikes, wounds, imprisons, or offers violence to a foreign official, official guest, or internationally protected person or makes any other violent attack upon the person or liberty of such person, or, if likely to endanger his person or liberty, makes a violent attack upon his official premises, private accommodation, or means of transport, or attempts to commit any of the foregoing shall be fined under this title or imprisoned not more than 3 years, or both. Whoever in the Commission 1. Convention on the Prevention and Punishment of the Crime of Genocide, adopted by Resolution 263, A of the United Nations General Assembly on December 9, 1948. Article 1. The contracting parties confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law which they undertake to prevent and to punish. Article 2. In the present convention, genocide means any of the following acts committed with intent to destroy, in whole or in part, a national, ethnical, racial or religious group, as such. A. Killing members of the group. B. Causing serious bodily or mental harm to members of the group. C. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. D. Imposing measures intended to prevent births within the group. E. Forcibly transferring children of the group to another group. Article 3. The following acts shall be punishable. A. Genocide. B. Conspiracy to commit genocide. C. Direct and public incitement to commit genocide. D. Attempt to commit genocide. E. Complicity in genocide. Article 4. Persons committing genocide or any of the other acts enumerated in Article 3 shall be punished, whether they are constitutionally responsible rulers, public officials, or private individuals. Article 5. The contracting parties undertake to enact, in accordance with their respective constitutions, the necessary legislation to give effect to the provisions of the present convention and, in particular, to provide effective penalties for persons guilty of genocide or any of the other acts enumerated in Article 3. Article 6. Persons charged with genocide or any of the other acts enumerated in Article 3 shall be tried by a competent tribunal of the state in the territory of which the act was committed, or by such international penal tribunal as may have jurisdiction with respect to those contracting parties, which shall have accepted its jurisdiction. 2. Article 7. Genocide and the other acts enumerated in Article 3 shall not be considered as political crimes. For the purpose of extradition, the contracting parties pledge themselves in such cases to grant extradition in accordance with their laws and treaties in force. Article 8. Any contracting party may call upon the competent organs of the United Nations to take such action under the Charter of the United Nations as they consider appropriate for the prevention and suppression of acts of genocide or any of the other acts enumerated in Article 3. Article 9. Disputes between the contracting parties relating to the interpretation, application, or fulfillment of the present convention, including those relating to the responsibility of a state for genocide or any of the other acts enumerated in Article 3, shall be submitted to the International Court of Justice at the request of any of the parties to the dispute. Article 10. The present convention, of which the Chinese, English, French, Russian and Spanish texts are equally authentic, shall bear the date of December 9, 1948. Article 11. The present convention shall be open until December 31, 1949 for signature on behalf of any member of the United Nations and of any non-member state to which an invitation to sign has been addressed by the General Assembly. The present convention shall be ratified, and the instruments of ratification shall be deposited with the Secretary-General of the United Nations. After January 1, 1950, the present convention may be acceded to on behalf of any member of the United Nations and of any non-member state which has received an invitation as aforesaid. Instruments of accession shall be deposited with the Secretary-General of the United Nations. Article 12. Any contracting party may at any time, by notification addressed to the Secretary-General of the United Nations, extend the application of the present convention to all or any of the territories, for the conduct of whose foreign relations that contracting party is responsible. Article 13. On the day when the first 20 instruments of ratification or accession have been deposited, the Secretary-General shall draw up a procès-verbal and transmit a copy of it to each member of the United Nations and to each of the non-member states contemplated in Article 11. The present convention shall come into force on the 90th day following the date of deposit of the 20th instrument of ratification or accession. 3. Any ratification or accession effected subsequent to the latter date shall become effective on the 90th day following the deposit of the instrument of ratification or accession. Article 14. The present convention shall remain in effect for a period of 10 years as from the date of its coming into force. It shall thereafter remain in force for successive periods of 5 years for such contracting parties as have not denounced it at least 6 months before the expiration of the current period. Denunciation shall be effected by a written notification addressed to the Secretary-General of the United Nations. Article 15. If, as a result of denunciations, the number of parties to the present convention should become less than 16, the convention shall cease to be in force as from the date on which the last of these denunciations shall become effective. Article 16. A request for the revision of the present convention may be made at any time by any contracting party by means of a notification in writing addressed to the Secretary-General. The General Assembly shall decide upon the steps, if any, to be taken in respect of such request. Article 17. The Secretary-General of the United Nations shall notify all members of the United Nations and the non-member states contemplated in Article 11 of the following: A. Signatures, ratifications, and accessions received in accordance with Article 11. B. Notifications received in accordance with Article 12. C. the date upon which the present convention comes into force in accordance with Article 13. D. Denunciations received in accordance with Article 14. E. The abrogation of the convention in accordance with Article 15. F. Notifications received in accordance with Article 16. Article 18. The original of the present convention shall be deposited in the archives of the United Nations. A certified copy of the convention shall be transmitted to all members of the United Nations and to the non-member states contemplated in Article 11. Article 19. The present convention shall be registered by the Secretary-General of the United Nations on the date of its coming into force. Created on August 16, 1994 / last edited on January 27, 1997. Why Moors or any natural flesh and blood being cannot register or utilize vital statistics. Many think they must register their status correction, or name correction in judicial notice and proclamation. Thus, some have established a Moorish vital statistics, we like to call it the MVS. Others may have created registries and are telling you that you must be registered. No one has asked where the registry is being registered. Vital statistics may appear to be a branch of the county, municipality, or state, etc. However, it has its origins in the church, wherein the records of births of members / citizens of each union state was recorded for the church, and it is still that way today, even though many think church and state are separate. The current day preachers, pastors, reverends, etc., come out of their general clergy and step into secular clergy and report all marriages, making sure the marriage license that you retrieved from the local municipality or county is filled out and registered as property / members of the state. If you have children from that marriage, they must also be registered by default, beginning with the birth certificate, which is an instrument that proves human trafficking. See our article about the marriage license. This reporting is done under a quasi-national and municipal domicile, as that is what the church is also under to this day, particularly and especially those who have 501(c)(s), etc. In fact, the municipality is a religious organization with mincitaires who attend to the people in ministerial meeting rooms that they call courts, yet they are merely ministerial, possessing no judicial authority. They act as they do, just like an actor who was playing a part, except this is a part of the real-life illusion the people keep alive by having faith in it. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. Burns v. Sup. CT. SF. 140 calories 1. When acting to enforce a statute and its subsequent amendments to the present date, the judge of the municipal court is acting as an administrative officer and not in a judicial capacity. Courts in administering or enforcing statutes do not act judicially, but merely ministerially. Thompson v. Smith, 154 SE 583. The preachers, reverends, pastors, first get set up as a church after receiving permission through a license or a 501(c)(3), which provides they do not have to pay taxes. The 501(c) series or whatever assigned letter or number they have altered it to today, is their thank you for reporting and registering their congregation and the congregation's family under the corporate jurisdiction. For that service, not only does the church not have to pay taxes, they also cannot speak of civics, human rights, law of the land, etc., because it is a permission from a corporation. Yet, during election time they are asked to encourage the people of their congregation to vote for whoever they are instructed to push to win with the poll votes of the congregation. As a special note, most churches have had the full control of the donation plate. However, lately, because finances are getting tight, they have had to report their donation plate as well. Other stipulations have been added to certain donations made to the churches operating under 501(c)(s). The donation plate scrutiny started approximately 5 years ago in most churches. In short, registering is something you do with items and property, not with flesh and blood beings. It is a means of your agreement to redefine your status and place you under jurisdiction of a quasi-national domicile, of which all states are quasi-national domiciles. They are not a national domicile or jurisdiction. Thus the beginning of confusion and truth and falsehood being strangely mixed for one who says they are an aboriginal and indigenous of a nation or family, and then agrees to quasi-national activities. That ought be enough to wake you up and start to thinking so you can free yourself. It is clear that many do not know what proclaiming really is and how a proclamation relates to a lawful notice, or even what a lawful notice is. Law is notice. Both the registering and vital statistics have their origins in a feudal system and feudal law. Feudal systems have their origins in European-styled governments. You don't have to believe us, look it up for yourself. Whose hands have blood on them? Recently, on Facebook, this first week of August, notes were posted in regards to a sister who was fatally shot, and her small child shot and injured, at their home near corporate Baltimore, by policy enforcers over a traffic stop. They came to her home with a so-called warrant, after the traffic stop, which is ex post facto. If a municipality sends their policy enforcers with a warrant, it is called a municipal warrant. A municipal warrant is a bill of attainder, and bills of attainders are forbidden for both the Congress and the state to create. Article 1 Section 9 and 10 of the American National Constitution of 1791, of which all people and entities derive authority from on this American land. No bill of attainder or ex post facto law shall be passed. Article 1 Section 9. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. Article 1 Section 10. Municipal warrant. A municipal warrant or order is an instrument, generally in the form of a bill of exchange, drawn by an officer of a municipality upon its treasurer, directing him to pay an amount of money specified therein to the person named or his order, or to bearer. 15 America and ENG in Law, 1206. Bills of attainder are forbidden to be created by states, or any entities of a state, and any enclave, agency, association, etc., registered under a state. You must recognize these facts, just as any arrest warrant and or search warrant is described as to what it is, and what it looks like, in Article 4. Upon reviewing it, you will see it is not computer generated, as it must have a raised seal and signature of a judge, a real judge. What is that you say? An Article 3 judge, of which the defines and obligations of same are described in Article 3, as well as in Article 6. The warrant also must have an attached sworn affidavit. Why, you say? Because in order for there to be any action taken by any so-called law enforcer, there must be a complainant/accuser and or injured party, and that complainant must bring to light the nature of the complaint in written form, signed as a sworn affidavit. In order for there to be any action taken in regards to a crime, there must be an injured party, of which traffic infractions, if any, are not a crime, and the same goes that a sworn affidavit describing such injury of the injured party, must exist and be attached to any warrant. It is then carried out via due process of law and not arbitrarily decided and created by municipal employees. For a crime to exist, there must be an injured party, corpus delicti. There can be no sanction or penalty imposed on one because of this constitutional right. Scherer v. Cullen 481 F 945. Those are the explicit limited obligations of a state, described to ensure the people are not exploited by others, especially by corporations. Therefore, the question to ask is, have the municipalities gone rogue, and have the states in which they are supposed to be registered under or contracted out to work for, turned a blind eye? Turning a blind eye is easy to do when the people themselves are blind. The sister, and many others, died without a crime being committed, and the blood of them is on the hands of the municipal employees, security guards or Roman soldiers, or Ku Klux Klan members who have infiltrated law enforcement via municipal venues, according to the FBI reports. Yet the Facebook poster, and the grand sheiks of certain infiltrated, out-of-order MSTA temples, have not pointed a finger at them, or threatened to check them for it. You do the math on that, as it sounds and smells cowardice. Additionally, what disturbed us, is that other Moors have posted that the blood of this sister is on our hands because we have directed the people to look up and review delegation of authority, for their improvement and overstanding of law, which is in the Constitution under Article 3, which deals with judicial authority and diversity of citizenship. The entire Constitution is based on the diversity of the people and their citizenship. The American National Constitution of 1791 is what brought the Union States into the fold of government in the first place. Many of the descendants of the modern Europeans, and anyone who works for the Union States/colonist, are, or are acting as, Roman soldiers seated in a municipal venue, hired to protect their venue, which are not operating as, or under the Republic state, but are corporations that abandoned their constitutional obligations and formed as corporations using derivatives of the state names. I.e. New York State, State of New York, wherein if you look at the papers they generate and the pseudo-charging documents, it will say the state of versus you. Therefore, these facts are not hidden by them. It is that the unsuspecting, unknowledgeable people do not know, and the people are in truth held accountable for allowing impostors into their lives to rape them of their liberties. Thus, the people do need to wake up quickly. The Union States decided around 1870 that they wanted to participate in commerce as corporations instead of in government, as governmental entities, and since they have no product to sell, they devised a pseudo, not real evidence, to make the people their commodity, and the people believed it out of lack of knowledge and mental inadequacies regarding knowledge or knowing or being noble, as noble means to know. This was done in the spirit of intentional deceit and conspiracy to extort, both being highly penal if you are a government entity. Since they are not, it makes any instrument coming from them void, and upon them enforcing or forcing same, it makes them participants in human trafficking and genocide, which is an international crime, a crime of genocide. As corporations, they are not government, and their municipal employees have no authority to compel authority against the natural people, as a corporation has no parity with the real. The Union States decided around 1870 that they wanted to participate in commerce as corporations instead of in government, as governmental entities, and since they have no product to sell, they devised a pseudo, not real evidence, to make the people their commodity, and the people believed it out of lack of knowledge and mental inadequacies regarding knowledge or knowing or being noble, as noble means to know. This was done in the spirit of intentional deceit and conspiracy to extort, both being highly penal if you are a government entity. Since they are not, it makes any instrument coming from them void, and upon them enforcing or forcing same, it makes them participants in human trafficking and genocide, which is an international crime, a crime of genocide. As corporations, they are not government, and their municipal employees have no authority to compel authority against the natural people, as a corporation has no parity with the real. Landmark case law. Administrators defined government succinctly. Governments are corporations, inasmuch as every government is an artificial person, an abstraction, a creature of the mind only. A government can deal only with artificial persons. The imaginary, having no reality or substance, cannot create or attain parity with the real. Penhallow v. Dones. Good thing that no matter who is who and what is what, all people and entities, including corporations, occupying and or operating on this American land estate, are under the obligation of the law of the land and derive their limited, if any, authority from it. State governments are but trustees with a derived authority for week 402. That is what makes the enforcing of it beautiful in its nature, as in doing so, no one is molested. Thus, the supreme issue is to enforce the Constitution for the United States of America, written so other citizens would not molest you. Whoever is asking what is a delegation of authority, has just exposed that they are not enforcing the Constitution, which was established for the United States of America, consisting of all the Union States, who derive their limited authority from it. To all the grand sheiks, who ask what it is, you now know, if you did not before, that they do not study the Constitution, nor do they enforce it, yet they were instructed to do so by Prophet Noble Drew Ali, of which they say they are doing his work. It is clear they are not. So they are a private club, association, etc., and ought leave other people alone, as they know, or ought to know by the Prophet's teaching, that no one can change another's descent nature, and they ought to know that one's bloodline and descent nature does not come from any institution, i.e. any MSTA. They are to teach about nationality and birthrights, obtained at birth, by the act of their mother giving birth to them, or in other words, man was formed in the flesh and departed from her flesh. It is also instructed that all members within the temple must proclaim their nationality. The institution does not give that to them, it assists in the teachings for them to declare and proclaim it. Institutions do not create the cause creates the institutions. The fact that these private security guards work for, and have a duty to protect corporations, and do not respect nature or law, and are hired by municipal corporations and their institutions, which are not government, ought be clear by now to anyone who has studied, as the Prophet suggested they do thrice times over. So you figure out who these people are that are saying they have your best interest in heart, both municipal employees and Moors, we call dirty Moors, who make horrible accusations and threats, and figure out what and who they are really protecting. What we have never done is told anyone to ask for a delegation of authority at a traffic stop, and that is what the dirty Moor said we do, here at rapblayz Publications. In fact, he and Grand Sheikhs of temples used that as the foundation of their attack. Which is also disrespectful to the sister and her child, to have such discussion. At any rate, we do not tell people to ask for a delegation at a traffic stop. That is something to take up in your subsequent written claim at the federal level, and not on or at a traffic stop with municipal employees who are not trained in law, nor do they have any interest in upholding the law, although they say they are law enforcers, and they lie and say they are giving you a lawful order, when they are not. The person in their audio post also said do not listen to us, to listen to someone else, or otherwise do it yourself. Well, now they are talking, because we are all about the people becoming proficient enough in law to know and do it themselves, because we know the Roman soldiers, working for municipalities and institutions, supposedly speaking and acting on behalf of the state, are coming for them with the quickness. Therefore, telling the people to not listen to us and to do it themselves, is a contradiction on their part where we are concerned. Strangely, the audio Facebook poster, nor any of the Grand Sheikhs made any accusations of blood being on the hands of the policy enforcers, who in plain sight for all to see, murder the people on the highways and byways. Nor do they make them a target personally or otherwise. Yet they want to make us, at rapblayz Publications, a target and blame us. That is cowardice of them, and it is clear their intention is to target us. You do the math on that. Because we provide information to support one's study, to show themselves approved, it is also clear that those people making these posts, audio and otherwise, at the very least have an agenda of their own, which is clearly against us and seems to be to infiltrate and distract from valuable information being shared, because, as they said, they can do it better in a more disciplined manner. If that is the case, then continue your work towards that. As we can all only do what portion we can do on this platform to uplift fallen humanity and bring the people back into the constitutional fold of government, so they can take their place amongst the affairs of man. We know for a fact that ego often gets in the way of the unity of family. You, the reader, do the math on that. Love, truth, peace, freedom, and justice to all who have ears to hear and eyes to see. For those who do not, soon if not sooner, you may lose both forever. Shoveling out from the avalanche of lies. The investigation into the recent killing of 2 municipal employees/police at Baton Rouge, Louisiana, is attempting to point to the MSTA and members, or a member. The report says MSTA members are anti-government, however that is a blatant falsehood and misrepresentation, as Moors, whether in the temple or not, are upholders of the law, specifically respecting the American National Constitution of 1791, and, are aware that any and all government entities' authority is derived from that same Constitution as the law of the American land. As well, any and all government entities have the duty to protect, secure, and preserve the rights/liberties of the people as scribed within the said Constitution, with specific limitations, and no entity can be government if they are violating the law of the land. Moors are Moors whether members or not in the MSTA. It is interesting because we need to always maintain the integrity of what Prophet Noble Drew Ali put forth. However, just because most of the M.S.T.A's current leadership may deny and rebuke their brethren and sisterin Moors, due to the confusion caused by the infiltration via COINTELPRO some years ago, no more ought allow the lessons of Prophet Noble Drew Ali to be lost in the avalanche of lies that are being heaped upon them, as was prophesied would happen in these days and times, by Prophet Noble Drew Ali himself. Moors are those who have been coined Negroes, coloreds, blacks and African Americans, making them a minority because of their minor mind, or lack of knowledge regarding humanity, their own heritage, national principles, history, and law, which cannot be separated, family and government. These coins of Negro, colored and black, do not apply to natural flesh and blood beings. Thus, the rallies and protest under Black Lives Matter is more of an organized predatory ground for municipal employees, police, and other participating highwaymen to generate revenue even when supposedly organized as a safe and peaceable assembly. It also breeds more murders, imprisonments, and some who may come up on the missing persons list. For all who think these recent happenings are a script out of Hollywood, a conspiracy, not real, or have been scripted to be played out. Look at this script, the King Alfred and updated Rex 84 plan written years ago, in regards to the minorities, and see if you think it is being played out today, right now. There will be many cities where the minority will be able to put into the street a superior number of people with a desperate and dangerous will. He will be a formidable enemy, for he is bound to the continent by heritage and knows that political asylum will not be available to him in other countries. The greatest concentration of the minority is in the Deep South, the Eastern Seaboard, the Great Lakes region and the West Coast. It is expected, therefore, that, when those objectives are denied the minority, racial war must be considered inevitable. When that emergency comes, we must expect the total involvement of all 22 million members of the minority, men, women, and children, for once this project is launched, its goal is to terminate, once and for all, the minority threat to the whole of the American society, and, indeed, the free world. We are confident that the minority could hold any city it took for only a few hours. The lack of weapons, facilities, logistics all put the minority at a final disadvantage. In this electrifying age of information, all is being exposed. Our message to the people and the citizens, the reporters, to all those concerned in regards to uplifting fallen humanity, and to the municipal employees, police, who are, and have been for a long time, blatantly violating law and divine law. If you are really looking for the devil in this, look within. We offer excerpts from Chapter 3 of the Circle 7 Holy Quran divinely prepared by Prophet Noble Drew Ali. Epidemics. Can you see the truth of it? By Anad L. September 14, 2006. FDA warning on serious foodborne E. coli 0157H7 outbreak. 1 death and multiple hospitalizations in one state. August 29, 2007. Bagged spinach recalled over salmonella fears. A California produce company recalled bagged fresh spinach Wednesday after it tested positive for salmonella. There were no immediate reports of illness linked to the tainted spinach, distributed by Metz Fresh LLC of King City, California. The recall comes nearly a year after an outbreak of another pathogen, E. coli, in fresh spinach killed 3 people and sickened another 200. June 6, 2008. Salmonella linked to tomatoes. The FDA and DCD first warned last week of dozens of people in 9 states who had gotten sick after eating certain types of raw, red tomatoes. Connecticut, April 24, 2009. 6 communities: Bloomfield, Windsor, Hartford, West Hartford, and parts of East Granby and Windsor locks contaminants found in drinking water. Public advised to boil water, however contaminants are not harmful to people. April 27, 2009. Swine flu breakout linked to Mexico spreads to New York, California, Texas, Kansas, Ohio. What can we do? It seems every year there is a food epidemic. A food scare. What is going on? The better question to ask is, why are we so surprised? Aren't we aware that this is slow, methodical programming? Where is the information coming from? Do we actually know for sure if this is really happening based on what is being told to the public? Why are we so trusting, and why are we not being scientific about ourselves, our world, and our universe? One premise we all need to remember is, everything happens based on what we eat and breathe. We may not always be able to control what we breathe, however, if we discipline ourselves regarding what we eat, it will take care of what we may not be able to control in regards to what we breathe. The first thing to remember is bacteria, germs, and parasites are our friends. We are supposed to be able to coexist with them. They in fact serve a purpose contrary to what is told and promoted. If we are eating foods that help to create a healthy body environment, which regenerates and repairs as it should, bacteria, germs, parasites, infections, and illness cannot and will not affect us, as it would not be possible. If you have a healthy body, you can be in the center of an epidemic and you will not be affected in any way whatsoever. If, however, you are not eating foods that are conducive to a healthy body, which includes healthy bone, muscle, and tissue, bacteria, germs, and parasites will appear to eat the unhealthy bone, muscle, and tissue, as this is their function. The human body creates hydrochloric acid. Hydrochloric acid is created during the process of food consumption. Its purpose is to kill any and all unnecessary bacteria, germs, and parasites that attempt to invade the body via the foods that we consume, hence the destruction of any harmful bacteria such as E. coli, salmonella, and worms. Hydrochloric acid in humans is very low because most of us eat the wrong foods. Our food source is supposed to be fruits and vegetables. Our bodies and the level of hydrochloric acid is not designed to destroy parasites that may be found in meat. This includes chicken and fish. Because we consume incorrect types of foods, usually in large amounts, many of us have little to no hydrochloric acid, which leaves us open to all sorts of bodily invasions. Not to mention our immune system is struggling to support us with no help from the foods we choose to consume. To assist with hydrochloric acid production, one item that can be added to the diet is cayenne pepper. Cayenne pepper will help the body adjust and improve its hydrochloric level. Although there are many herbs that assist in improving our body, if we implement a program of change, and continue to consume incorrect food, at some point those incorrect foods will outweigh the good of the herbs, and over time the effectiveness will decrease until there is no effect at all. Many people have changed to an intake of flesh consisting of only chicken and fish. Some of no flesh at all, or maybe a vegetable protein substitute with the continued consumption of grains, cereals, cooked foods, and continue consuming dairy products. You may want to reconsider all dairy products. Dairy products consist of extreme amounts of mucus. The milk of the cow contains large amounts of mucus for their calf. This is not designed for the human race, and consequently contributes to the breakdown of the immune system and ultimately the body. You may want to also reconsider or start a program to move away from protein substitutes, grains, and less sprouted, cereals, and cooked foods. What has been going on for quite some time now, is an attack on the immune system. Many things, in addition to food, break down the immune system, such as antibiotics, most all medications, drugs, and so-called immunizations. However, food is the number one source that we participate in with great enjoyment, disregard, and little thought. We have become so programmed that we no longer hear the voice inside us that tells us you shouldn't eat that. We miss or ignore the signs such as allergic reactions that tell us you shouldn't eat that. Unbeknownst to us, the universe is forcing us to make a change, now. Many of these epidemics are coming into existence being because we are a programmed stubborn people, and we seem to only move when pain and suffering is present. It is a very bitter pill, however we must move back to knowledge of who and what we are, and what our body needs to function as the replica of the universe it is. Our body is our first temple, of which residing within it is our soul, thus it is Solomon's temple, soul of man's temple. We must make this acknowledgement and corrections now. Consider everything, and make changes accordingly while you still have the time to do so. A new paradigm is upon us, the climate and the vibration of the planet is changing. If our bodies are not healthy and in tune with the vibrations, we will not withstand the shift. A very wise man once said, "Discipline yourself, or you will be disciplined." Important excerpt from preface of 1895, 8th grade final public school test. Preface written by Taj Tariq Bey. It is inviolably impractical and non-productive for any suppressed and oppressed people to properly analyze and understand world history, or their own history, without having knowledge of the linear processes under which forced servitude and literary destruction took place. Keep in mind that illiteracy was artificially induced upon those held to servitude in North America. Those held to forced servitude in North American territories, by the occupying Inquisition colonists from Europe, were severely suppressed and denied any formal education for generations. Even informal forms of education were prohibited. The intended effect was to eliminate future generations, of those made subject, from any intelligible ability to counter the misinformation and altered history imposed by the European occupying forces. Heavy yokes were placed upon the young subjugates at the earliest stages of their lives, so that they would not contemplate a questioning of their conditions, nor of those hostiles exercising authority. Thus, ignorance by design became a hallmark of the U.S. demo educational institutions directed at an unprotected people. The coats servile children were, and are, groomed for the purpose of serving as state-bound chattel and are being cultivated as straw man, pawns for corporate slavery. They are being prepared for use in hard yoke labor and as war fodder. In order to create such expendable personages, a low mental state must be carefully groomed. To meet this end, colorable conditions, artificially induced poverty, taxation without representation, and designed miseducation serves its controllers, administrators, and their employed pseudo-teachers. Horizontal divider 12. Answers to frequently asked questions. Horizontal divider 12. Question 1. We are starting our lecture series and study about nationality and commerce, and law down here in Louisville. I had a brother show me his travel card and identification that he received from information from lecture series when the brothers, rather not say their names, was in Indianapolis. Is it necessary to have a travel card, and how can we, ancient Kemetic Moors, in Louisville get more information to get up to date with processes of the ID? So far I have all of my paperwork in my permanent file with the county and apostilles with the state. The ID I have now, compared to the Indianapolis brother, appearance is not as prestigious of his. Can anybody help so we can unite and have one ID? Answer: we have a uniformed card, that has been available for 7 years now, and as a result of what it expresses allodially, it is accepted in many places across the planet. The more IDs in your Moorish nature, the better. One can certainly have a temple card, meaning you are a member of a temple, and a national ID, a student ID, etc. The key is that it expresses properly those allodial characters. Anything in writing, or published, is but a brief that expresses your position regarding a matter, whatever that matter may be. Inclusive of the national ID, which is printed, therefore published, therefore valid as an identification. Also refer to USC 1028 to be better versed, therefore more secure, yourself, as to what you are presenting, and that what you are presenting is in fact valid. Then you will see how your nationality card changes in your pocket. Answer: The variations in Moorish American identification cards came about with some of the many newly conscious Moors, after making efforts to obtain them from some temples, and being unable to acquire Moorish identification cards from the temples, or with some of them, becoming frustrated by limited communications or other roadblocks, began making their own Moorish American identification cards by studying and operating under the self-authority of birthright actuation. In due time, however, and as Moors become more educated, organized, and adept in their Moorish science and high culture, their consciousness will ascend to an even higher plane or level of social and governmental understanding, and many of these troubling things and unbalanced circumstances will dissolve. The progressive Moors among us will then have the credibility to communicate the already existing foundation gnosis of Moorish history, law, spiritual philosophy, and culture. This is a part of the cycle of human development, from a state of debasement to a more allodial self-preserving recognition of nationality. In the social and political realm of human endeavors, the word unity and the word nationality are synonymous in organizational and associate function. When the newly conscious Moors learn of the ancient principles, they, themselves will agree, and encourage unity of form and structure. Meanwhile, as we tread this journey towards freedom, justice, and sovereign right, we must acknowledge and address the reality of the need to teach our people those things which are necessary for their, and are, becoming better citizens of our redeemed Moorish nation, and having a functional knowledge of the benefits and the responsibilities that are assigned to that corrected status. Horizontal divider 12. Question 2. I'd first like to tell you how great this website is. I domicile in the Bronx. I wanted to know if you offer any classes on birthright and nationality for someone like me who is just learning. I am reading as much as possible, but would like additional information, particularly what steps I need to take to claim my nationality and birthright. Thank you so much for the information here. Answer. After completing 12 years of civic classes in the National Theatre at New York, and currently broadcasting 5 programs under MHHSI's Wide Open Blog Talk, every Tuesday at 9:30 p.m. and every Wednesday at 7:30 p.m., we are just about reading to provide a new live classroom experience. Most classes will be broadcast over blog, however, there will also be closed classes. You will have to pre-sign up for them, and when announced, you will receive instructions via email. In the meantime and between time, visit the site and continue to study. Horizontal divider 12. Question 3. After studying the Moor's Order of the Round Table, I am of a national mindset and conscious, to perceive in obtaining my nature rights, birthrights, and rightful name. I would like to become a bona fide and legitimate Moor, carry the name with the L on it, and the entire rights associated with my rightful name. Can you assist me? Answer. Thank you for your interest and activity, however, the universe thanks you more. Nationality is not really a process except for if and when it starts in the mind, as you now already know, if you didn't before. It has apparently awakened in you, thus declaring it is to be clear yourself and does not necessarily require any paperwork, but does require study to be clear yourself, as you can only be what you know. Proclaiming is the publishing, and that is where the paperwork comes in. Anything in written form is but a brief expressing your position regarding a matter, whatever that matter may be, and that includes the card itself, which is a brief and lawful claim. Answer. Your Moorish nationality belongs to you, and resides with you, now, and whilst you were gestating in your mother's womb, as she expressed the building of a temple of life from the elements of the earth, filtered through the gates of her magnificent form, and molded that constellation-marked temple for your spirit man to acclimate to, during this particular cycle of you ongoing sojourn towards perfected man. Know now, that your physical temple, body, is genetically coded, coming down from your ancient of ancient foremothers and forefathers. Your divine, natural person being is manifested to express the monad, spirit on the physical plane. Your, and my, Moorish American nationality is a fact, without doubt or contradiction, and descended down from your ancestors, the ancient Moabites/Moroccans/Moors/Moors. Thus your nationality is a bona fide birthright inheritance, and is a pedigree reality. The issue before you and many others is that of a lack of consciousness of identity, status, and the probable misrepresentation by others who may have created strawman fiction, creature instruments, to make claims upon you under the allegations of abandonment, and thereby initiated fraudulent power of attorney assertions against your body, your lands, and your inheritances. This has been a long-lived practice by corporate state Europeans, used to steal the natural people's hereditaments. The subject matter of consciousness of these anthropological and inherited facts must be resolved in your mind, and begin to be reflected in your activities of social, legal, and commercial interchanges. Expect opposition from traitors amongst us, and from racketeering European politicians and from anti-constitutional, color of law, state, city, and municipal officers. These types of legal crimes are at the heart of colonialism and are practiced by its secret society members. Horizontal divider 12. Question 4. I am really confused. I want to be nationalized so bad, but it seems to be so many scams out here. I have been doing a lot of reading on Moorish history, as well as watching a lot of videos which are on YouTube. I know they have temples, but when I call I get no one. I tried to email them but nothing, no response. I really am searching for some honest answers, sister. I just want to make the right decision. The most important thing is I will be a Moor. So my question to you is, when I do join, the fact that I'm a Moor will remain regardless if I'm with the Moorish Science Temple of America or with any other group, right? Nationalized is nationalized, right? Answer. Nationality is free. It is yours by consanguine birthright, primogeniture, and inheritance. Study, and you will be qualified to separate the truths from the falsehoods, know that which is valid from that which invalid, and recognize that which is constitutional from that which is unconstitutional. Answer 2. If you study the principles of nationality, typically no one can scam you, however it happens. I believe that every 20 years or so, there is some major redirection and derailing of the forward movement gained in the rise of the consciousness that leads one to have a conscience of national principles. It scatters the people, confuses them, and there you have classic infiltration. You must study to have eyes to see and ears to listen. I also believe the basic fundamental thing to be clear of is that the USA is not an authoritative government over natural people because it is a company, a union company or corporation. The first thing is to know this to be true, and then we would not be so focused on what they do with their company operating on the land and may be more focused on what we need to do in order to be who we say we are. The chronological history must be told and must be received, as it is documented as such. This does not mean you are bucking the government or think you are above the law, not at all. As a Moor, you are to know the law, therefore be able to recognize when someone, some entity, anyone, any entity, company, corporation, enclave or agency of same is violating the law against you. Thus, again, must study to know. Anyone can have a government or be a governor of whatever they are governing. That does not mean they are above the law of this land. Horizontal divider 12. Question 5. I am having some difficulty in my life and I need some guidance. I've been fighting with Rome for some time now, and I need to make the right moves to shut some of these agencies down. I really need to talk to someone, sit down and discuss some very important issues in my life. I need to get an understanding of my situation. I'm fighting now, but I feel like I am getting nowhere. Peace and love. Answer. Our natural people's enforcement of the Constitution is what will shut the fraudulent agencies down. Continue to visit rapblayz.com website, and study. We will be adding more constructive and progressive information on a timely basis. If you come to the classes, which will now be in Vineland, New Jersey, we will provide access to speak with you then. Otherwise, based on geographic logistics, mail communications are our best communications at this time. Horizontal divider 12. Question 6. I was born in Winnipeg, Manitoba, Canada. I am currently an avid listener of Moor's Heritage and History School on Harlem Rising Radio. I've only been made aware Moors about 2 months ago and am amazed of the truth that is being disseminated. It was Brother Taj Tariq Bey and Brother Sabir Bey that has led me to the truth about sovereignty and nationality. I was registered as a Métis with the Manitoba Métis Federation in the municipal district known as Winnipeg, Manitoba, Canada, but withdrew my status with them last week, finding out that being registered with the MMF as Métis would put me under corporate ward status. I want to become part of the solution and really don't know where to go from here. As Taj is married to the cause, well, so am I. If there is any organization in Winnipeg that anybody know of that I could get involved with, it would great if I could get that info. I just want to say thanks to Brother Taj and Brother Sabir for opening my eyes to the truth about sovereignty and nationality. Peace. Answer. Manitoba Province/Territory, a political subdivision of Canada, is still, in fact, a northern part of the Moroccan Empire, land of the ancient Moabites/Moors. Thus, this is also Moorish land that was usurped by European Inquisition colonists. Being Moorish American, you can refer to the writs of freedom for use, study, and application, as placed on the rvbaypublications.com website for all Moorish Americans. Read them all and clear up your concepts on identity, status, and gain a concept of basic protocols for protecting and standing for your substantive rights. Also see, acquire, and study the booklet entitled, Confused About Taxes and Correcting Position of the IRS. Remember that Aboriginal natural peoples are not to be taxed by the foreigners. Study. Horizontal divider 12. Question 7. I am writing a court in Virginia in which I reside in Kentucky, an affidavit demand for dismissal default judgment. Is it necessary to writ KY Secretary of State and others about this, or wait until I write a writ of mandamus? How long do I write a writ of mandamus? Answer. Do not abbreviate states and locations in your correspondences. Always address these colorable ministerial courts and court officers with your judicial proclamations and ticket dismiss writs, etc. The reasoning for CC inclusions, to other government department officials, are to make them, in their official capacities, aware of the criminality that is taking place in these municipalities, by the unclean hands of their employees, court officers, and magistrates, etc. Review the law's coving color of law activities, racketeering, and the RICO Act. Their failure to act upon notification this criminal information, reports of a crime, establishes a future legal suit and claim of conspiracy, arbitrary, fraud, and collusion, which, of course, with their long history of corruption being apparent by their profiling practices, most of these colorable officers have already practiced in the past. As you know, a writ of mandamus is a command issued from the higher courts, and addresses the officers of the private law and municipal courts, being inferior and out of order, to perform according to the law of the land and to correctly perform their fiduciary duties in accord with their limited and specified delegated political, ministerial, or judicial positions. And the rights of the complainant, must be restored. Logically, writs of mandamus should be common instruments issued from our Moorish communities. They should be activated on a more regular basis, and early in the legal processes, due to the rampant corruption plaguing the cities, boroughs, and towns of the country. You must always remember that abbreviated designations, used by the state of operatives, is cribbed to subvert the state republics. These acts are done to convert the republics into foreign, colorable, demo jurisdictions, and under foreign law. The ensuing corrupted status of your correspondence is the used against you. These grammatical alterations are designed to steal your unalienable rights and to violate your birthrights. Do not abbreviate. Horizontal divider 12. Question 8. How can I proclaim my nationality? So I can teach my kids about their rich history and their birthrights. I want to teach them at an early age so they don't go through the things I went through. You can contact me by phone or email. I am truly sincere. I want to nationalize and learn how to apply it. Answer. Noble Drew Ali founded the Moorish Divine and National Movement of the North America and the world, in order to address the nationality and birthrights issues of the fallen Moors/Aboriginals of the Northwest and the planet. Visit the nearest Moorish Holy Temple of Science or Moorish Science Temple of America, and I am sure you can begin your redemption journey. If you run into difficulties, which sometimes occurs, then continue to study, and remedy will come to you. Just as the wind moves across your face, to awaken your cellular consciousness, so comes, again, the love from your ancient mothers and fathers. A conscious sister or brother will come to your assistance, and your request will be granted in accord with your honor. Note, do not call the children kids. It means billy goat. Remember that juris equals right and diction equals words. Horizontal divider 12. Question 9, regarding the U.C.CS. Islam, good day. I want someone to work with me in regards to UCC codes and UCC financing. I am also interested in becoming sharp on judicial notice and proclamation. I've always felt upright and close to the Creator, but wasn't knowledgeable about things and therefore felt victimized and left broke without understanding why when I work so hard. I live in Louisville, Kentucky. I am working as a master barber and study very hard but can't find others like myself to work with. Any suggestions or advice would be great. Love and peace. Answer. Keep in mind that the commercial codes essentially and factually means codes for trafficking and to carry on trade. My first question to you is, do you have a clear understanding of what birthrights and unalienable rights are? Are you aware that unalienable rights cannot be transferred to, or sold to, another? I am sure you are aware that the commercial codes did not become uniform until about 1968, with Texas State Republic officials bowing to pressure and agreeing to play the state of Texas fraud game of commercializing or trading the natural people's rights, in collusion with the other compromised state officials and politicians. I suggest you study and enforce the Constitution for the United States Republic of North America, and enforce the laws relative to your nationality and birthrights. Note, do not confuse commercial activity with nationality, bloodline. Also keep in mind that the Constitution for the United States of America is the supreme law of the land, and is derived from ancient Moorish jurisprudence. U.S. demo politicians, educators, and many other corporate persons, operating at North America, are members of the demos, are subversives and against the Constitution, having no allegiance to the Republic. They do not want you or any other aboriginals or citizens to be cognizant of this binding fact. Verily, many of the officers of the various ministerial courts/tribunals, not constitutionally sanctioned, are traitorous racketeers, who are working together with others to rob and to steal from the natural people. They are using their bought and sold seats in government to enforce fraudulent, private, color of law, and systematically connive to substitute the supreme law of the land with their foreign corporate policies and ordinances. This is at the root of most of the common people's economic problems, and the current lack of due process railroading that is used to feed the penal industry. Many of the politicians, and judges of the ministerial courts, have invested interests in these profitable domestic POW camps/prisons and jails. These anti-republic institutions, and the colorable acts of these officers, are constructed to cause injury, and to place their fraud-based, and non-substantive, implied contract, originating debts upon the natural people. Now that they, European occupiers, are aware of the natural people becoming aware of the truth about nationality and birthrights, some of them have been promoting the use of the Uniform Commercial Codes, U.C.C.S, as a remedy for attaining sovereignty. Logically, anyone and everyone should be educated in the areas of contract law, due to the fact that we contract every day in some form or another, when we are interchanging with others. However, I will remind you and others recognize the integrity of the nation, that the sovereignty that many of the Europeans are arguing over is not their own, but is, actually, the sovereign rights of the Aboriginal and Indigenous Moors, whom the Europeans have colonized and usurped. The misrepresenting Europeans are debating among themselves with their corrupt rulers, who have, in cabal with them, robbed the Moors of their lands and of their birthrights. This land, Amaxime/Africa/Americas, is not Europe, and the sovereign powers over the land and the resources are not theirs, and never was theirs to possess, nor to claim jurisdiction over. Their claims are all of a corporate fiction character, artificially created on paper, and fraudulently propagated to the world. Their success has root in blind faith and fiction altogether. The present, fiat corrupted, fake economic political conditions, the defrauding of the people of the United States and the world, etc., arises from their foul, entrenched Inquisition policies. They know this, and work diligently to keep these Masonic secrets from you, the rightful heirs. Their inner working conflicts over our silver, gold, and commerce, reflects a truth that the divided and conniving thieves among them are bickering over ill-gotten booty and prize spoils, and are seething amoral arguments over escheat hereditaments. Let this first be made clear to all Moorish Americans. This is your lost estate. The land, the gold, the silver, and the commerce belong only to the true, primogeniture heir citizens of the land, and to them alone. Nationalize. As for the U.C.C.S., know that Section 8 and Section 2 relates to those important aspects which govern securities. Most of the people who sell UCC packages to the unstudied among us, usually fail to emphasize this important fact. They will usually put highlights on Sections 1 and 3. However, remember this. A UCC1 is to be filed only by one who, in commerce, already has a valid contract in the first instance. If this is not the precondition, then one has just created the jurisdiction of commercial trade of self, personam jurisdiction, which is not the intended outcome of the chosen UCC-initiated action. In due course of time, all instruments, built upon the fraud must fail. Declare your nationality and enforce the Constitution. The seller gets your limited energy regulating bookkeeping certificates, fiat, and the corrupt corporate state operative get windfall profits in filing fees. Tell me now, who has the advantage? Nationalize. Study all the aspects and implications of its political and social remedies. Note, a birth certificate is not a valid contract. It is the instrument that proves human trafficking, and your mother did not agree to it as a conscious contract. Horizontal divider 12. Question 10. The state of KY is trying to force me in court and show them a driver license. I want to file an affidavit before my court date appearance. Help. Answer. Do not abbreviate the states and / or other locations and entities. Capitalize where grammatically correct. That grammatical violation creates a deceptive and foreign jurisdiction. Refer to the Writs of Freedom sector of the rvbaypublications.com website, and use the writ entitled, Judicial Notice and Proclamation, and another writ which is entitled, Ticket Dismiss. Read Driver's License Fraud. When filing evidence and exhibits, always place the case number which is assigned to the municipality's usually misrepresented accusation instrument, S. Mark each of your correspondences as exhibits of evidence in the case. Always have your affidavits of fact or writs introduced and filed with these ministerial courts and or other quasi-agencies, before you make your special appearance before their anti-constitutional and foreign law tribunals. Send certified copies of your proclamations and writs to the prosecutor/accuser in the case, to the alleged judge, and to the clerk of the courts, etc. Know that licenses are required of commercial corporations, and not of the natural persons, nor of the natural beings of the land. Study some of the Supreme Court cases, which we have places in the text for your approbation. You should also issue to the prosecutor and judge in the case, an averment of jurisdiction. Remember that the sovereign power is not inherent in government. The sovereign power, right and power resides in the true natural citizens and in them alone. Being conscious of your Moorish nationality and birthrights, and being active in your proper person status, being yourself, confirms your competence to exercise such rights without the fictionally implied power of attorney or unauthorized leave assumed by the less than honorable officers of the municipal courts. Horizontal divider 12. Question 11. I want to get my paperwork done, and learn. Get true knowledge. I truly want to study with Taj. I'm in Delaware. Do you give classes anywhere near Da or Pa? Answer. Do not approach this Moorish humanitarian movement with a naive mind and get caught up in the contemporarily practiced misjudgment of what has come to be known as the paper chase. You need to have a sound, testable, and functional background and knowledge about the evolution and developmental ins and outs of this Moorish movement in North America. It is vital that you also be grounded in basic ancient American and world history, to boot. Know that you will be tried and tested by the corporate state operatives, for they are Masons and Eastern Stars, etc. Most all of them will play dumb when dealing with you, but know for a surety that they are aware of your true nationality, and of the fact that they are enforcing colonial extortion policies. Most of them are secret society inquisitionists and crusaders. This is why legitimate Moorish American organizations will also teach you civics, jurisprudence, history, Moorish culture, and fundamental constitution law. The paperwork, concerning the activation of protocols for issuing legal notices, affidavits, and writs, etc., are necessary aspects of a broader nationally active, spiritual, and civic plane of development and involvement. Let it be known for the record that subverting opportunists and con artists are all over the country, working to undermine the positive activities of the Moorish divine and national movement. The demos did not end their works with the Coolidge and Hoover administrations of the Union States Society anti-constitutionalists and with their misguiding influences amongst traitor overseers operating among our own. Some of these less than honorable persons are seizing the informational and consciousness advantage over some of the newly conscious Moors, who have, by whatever means, discovered the truth about their nationality and their birthrights. Study yourselves, and remember that unalienable rights cannot be transferred to, nor sold to, another. Governments and organized clubs, etc., do not give rights. They have no rights to give. Governments and civic organizations exist for one purpose, and that is to preserve and to secure the divine and natural birthrights/unalienable rights which are, by nature's law, and nature's God principles, the pre-existing rights of all humanity. Know that your Moorish nationality and birthrights are not for sale, as these incorporeal hereditaments are of primogeniture inheritance, and heirship, coming down from your ancient mothers and fathers, and they are also of a consanguine nature. Study the roots, purpose, and the development of the Moorish movement initiated by Noble Drew Ali, Sheikh Sharif Abdul Ali, in Northwest Amexem/Northwest Africa/North America. Study world history, and the Inquisition/Black Codes, and be aware that whenever someone amongst the Aboriginals establishes order amongst those who have been, or are, suffering oppression and mental slavery, the Romans/Europeans/Albion have always sought to infiltrate, undermine, and to destroy such organizations and natural persons. Keep in mind that the Roman colonists have never forgotten their Inquisition mission, in spite of the fact that many Aboriginals have forgotten that they are colonists and extortionists by social and political agenda. The passage of time will never change that fact. Nevertheless, in the face of the Europeans' demo corruption, the Moors have made substantive strides and success, which have come about, due to the principled Moorish divine and national movement. This is to remind you to keep on your toes and to be diligent. Get a solid foundation, knowledge, about the Moorish divine and national movement, founded by Prophet Noble Drew Ali, and accentuate your knowledge about world history, about contract law, about jurisprudence, about etymology, about unalienable rights versus licensed privileges, about status and its relationship to a state, about the law of evidence concerning identity, about the study of, and the enforcement of, the Constitution for the United States of America, and why. Learn about, and study the Spanish Inquisition initiated and operative for centuries, and institutionalized in U.S. demo operation in these days, against the Moors and Yehudi, Jews. Learn about the Enlightenment brought about for Europe, through, and by, the Renaissance of the 14th, 15th, and 16th centuries, initiated in Italy by the Moors, etc. Then, but not limited to the foregoing, you will have an unshakable and qualified understanding and resolve as to the purpose and the functions of these Moorish name/attribute and status correcting documents, affidavits, and general writs, etc. You will also have greater and more profound understanding of the roles that these documents play, at this time, to the benefit of uplifting the Moorish nation of the Western Hemisphere and the world. In the interim, and with the right law and allodial considerations about the true nationality and birthrights of my people, I have placed a few affidavits and writs on the rapblayz.com website for the free access and for the rightful free use of them by all Moorish Americans. The reasoning is for reaching out to the nation, in spite of economic and political oppressions, initiated by the corporate state quasi-government agencies who are violating, by conspiracy and color, the law of the land. These writs and judicial notices, etc., are to give notice to the nations of the earth, that we, the Moors, are aware of our nationality, our birthrights, the geographical longitudes and latitudes of our lost estate, and that we are active in our efforts to display our claims to our inheritances and to our competency to attain to self-authority, sovereign right. The initiating of valid lawful defenses of the Moorish nationality and birthrights, are expressed by the allodial rights to issue these writs of freedom. Study these writs and the nature of the presentments made therein. Use them rightly, with the consciousness of their emendatory declarations. Embrace them, and apply them with integrity. These public record, and publication communications are for the support of, and are of Moorish American prerogative, invoked as an affirmation of, your and my Moorish birthrights, and of our divine rights to acknowledge, to possess, to exercise, and to enjoy the said rights. As you, and we the nation, develop and evolve in your/our degrees of knowledge, understanding, and insights into your/our Moorish affairs, we will become more adept in our skills and abilities to contribute to uplifting of all humanity. When the mind changes to the positive, the conditions will follow. The current negative conditions are obvious. Work toward justice for and with self, man, and the nations, and prepare to take your proper place amongst the greater family. With the exercising of the mind, you will be well qualified to produce your own writs for the defense of that which is right, true, honorable, and socially and politically correct. Brother Taj Tariq Bey. Horizontal Divider 12. Question 12. I need some advice. How should I go about addressing the municipal court of whom I contracted with prior to me waking up and getting nationalized through my temple? Also, the other issue is motor vehicles with the surcharges that I have been paying them. My main question is, in your opinion, how should I address the situation with them? I contracted with the municipal court under T.D.C, and the strawman was obligated to pay that court a certain amount of fiat a month. Next, through extortion, they contracted with motor vehicles, so I ended up paying both of them off at certain times of the month. I have stopped paying them both for a few months now. The question is, do I send them an affidavit of fact? I just need some advice on how to go about both of the situations. I want to put them in check, but I want to come correct. What should I do? Answer. Refer to the Writs of Freedom sector of the rapblayz.com website, and use the writ entitled, Judicial Notice and Proclamation, and another writ which is entitled, Ticket Dismiss. Always place the case number which is assigned to the municipality's accusation instrument, S, and mark each of your correspondences as exhibits of evidence in the case. Always have your affidavits of fact or writs introduced and filed with these ministerial courts and or other quasi-agencies before you make your special appearance before their foreign law tribunals. Send certified copies of your proclamations and writs to the prosecutor/accuser in the case, to the alleged judge, and to the clerk of the courts, etc. This is a fundamental establishment of status, and the entering of evidence in the case is a rights-preserving activity, relative to the protocols of liberties. These, or related protocols, should be actuated by all aboriginal, natural person citizens of the land, since we are suffering under the occupation of the foreign European exploiters of the planet and natural peoples. A diversity of nationality and a diversity of citizenship is, in fact, a true political reality in our intersocial relationship with the European immigrant descendants. Be clear on your consciousness and connection to your Moorish nationality and of the civic responsibilities which it commands to the enforcement of the Constitution contract, which binds those in government to the law, Constitution and treaties. Taj Tariq Bey. Horizontal divider 12. Question 13. Peace sis. Thank you for your time and social duty of answering my quest of freedom. In your response you mentioned my being a national and not under their jurisdiction. What documents and forms are there available for me to present for the record? Also, upon me presenting them, how do I stop them from extracting the finances from my income? No, I am not one who's attempting to escape my responsibilities of my said child. I am the father of 8 and I just want to have my cipher complete. I just don't to have a financial relationship with my seed but a uniting of family. You also spoke about the null void of be cert for use. Could you do a audio on how to live within contracts as well? Peace and thanks in return. Answer. Refer to the writs of freedom placed on this site for all Moorish Americans. Read them all and clear up your concepts on identity and status. Also see and acquire the booklet entitled, Confused About Taxes. Study. Income refers to profits made from the stocks, capital gains, and investments of corporations only. Personal compensation for labor, work, or private service contracts are not income. These are categorized under personality and are not lawfully taxable. Someone is acting under misrepresentation, misprision, and a fraud. Remember that the IRS is a foreign corporation, connected to the papal government of the Vatican. The IRS is not sanctioned by the United States Republic Constitution. Not one debt note, or penny, collected under the current constitutional fraud, go to the support of any services for schools, streets, housing, health, etc. Nor does any financial or government service initiated by or from the IRS, contribute to any positive benefits for the natural people. Taj Tariq Bey. Horizontal divider 12. Question 14. Peace, to whomever may be reading this. I have become very interested in the Moorish divine and national movement. I somehow stumbled across Taj Tariq Bey's lectures on YouTube. No one told me of them, and from there it was on. Now I know of great teachers such as Hakim Bey, Ali Muhammad, Queen Ranita Bey, Sabir Bey, Ras Mariavi Bey and many others, in use a few short weeks. My point of contacting you is to find out, do you offer anything to southern regions of the states? I live in Atlanta. I know there is a temple here but I am not comfortable with the one here for reasons that may be explained in a more personal conversation. I've listened to lectures and have found how much I didn't know. I am only 20 so no surprise, but I agree with Taj and others, that law is the issue at hand, and I would like to learn more about law and our history, especially concerning claiming my nationality the correct way. But if possible I would like the helping in of an elder, for I am willing and eager to study to better myself, my family and nation as a whole. I would greatly appreciate it if you could contact me regarding my concerns. Thank you. Answer. On the site I trust that you will find enough to enhance your journey back to self and to your birthrights, hereditaments, and lost estate. Seek out active Moorish Americans in your territory and begin to reassociate yourself with those things necessary to become a better natural person, citizen of the land. The information needed by you for your connectedness and social/political development will come your way. When the student is ready, the master will appear. Sincerity is a vital key to your quest. Horizontal divider 12. Question 15. I want to understand more about claiming my national status. I have been to a few more meetings but have not been able to commit to going every week because of my schedule. Where should I begin my journey? Follow in the steps of my ancestors. Answer. Attend a Moorish Science Temple of America or Moorish Holy Temple of Science in your area, when possible, so you may get a strong foundation, relative your inherited connection to the ancient Moabites/Moors, the ancient ones, of the land. Learn of your ancient Moorish culture and customs, etc. Definitely, and without delay, acquire and study Noble Drew Ali's written and oral statements. Search out, and read the treatises written by him in the old Moorish Guide newspapers. This will take some scholarly work, due to the subversives amongst us. This, however, must be done and respected, in order to recognize the geography of your lost estate and the actions and patterns prescribed for graduating advancements and activities for the improvement and advancement of self, of family, and of the nation. Remember that the Prophet said to the Moors, the half has not been told. If I told you everything, you would go back to sleep. Imprint that statement in your mind. Do not be surprised when you discover that your learning curve gets saturated on the elementary level. Your spirit in the movement ascends to a higher plane, when you learn to pay attention to the details and nuances, coupled with your improvement in world history studies and the philosophies. This requires more disciplined reasoning and an advanced acclimation to metaphysical analysis in ancient religion, civic studies, and unity activities. A change of conditions and circumstances demands a change of mind and a social cleansing, an emphatic motivation to higher nature, validating culture. Knowledge changes conditions. Study.